Morena koutou, warm welcome to you all here today to open the informal meeting for consent 250127 Baruchel Trustees Limited at 3A Spot Hearings. I hope I've pronounced Baruchel correctly. Excellent. Good start. My name is Ros J. Cleven. I'm an independent commissioner from Ōtepoti, Dunedin. I've got a background in resource management planning, and I've been appointed today by the Central Otago District Council to chair this hearing process. So it's good to be here. Thank you. And I'll ask my fellow panel members to introduce themselves.
Morning, Tracy Peterson, Commissioner and Councillor for the CODC.
Sarah Brown, Commissioner and Councillor for CODC as well.
Hi, Martin McPherson, Vincent Ward, Councillor and Commissioner.
Jessie Dick, I'm the Minutes Secretary. And acknowledging staff and attendance, could you please introduce yourself and the roles that you play in the process?
I'm Tim Anderson. I'm planning team leader and reporting officer in this matter.
And Walt Finley, development engineering manager.
Julie Neal's manager for 3 waters.
Hi, Julie.
Julie Neal.
Julie will be available to answer questions in respect of roading and servicing.
Thank you. And so we don't have Dominic Hannon appearing?
No.
Okay. And no one's online? Otherwise, no. Right, thank you. Welcome to the applicant. Mr. Barr, are you able to introduce your team?
Sure, thank you. I'm Craig Barr. I'm a resource management planner, and I provided a statement of evidence and a summary statement. To my right are Mark and Beth. And to my left is Campbell Hughes, surveyor, who's also the project lead.
Yes.
More so than myself, even though I'm sitting centre. It's probably Campbell's probably the main project lead for this.
Welcome. And I think the hearing schedule suggests we've got up until morning tea, so approximately 1 hour. That suit you time-wise, everything that you've got nothing to kind of introduce or check with us in terms of time.
No, that sounds good.
And we have no submitters. It was a non-notified application. Housekeeping.
In terms of if there's a fire, evacuate through any of the exit doors up into the car.
Thank you. So turning now to procedural matters. So we visited the site yesterday afternoon. We went by car and made our way around the subject property, noting key features that were available to us on the site plan. And we drove around the immediate area to kind of familiarise ourselves with that. We may or may not undertake another site visit, depending on what we hear today. Any comment or declarations the panel wish to make in terms of any position? So no conflicts, no declarations that we need to make today. And are there any other procedural matters that anyone would like to raise? Thank you. And just to note that we are being recorded today and that will be publicly available on YouTube, I believe. Okay, so if I then over to you for the applicant, Mr. Campbell, are you running this case?
Yes, yeah, that suits me. So
just 1 moment. Sorry to interrupt you. I've just been asked by the Minutes Secretary to say that all statutory requirements under Section 95 of the RMA have been complied with, and the Section 42A report prepared by Mr. Anderson has been circulated to address for service. Sure.
yes, so yeah, my name's Campbell Hills. I work with Coterra and I prepared the original. Well, I've assisted Mark and Beth through probably the last 5-6 years. Yeah. With various ideas for subdivision development, originally we applied for consent in 2021. Pre-plan change 19 coming through, and we withdrew that application awaiting plan change 19. So yes, we've ended up here with, obviously I hope you've got a copy of the plan.
Yes. Thank you.
And the proposal is very much the same as it has been. Really. It's obviously sized according to the new rules, the new zoning under plan change 19, or what came through, sorry. And I guess the only real departure from would be considered standard under that new framework is the proposed private access road, which I think is probably the core or only real reason that we're in this setting. From my point of view anyway. So yes, the idea is really just to have a discussion around that and how that aligns with some other examples in Cromwell and other parts of Central Otago, Queenstown Lakes. Obviously, it's a departure from the standard requirement, standard approach with 1 to 6 lots as a private right-of-way scenario, and anything greater than that is typically expected to be vested in council. Mark and Beth have recently built their retirement home on the site, which you would have noticed yesterday. And they've had this vision for a whole time, well, since before I was working with them, to having this sort of more private, contained sort of development. And they've got a lot of interest actually from others in that same sort of environment, neighbourhood. Obviously, it's not typical, but it's something that they would very much like to see, and there's some unique characteristics with this site which they'll think sort of lean to that approach, being quite contained and quite private as it is. I mean, when you drive through on the Scott Terrace or down into McNulty Inlet, you can't really see the site sort of tucked away, not sort of encouraging just general public access where it's not really required, because there is a good pattern of connectivity in this area with public open space and that sort of thing. So yeah, that's the thinking, and also retaining some ability to actually have control over streetscape planting and things like that, which they wouldn't otherwise be able to have, I guess, with certain requirements around, vested roads with different types of tree planting, garden beds and things like that, which council wouldn't necessarily want to take on maintenance of. So yeah, the idea is to have sort of this community feel where everybody has some investment in the shared open spaces and things like that, and keep of those and have that protected through consent notice conditions and things to obviously protect council's interests and ensure that things are clear in terms of responsibilities moving forward. So personally, I've been involved with one other similar development in Wanaka, obviously QLDC, a few years ago now, and it was a good outcome. And obviously, yeah, we worked through similar things, what we're looking at here in terms of private shared responsibilities and making sure that things are documented on titles and people are buying in, knowing what they're buying into, because, obviously the road itself is going to be fully the responsibility of the residents in terms of maintenance and reseals and things like that, which isn't normal, but people are seeking something that's a bit unique, that's, got a bit more of a community feel to it, then, that they have that choice to be paying a bit extra for it. So guess that's a bit of a brief summary. And yeah, Craig, if you want to sort of talk to more of the framework, I suppose, policy type stuff.
Yeah, thanks.
We might have some questions
Yeah.
for you now, if you're happy
Yeah.
to take questions now rather than wait.
Yeah,
Yeah,
sounds
okay.
good. Thank you.
Thank you, Mr. Hills. That's a helpful summary. It has highlighted some of the key points in your written statement, so thank you for that. I do have a question for you. You mentioned an example specifically in Wanaka with QLDC. Did I hear correctly that earlier in your summary that you said there were other examples within this district?
Yes, so the two that I'm aware of would be the dunes at the golf course in Cromwell, which is quite an old, well, it's an older development. So private obviously has a gate, but the gate remains open. As far as I know, it never gets shut. And rubbish collection, I think servicing is all council internally there, which is probably a point of difference to what we're looking at here, where the advice from councils through Wooders' team has been to keep everything private internally, just to have that clear distinction between and then so obviously it would only be the council appointed contractor for rubbish or waste collection would still be entering the site.
And were you involved in that one? No.
The dunes, no, I wasn't. And the other example I had in my evidence was the Highlands Industrial Park, which, as far as I know, is fully private internally. Surely might know more than me, but
we can, we'll keep the questions.
Yeah, cool.
Thank you. Thank you. Okay. And were you involved in Highlands one, or that's just something you're aware of?
just sort of touching on some of the local examples. The only one that I've been directly involved with was a Wanaka example, Tarangi Estate, which is next to Puzzling World.
Thank you. And in your evidence at paragraph 23A, you've summarised this at a high level this morning. You said that there is a risk that vesting of a access road in council may encourage additional unnecessary vehicle and pedestrian movements in the area. What's the reality of that risk? Like, what? When you say risk, what do you mean?
I guess so. My idea around that was more just that obviously people are inquisitive by nature a lot, and so having a public no exit road there could just encourage, unnecessary vehicle movements through people who are curious to see what's, I don't know whether a private road sign is going to deter that anyway, but the idea is just to try and limit that.
Right. So particularly interested people in their vehicles moving through to see
because
like a view of the lake or
exactly it is obviously close to the lake and some of the site does have quite a nice view down onto the lake, but there's no obvious need for public to be going through there to get to the lake or to sort of thing. Whereas if it's a public road, I think people might be encouraged to drive in there thinking that it does potentially provide lake access or something like that. Whereas obviously the obvious access is down McNulty Inlet.
That's very helpful. Thank you. I'll see if there are other questions for you.
Sounds good. Thank you.
Yeah, I guess the big thing that I'm quite interested in is in relation to the servicing on site.
Yeah.
Experience, we've found that what has happened in the past is that the initial intention is, I guess, a lot of promise and somewhat down the track, and it could be well beyond everybody in this room. There's an indication for it to go back then to council. It's always and that's a risk So how do you see that being not going to be the case for council and not going to end up that foot down the track that, or is that just a risk?
I guess there is a risk that someone who is a resident in this area might decide, actually, we don't like this and we'd prefer council to have ownership of all of this infrastructure. The challenge for them would be that they would obviously need to get everybody else on board, or they move on to somewhere else potentially. But the idea is to actually construct everything to a council standard anyway. So if everyone was of a mind to consider vesting, then they could approach council collectively and say, got this infrastructure here, it's meeting current council standards, it's in good condition. They'd have to obviously prove all of that, and then it would be up to council to decide whether they are happy to take that on to vest. I think, yeah, obviously everybody's going to be buying in to private arrangement initially, and they'll be, talking to each other, and it would require everyone to be on the same page. So I don't think there's a real risk in terms of, like, are you sort of more thinking if there was an issue, like if there was a water main burst or something like that, and then?
Yeah, so essentially there is, using examples from even within the Cromwell area, there is infrastructure that was set up in accordance with similar, or if not exactly the same as council infrastructure. Passage of time and potential development and what have you, there is, when it gets to the point that it becomes an upgrade is required, it is so expensive that
To bring it forward.
it ends up being council's cost at the end, as opposed to that being council, vested in council right at the outset.
Yeah. Yeah. Yeah, I don't really see that there's much risk here in terms of requiring extensive upgrades, because obviously the site is so well contained. And I don't see there being much further development potential. Obviously, it's recently rezoned, so, and the density is aligned with that zoning. So there probably isn't much scope for things to actually, physical change being required, or upgrade, or extension or anything like that. It would more be around, if any of the residents decided, actually, we don't like having to look after this, then they need to talk, there needs to be a collective decision made. And then it's obviously up to council to decide whether that infrastructure is still meeting standards or not. But yeah, the fact that the site is contained, that the servicing I don't see any potential for mains being extended beyond the site. So, or requiring, upsizing for any reason.
I guess having a one dwelling put on each of these sites, but we are now in a playing field where every single one of those sites could have another building put on, a small one admittedly, but it could be that every single one of those sites has an additional.
Yeah.
So are you going to have the capacity to be able to allow for each one of those sites to have that there?
Yeah, we've obviously, we haven't got into detailed design yet, but our preliminary design easily caters for twice the number of units to what we've got here with 19 lots. So, yeah. And we'd always put that protection in place and design with, a buffer in terms of capacity. So.
And just one other question, different line of thinking. Reverse sensitivity. When we visited the site, obviously there was there's obviously a bit of activity in the public area, which is directly in front of essentially lots 4 through to 8.
Mhm.
Do you see any potential for reverse sensitivity? Activity on that front sloped area?
I don't see any potential risk in terms of reverse sensitivity because obviously the zoning caters for, it anticipates this density of development. And people buying in here are fully aware of, you know, the inlet and the boat activity and different things like that. I guess that's potentially a good question for Mark, given that he's lived on the property now for a period of time. But yeah, there'd be a reasonable expectation, obviously buying here, that you are buying and you're going to reside in an environment where you've got, you know, boating activity and vehicle movements for lake access and things like that. Cyclists, exactly. And obviously the terrace face and right up to the top edge is all public as well. So people do walk their dogs up around there as well. That's something that Mark and Beth will have noticed a lot in the time they've been living there. But yeah, I don't see that as an issue for this proposal. Obviously, it's aligned with what's anticipated through the district plan, and people have a choice, you know, as to where they choose to live and the environment that they. Yes, yeah, there's obviously the odd event that happens in this area where you've got, you know, particularly say noisy boating activity, including just this last weekend. But yeah, again, that would always be made public and right into this, knowing what they're getting.
Can you just clarify for me how lots 18 and 19 work with that separate access? How much involvement is there in the, obviously, if you've got access off that lot 100, it's fairly straightforward, but that appears to be a self-contained for just those two. Am I correct there?
It is, yeah, that's right. And that is actually under construction at the moment because lot 5 on the cul-de-sac head is being subdivided into 2. So that's also owned by Mark. So that there, because it's lower lying, you might have noticed when you walked around the site, if you went through the Rotary Glen camp area, that western side is quite significantly lower. Yeah, it does drop down from more or less the boundary of lots 17, 18, 19. That's sort of the defined terrace edge there. So getting access through from lot 100 didn't really make sense. It always made more sense to come in from the bottom and be able to sort of have, you know, potentially have garaging in underneath your house. And also, obviously, for servicing reasons, lots 18 and 19 and part of 16 are quite low down. So those are going to require pumped sewer connections. But yeah, that side is a little, it's quite distinct from the remainder of the development.
Would they be included under that blanket, like the body of water or whatever? Would they be under those same terms? Because paying for a road and.
No, they won't be. So on the plan, we've got a draft amalgamation note, number 4 in the title block panel, which just says that lots 1 to 17, we basically have undivided 1/17 shares of lot 100. So they'll then have the extra responsibilities, conditions on their titles, and lots 18 and 19 will be separate. Yeah.
And does their wastewater is interreticulated, is it then?
Yes, yeah, it all
So
is, yeah, yeah. It's only a case of pumping for 18, 19 and part of 16, depending on where, yeah, into the gravity network.
And that'll be deemed a, that's just an access way, because that's just going to those two lots. So rubbish collection for there would be at the end of Scott
It will
Terrace.
be,
They
yeah.
would be.
Yeah.
No, there's no truck access, nothing there,
No.
so that's just driveway. Thank you.
So that's a standard right of way.
Yeah, that's just the two. The others are getting the bins collected in there and they've got quite a long walk.
Yes.
Issue with the blue one.
What about the weekenders all three? I hope you've got kids.
What's going to be the legal framework you're going to use to ensure lot 100 is maintained?
So there'll be an owner's agreement, which will be a legal document that gets registered on the titles. Lawyers will obviously draw all that up. Could actually provide the example from the project that I was working on if it's required. I couldn't tell you off the top of my head the different terms and clauses and things that will be in there. But obviously the lawyers will be quite careful about, documenting some responsibilities and contributions as well, towards different things, including irrigation, because part of this whole model is to have existing orchard bore actually used as a irrigation supply for everybody. So there'll be allocation, obviously, of water, daily allocation for that and different things. So it'll all be registered on the title. I'm not 100% sure of exact wording and documentation at this point, but it is quite commonly done. We're certainly familiar with these types of arrangements. So Mark's actually had a lot of experience up country in Hamilton areas and things with these types of developments in his over his working life. So yeah.
This may be more of a question to the applicant, considering that you've done an extensive amount of work on that property over the last 20 years.
That's correct.
Basically, it's a gated community without a gate. Would I be right in saying that, or is that being a little flippant?
But it's developed. I mean, my experience is over 15,000 projects throughout New Zealand as a geotechnical manager of each of those sites. So I have quite a wide experience, like in the South Island as well, not just the North Island. And so I've used that experience of many, a good majority of those sites would be subdivisions, occasionally smaller. So I've just built on my experience and having a property in here for the last 20 years with a house on and I've just relied on my experience of how you should manage, how this needs to be managed. And there are examples in other councils too around the country. So I'm confident the model we've put together is workable. And having a ownership of that lot 100, that access really gives us a community facility, and you're building basically your covenants when you're selling off the sections. That's all covered of the financial contributions, and typically you would be having a levy of maybe $500 per lot owner coming into a common pool, and that money is then used for maintenance of the access strip. Not only access strip, which we're talking about today, but also around the road itself, and then the vegetation.
So would there be some form of legal entity, like a body corporate or,
Typically, you'll have out of the 19 people, they'll have an annual meeting where they have possibly 5 or 6 elected as being responsible. So you have a community involvement, not an independent sort of group that does the management. If any, that is, yeah.
thank you.
Thank you, Mr. Hill. No further questions for you at the moment. We may swing back.
Is that right? Yeah. Thank you.
Now, Mr. Hill, was it the plan to have Mr. and Mrs. Mitchell present to us as part of your presentation today, or
They're quite happy just to answer
answer
questions.
questions?
I
Is that
think.
right? Okay, sure.
I think with my response, Mr. McPherson sort of ran it off.
Okay. Thank you. So we'll when we have questions that might arise from other questions, we'll ask those of you. Thank you.
Thank you.
So does that take us now to Mr. Barr?
Yeah, I think so. Yes,
Yes.
thank you. Okay, so I've got my evidence, which was pre-circulated, dated the March. I also have a short 1-page summary statement. I'll just check that.
Yes, we have. Thank you.
Okay. So we'll start there at paragraph 1.2. The key matter of contention and the reason for council officers referring the application to the hearings panel is to do with the access road serving greater than 6 lots and remaining in private ownership. It's paragraph 1.3. My evidence is that neither the council's roading policy nor the district plan takes a predetermined view that infrastructure created as part of a subdivision is required to be vested. My evidence is nor that does the district plan provide a strong direction that roads which service greater than 6 lots require vesting. In my view, the focus of the district plan's provisions are that infrastructure is built to an appropriate standard and that it doesn't have adverse effects on the environment. At 1.4, council officers just noting that council officers support the proposal in its current form without the applicant being required to vest the road or lot 100. At 1.5, conditions of consent have been agreed by the applicant. And just to note that these will avoid the potential for gates or other structures which could impede access to the subdivision. The conditions of consent will also ensure the road access is built to the appropriate standards and that it will be managed on an ongoing basis. And at paragraph 1.6, just some clarification to my evidence, and it's probably an important clarification. At paragraph 17, I omitted a word, and it means what I meant to say is that what this means in a practical sense is that there is no uncertainty for an application for subdivision if the allotment size has achieved the required minimum for precinct 1. I omitted the word no. So if you're reading that paragraph and you thought, this guy's, I've lost the line. Yeah. Hopefully you've found me again. So I added no before uncertainty. So the point there is that even though there's appeals still outstanding on the zone framework, those appeals aren't seeking a downzoning or a less intensive lot size than it's proposed here. So it's relatively safe for the council to apply sort of all of its weight to the Plan Change 19 provisions. And that's a summary of my evidence, and I'll be happy to take any questions.
So yes, I had that circled in paragraph 17, so that saves me a question. Thank you. That's much clearer. So at paragraph 18 of your evidence, Mr. Barr, you've just verbally summarised that you consider that full weight should be afforded to those LLRZ provisions in the residential resource area. And I note that Mr. Anderson says considerable weight should be applied. Is there any material difference in terms of his assessment that you used in that respect, or?
No, because Mr. Anderson's evidence doesn't rely on any provisions that are sort of going to be rendered obsolete. So no, I think we're on the same page there in terms of waiting really. Yes.
Thank you. And at paragraph 19, you've talked about the council applying this approach to other consents in this situation. And a footnote includes Molyneux Lifestyle Village.
Mhm.
Are you able to explain that particular example?
So the point I was making there was that I understand that the way the council's delegation register works is that in the first instance, it's the hearings panel that make the decision on that are tasked with making decisions, and then it's their discretion to sort of delegate or sub-delegate that to the officer level. One of the thresholds is that if it's a non-complying activity, it generally remains with the hearings panel.
Yes.
And the point I was making is that in the delegation register, it says if it's non-complying due to a minor or technical issue, then they have the option to delegate it to council officers. So the point there is that this activity is non-complying because of the legacy former zoning framework still having legal effect. And with the Molyneux Estate subdivision, that was a different zoning. It was rural residential zoning, but it was the same issue. It's because the rule still had legal effect because there was an appeal on it. So I was sort of making the point that I was just making the point that council have been able to use their discretion to process make the section 95 and section 104 substantive determinations at an officer level and didn't need to
Yes, I see.
delegated it to them.
So that was more a process example.
Yeah, that's right.
Okay.
It's a moot point really because we're here now in
Yes.
this hearing, but I was sort of emphasising that there's nothing particularly contentious about this that, needs overthinking.
Okay, thank you. And in terms of your statements around your summary conclusion there around the council's roading policy, more the district plan takes a predetermined view. The infrastructure created as part of a subdivision are required to be vested. So is that on the basis that the roading policy, in your view, is given it's non-statutory, doesn't have weighting in this process if we are to consider the district planning policies framework? Or are you saying something else?
I'm not saying it wouldn't have weighting. It's another matter, and council's policies that sit as internal documents, such as its code of practice or its roading policies, to be fair, documents that assist council to sort of implement the district plan. So I wouldn't say it has no weight at all, but what I was looking for was the relationship between those two documents and trying to understand if either one of those two documents made it clear and I guess binary or a requirement to vest at all with no exceptions. And I couldn't find that.
Okay.
But to be fair, the district plan would have, where there was some conflict, the district plan would have greater weight because it is a statutory document.
Okay. And so in terms of weighting, does the roading policy come into is that rather another matter in the section 104C consideration as opposed to?
Yes, it would be because it is a non-statutory plan in that context.
Yeah.
And it's not incorporated by reference by the district plan.
Couple. That is the extent of my questions for now. I'll hand over to fellow panel members.
That's a similar.
Yeah, I think I'm good.
Okay. Okay. Right. That's no further questions for you.
Thank you.
So anything you would wish to highlight for us, Mr. Mitchell, or are you happy that the presentation is complete?
I think it's pretty clear. Just again emphasising my experience throughout the country. I think I've used that in developing this or purchasing the property in the first place. And then keeping it until the right time. So, and really the main question is that access way, private or public, and examples of like Tauranga couple, access ways are really a complement to the vision of the subdivision, and having a standard, well, as you see from the planting coming through, of establishing that planting, in the assumption that the residents will continue to water it, the moment continue. So if it's in a council hands, well, who pays for the percentage of the water? So that it's a lot simpler to have a private access way, which is owned by the residents, rather than council coming to have to full stop.
Your experience with other districts in the country,
Yes.
just kind of following on from my commissioner colleague, Ms Patterson, around her question around certainty for council and the future possibility of vesting or not. Have you come across that in any of your other projects where a community has changed its mind and have wanted it vested after all?
I think what was some Tauranga examples, which I haven't got photographs to present, but no, it really looks a very permanent, no maintenance approach, and it makes it more simple if the residents have ownership of shared ownership of trimming the trees or whatever, but ask the council to come and trim the hedges down that right of way for the planting. It's not I wouldn't say, I think it's obvious that I wouldn't expect council to have the same empathy with keeping that access way congenial with, and we'll have quite strict covenants on each of the sections, which is again based on previous examples of. And the question of two residents came up, two houses, unlikely. Well, have that covenant. They can't. And but of course, you have a governing committee of half a dozen, elected, but ultimately, you have a community that's sort of woven and genuine.
Oh, thank you very much. Mr Hill, any final comments for the applicant before? Obviously, we'll return to you for any reply you may have, or after we turn to
Thank you.
at this point. Any comment you want to make?
Probably just covering off Mr McPherson's query about body corporate. So I don't know if that was sort of directly responded to, but the example that I had in Wanaka had a residents association, which I think is what Mark has sort of indicated with that, you have a committee, obviously, everybody's part of the association, which is effectively a body corporate, although that's under the Unit Titles Act, which is separate, but residents association is a common framework. Then obviously there's rules and terms under that in terms of as people buy in, how that gets formed up, that type of thing. So that's probably my only further comment. Thank you.
Great. Right. So turning to staff. Mr Anderson, do you have a preference whether we start with you, or would you like to come in? Should we talk to the technical first? How would you like things to run?
I think if you have questions for the technical officer, it might be best that's
And Mr Denley and Ms Muir, have you got a summary you would like to present to us, or are you here you're happy to take questions?
Just take questions.
Okay, thank you.
I just will though that it's not, if the roads are private, then we're proposing that the infrastructure wastewater infrastructure in the roads is also private. It's not just the road.
Yes.
It's private. The residents will be responsible for the renewals and maintenance of those assets as well.
Okay. Questions for either of our experts?
Just for me, just with regards to services, Julie, this is a water question, to the boundary. Do you foresee any issue with providing essentially what my concern was that there was 19 sections, 19 lots, pardon me, and then every single one of those lots having a granny flat put on it?
Not specifically to this development. It's something we will have to consider across our network in terms of our it's right across everything now, but the ability to do that. So we have to take that into account generally.
And having the services to the boundary, while this is not a conventional approach as far as normal practice, are you reasonably satisfied that this will be sufficient?
We will put a bulk meter at that boundary so that we can bill all the water that's supplied into this development. It will be the responsibility of the body corp to pay any difference. And I think that the key thing with these is when they're established and the infrastructure is nice and new, we would expect that there won't be any problems for a prolonged period of time. But in 20 years' time, when some of the laterals need replacing and they need to be dug up and leakage is occurring, then it'll be beholden on the body corp to make sure that that gets addressed, because otherwise the water leakage costs will fall on the body corp. So we think we're managing that by making sure we've got a bulk meter at that entry point development. Without that bulk meter, then I would have concerns.
I guess my follow on from that is, do you think this will set a precedent for similar developments?
My experience has been that it's to go the other way, that people want to list the infrastructure and council so they don't have the responsibility for the ongoing maintenance and funding and depreciation and the likes on those things. So it's quite unusual that people want to be.
My next question is to
Yeah,
Mr. Denley,
Yeah,
if that's okay,
fine.
going over
Yeah.
to roading.
yeah, absolutely.
In relation to the roading side, and obviously using a Cromwell example, Gear Ab at the moment taking trees out because of issues with pavements, and I fully respect that the applicant has said that that would be their responsibility. And because of the construction of a community-based space, in the event that that was to vest with council in the future, how would you see any potential changes with what they are proposing? It's going to be impacting the roading or pathway development.
Start. So the proposal is to construct it to the required engineered standard. So that's the starting point in terms of damage to that surface, roading surface and other infrastructure to the future. That is obviously residents association or whatever other legal framework that gets set up. Now, if that residents association got together and they all wanted to then invest their asset with council in the future, that asset would need to be brought up to the future's required standard before it would be considered investable asset.
We can just add that as actually a requirement in the Government Act. In order for council to declare a private road a public road, it has to be then invested in it. The residents who have frontages to the road are required to upgrade it to the required standard before council takes it over.
No further questions, or do you? It's very clear. Thank you for being available today. We might swing back to you depending on what our questions with Mr. Anderson. Okay, so Mr. Anderson, we've received your section 42A report and we've read that, so that can be taken as read. Is there anything you wish to highlight to us before we go into questions?
Yes, just reiterate what Mr. Hills and Mr. Barr said. The proposal is broadly consistent with the anticipated development in the large lot residential precinct 1. The allotments meet the required minimum, and whilst there is an ongoing appeal, relief sought is for increased intensification rather than anything that would go the other way. I understand there's a consent order imminent to resolve that. It's taken longer than expected to arrive. So under section 86F, the residential resource area 6 standard of 4,000 metres is still treated as operative. With terms of weight, I feel for informing the future direction that the Plan Change 19 standards under the large lot residential P1 should be favoured, and that would be consistent with quite a number of recent decisions. That's the way it's tended to be addressed. So really, the private road is the sole element of this proposal that differs from the recent ones that have been approved within the zone. I think with acceptance of Mr. Denton and Ms. Muir's comments that the private road and private assets are acceptable, supportive also of that element of the proposal. And one thing I'll mention is with a private road, there is no opportunity for any publicly vested open space or walkways. However, the applicant will be able to make a reserves contribution under the development contributions policy, and for a number of reasons, given the nature and scale of the application, it probably doesn't lend itself to open space or pedestrian links that would add very much in the way of value. As a non-complying activity, I see this as passing the gateway tests under 104D and also represents sustainable management under Part 2. I've provided a draft list of recommended conditions, which I understand are accepted by the applicant in full, and accordingly I stand by my original recommendation that the proposal be granted.
Thank you. It's a helpful summary, highlights. I do have some questions for you, mostly just to check my understanding of your analysis and conclusions.
Sure.
In relation to Mr. Barr's. So the first issue being of weighting. So Mr. Barr has considered that full weighting should be applied, and you've considered the word? Considerable. Thank you. From you, what's your thought there? You're not going so far as saying full weight. Can you explain why that might be the case to me?
Well, the only reason I wouldn't accept full weight is the under 86F, section 86F of the RMA, there's still a requirement to treat rules as operative, but as discussed, I do favour the standards and the objectives and policies of a large lot residential zone.
And it's not necessarily determinative in any case in relation to your conclusion in relation to, it's not resulting in a material difference in evaluation.
No, I mean, the material difference in terms of the rules would be the lot sizes. However, under the appeal, that's not an issue that's in dispute.
Thank you. Also, you would have heard my question to Mr. Barr around the non-statutory document, the roading policy, and where that sits in relation to the planning framework, and for our purposes, when we're making a decision, where any weighting might fall on the roading policy in relation to the district planning standards and policies. Have you got a view on that?
I agree with what you said about it being another matter. It's not a matter that's directly referenced within the district plan.
And I did have a question around, given it's a non-complying activity and the district plan integrity and the precedent matter is often a matter of focus for non-complying activities. And I noted your conclusion there around that. They appeared to be more on the general side of rationale in terms of why you don't consider precedent to be an issue, like in terms of every application being assessed on its own merits, etc. But I am interested, and I think the panel will be as well, in terms of specifically in relation to this site and this proposal, what differentiates this proposal from generality of other cases.
I think as it's been touched on by the applicant, there's a relatively contained and separately accessed area. There's no great exclusion for people other than what currently exists with it being a single allotment. And I understand it's functioned for quite some time as a productive orchard.
And you've mentioned as well, would the, in terms of connection and public thoroughfare, and does that come into, is that what you mean when you're talking about contained?
Yes, that's part of it. In terms of access, it's topographically quite limited in what could be achieved in terms of linkages, and there are also good existing alternatives available, including a footpath along Scott Terrace and a trail formed along the shoulder down to McNulty Inlet.
I'll just check if we have any further questions for you. Questions?
Can I just have it, looking at the map, I think it's a water question, I think, Julie. There's a proposed stormwater submarine soakage pit, looks to be on Scott Terrace, in the Appendix 4 plan. Somebody just clarify for me how that's going to work. That's going to be fairly large soakage if that's coming from the road. I'm assuming that's runoff from the road. Is it from?
Yes, so that there is no stormwater infrastructure that it's all road associated infrastructure. It's a non-site stormwater that it'll only be the water from that is going into.
So that's going on to Scott Terrace, not on the driveway. Just that plan has it on the boundary side.
Yeah. Sorry, I'm not familiar with that because it would have been picked up through the roading. eroding review rather than the water. Because
Get bomb trucks, so that's fine.
we
So, well, it's
That's
okay.
typically we do require mud tank. Every
Mud
mud tank
tank,
has
yeah.
a soak pit within the road corridor.
Yeah, I love me a private road. I was part of Jones, I bought in the Jones originally, built near, and now I'm on a road access way as well with the mud tax. So the location of that has been contentious where I am, is where I'm asking, because that looks to be on Scott Terrace, which is best, isn't it? So I'm just wondering, I know it's not huge, but
Often that level of engineering detail is picked up at that engineering design.
But that would
stage.
be contained within lot 100 would be the expectation, as opposed to.
Depends on the fall of the road. The road falls towards Scott Terrace, then the stormwater will flow towards Scott Terrace, so the soak pits would be near the corner.
So that will end up on distance.
So the primary stormwater would need to be dealt with within the private access road.
Yep.
But in terms of flood, if it was indeed towards Scott Terrace, then we would be looking at what the current overland stormwater paths are, and then so we would deal with that at detail at engineering design.
But you're comfortable that that's doable and
Yes.
without encroaching. Okay, thanks.
Okay, any further comments from any of the staff? Okay, thanks for your help today. All right, Mr. Hill, that takes us back to the applicant team
Yeah.
and any right of reply. How would you like to right of reply?
I might defer that to Mr. Barr,
Sure.
if that's okay with you.
Absolutely.
Yeah, a few more planning type
Yes.
queries in there, so.
Yeah, look, I don't think we are going to seek leave to provide a written reply, but there's just three matters that we might, or I might just canvass quickly
Thank you.
now, and I think that will be us done. Just with regard to the issue of the activity being non-complying and creating issues with precedent issues or the integrity of the district plan, from a planning perspective, the issue of precedent doesn't arise for this because the Dunes development and the Highlands Park fee simple development already exists in Cromwell and were established under the current district plan. So for that reason, I don't think this resource consent application would create a precedent, a negative precedent. The second issue is the activity status, and while the activity is non-complying and that can raise issues with plan integrity, it's important to reiterate that the activity is non-complying because of the legacy rural residential rural resource area 6 density rules, and not because of any rules in the district plan relating to servicing. And so the other issue, and just in relation to that, a district plan integrity issue would only arise, or could potentially only arise, if the activity was contrary to the intentions of the district plan, or more specifically some objectives and policies. But the application could still be granted or may still be granted, and that may give rise to integrity issues of the administration of the district plan. And I don't think that issue arises at all here, because it's my evidence at least, and I think Mr. Anderson is on the same page that the activities are not contrary to the objectives and policies of the plan. So hopefully that helps a little.
Yes.
And I think besides that, that's us. Thank you.
Okay.
Yeah.
Thank you for that, Mr. Barr. That is helpful. Tree on precedent effect. Okay, so we all have a process from now. Thank you all for your time today. We really appreciate it. I know everyone's busy, and we also recognise the time and effort leading up to these processes. So I'd like to acknowledge the effort that the applicant and put into this process thus far. So the process from here is that we will we'll adjourn the hearing today, and we will consider whether we have sufficient information to formally close the hearing, and then we'll advise that promptly. And then from there, once we've officially closed the hearing, once we're satisfied we've got all the information we need to arrive at a decision, we will then advise you, and then the decision will release 15 days following. So unless there are any final comments from anyone, I will officially adjourn the hearing. Okay, thank you. Morning, my name is Ros Day Cleven. I'm an independent commissioner from Ōtepoti, Dunedin, and it's my pleasure to open the hearing today for land use consent RC 250016 for JKL Holdings Limited. I'll ask the panel to introduce themselves.
Tracy Patterson, Commissioner, and Vincent Ward Councillor.
Brown, Commissioner and Common Councillor.
Mark McPherson, Vincent Ward Council and Commissioner. Jill, welcome.
Thank you. And we have some council staff online. Could you please introduce yourself? Can you hear us?
Yes, good morning, everyone. I'm Ollie McIntosh, consultant town planner working for CODC and the author of the 42A report for this application. With me today, I have Sarah Wright, the ecologist that did the peer review on behalf of council, and Hannah Wilson of Boffanesco, who was council's landscape peer reviewer.
Thank you. And can I just check that everybody online can hear the dialogue okay? Thumbs up. But at any point during today, just email the hearings administrators and just let us know via the chat, or wave out loud. Panicking if you can't hear us. It's important that you can all keep track of what we're saying here. Thank you. And
Yes, I'm Jessie Dick and I'm the minute secretary for today.
thank you. Okay, up to you, Mr. Page, to introduce your team.
Thank you. Good morning. My name's Phil Page. I'm the lawyer for JKH Holdings, the applicant today. And sitting to my immediate right is Mr. Joe Hamlin, who is effectively JKH Holdings. This is Joe's baby. It's Joe's project, so you'll be hearing from Joe. To my left, Mr. Barry Condon is the architect who has designed the building that you're being asked to consent this morning. Barry will give evidence about that. Next to Barry, Jake Woodward, who's the author of the application and our local planning guru. Jake will give his evidence last in the list. Seems to be the traditional way we do things. On the screen behind you and in front of you, depending on which way you're facing, we've got Mr. Jason Tilley. Jason, hello. Jason's our lighting expert from ECC, who's provided the lighting specifications to a second person on screen, who's Mr. Jeremy London. Jeremy is our visual simulations expert who has prepared the sims that you'll see and that Jeremy will produce and discuss. After Jason's evidence, you're going to hear from Mr. Charlie Litchford. Charlie is in the back of the room, who is our surveyor, who's provided the survey information that has been relied on by Jeremy. And it's also produced the survey information for both the proposed access and what he will describe as the permitted alternative access. After Jeremy London's produced the visual simulations, then you'll hear from Mr. Paul Smith. Where's Paul gone? Paul's back here.
Good morning.
So Paul's our landscape architect who has provided evidence in relation to assessment of the landscape and visual effects. After Paul, Ruben Rorison will present his evidence in relation to ecology matters. which we think are now all resolved, but it's important that you hear about what the proposal is in any event. And then after Ruben, then we'll have the planning evidence from Jake, and he will discuss proposed changes to conditions that we're going to be suggesting to you as well. So that's our team. I'm thinking that we're probably somewhere in the 4 to 4.5 hours in terms of presentation time would be my best guess.
Thank you, Mr. Page. We've got the rest of the day booked out, so by
Yes.
the sounds of it, we'll have sufficient time.
Plenty.
We had wondered whether we needed to reserve tomorrow morning as well, but at this point, I think we're probably going to be okay.
Yes.
Yeah.
And of course, there's always the possibility of returning to the site in
Yes.
slightly less brutal conditions.
Yes, I was going to raise that. Thank you very much. And just noting that we have no submitters attending or online or physically present today. Housekeeping.
If there is a fire, just take any of the exits out towards the car park.
And that brings us to procedural matters. So as you know, we went to the site yesterday afternoon. We were contemplating pulling the plug on the site visit because the rain was pouring very heavily. However, by the time we arrived at the site, the rain had pretty much stopped. So it was pretty windy up there, but we had a good look around. We were accompanied by a Mr. Hayden Thompson, who I understand is not involved in the application or the application team, and he works for Fulton Hogan, and he very helpfully drove us from the highway, from our meeting spot, up the existing accessway, which is the proposed accessway, up to the building platform. We had a good look around there. A number of the poles had snapped, so we weren't able to see the height of all of the tagged points. So it would be really helpful when you're presenting the visualizations and the images that you could be really clear with us about the height, because we didn't really have the opportunity to gauge that on site. We then went around, the weather cleared a bit and we even had a bit of blue sky. So we went around the other state highway on the other side of the lake and looked at some of the, using the simulations and viewpoints, we looked at those and yeah, kind of got a good feel for the key landscape issues at play. And we may or may not find that we'll take another site visit. We may head back tomorrow morning. We are being recorded today, so it's going to be publicly available on YouTube, I believe. There is one procedural matter that the panel would like some assistance or guidance on, at least at the front end of the hearing, and it relates to the difference in landscape evidence around the landscape classification. We would appreciate hearing from staff in the first instance, particularly Ms. Wilson and then Mr. McIntosh, around what bearing this may have had on their evaluations and then their overall conclusions at the outset before we get into the material substantive hearing matters. Ms. Wilson, do you understand my question there? Would you be able to make a kind of preliminary comment, or how would you like to deal with this? Would you like to make an upfront comment about that now? Were you planning to speak to that at the end?
I'm happy either way. Is this with regard to the 2008 landscape study? Is this what this question is concerning?
Yes. So in the applicant's evidence, landscape evidence, and throughout, I believe, the legal submissions and also the planning evidence, there is some discussion on a difference in landscape classification, yes, which may or may not have had a bearing on your conclusions, and then which may or may not have had a bearing on Mr. McIntosh's planning assessment. So we're really interested to understand whether you agree with the applicant, because that may then change our questions later on.
Yes, certainly. I'm happy to talk to that now. That was something I was to address later, so that's good. To begin, having reviewed Mr. Smith's evidence, and then going back and looking at the study I was referring to, there's actually two landscape studies. So to begin, on file, I have a 2007 landscape study, which did identify, and I'm happy to share that if that would be helpful, on file, which identified the site as being within an area of extreme sensitivity. Having said that, I think to summarise, there's two key reasons why I haven't placed significant weight on whether or not this is moderate or extreme. One is because, and it's no critique at all of the landscape study, it was done in 2008 and it's of its time, but now we don't assess landscape values based on magnitude and sensitivity. It's about summarising those landscape values, understanding them, and therefore assessing the effects on them. Now, from what I can see, and Mr. Smith, please correct me if I'm wrong when it's your chance to talk, but there is broad agreement, I think, with our identification of landscape values associated with the site. So my starting point was not that it's got extreme sensitivity, commissioners, it was that this is an outstanding natural landscape, and these are the values that have been identified and broadly agreed on. Therefore, my assessment is based on those values, not whether or not the 2007 or 2008 study assessed it. It certainly helps inform building the picture of, the values. But since then, best practice has moved on. We've both, I think, broadly agreed on the values of the site, and that's where my assessment has stemmed from. So that's kind of where I'm coming from.
Okay, thank you. And so we can arrive to you at questioning
Yes.
Later, and we can continue that conversation with you there.
Fantastic. Yeah.
Okay, thank you. So in a nutshell, at this point, there's nothing procedurally that you wish to correct?
No, I don't believe so, not at this stage. But just to be clear, the point that hasn't driven my assessment of values. Yeah.
Okay, thank you. And Mr. McIntosh, do you have a comment to make at this point before we commence?
No, I don't really have anything to add to that. Just to confirm that Ms. Wilson and I had conferred on that very point prior to the hearing, and I had understood that to be her position, so I don't think it really has any consequence to either her conclusions or therefore my conclusions where I've relied on her evidence.
Thank you for that. Mr. Page, do you want to have a comment on that at this point? I guess the panel wanted to make that clear at the outset.
Yes.
Because you've got a lot of experts here, and we wanted to, I guess, test that at the very outset to understand what we were dealing with, if there was in fact an error or not.
I would like to discuss Ms. Wilson's response with Mr. Smith before he gives his evidence, and there'll be time enough to do that.
Okay.
But I think we understand sufficiently what she's now saying, that it's just a question of evaluating what the assessment actually is.
Okay. Thank you. You're happy for now that we?
Yes, I'm happy that we move on for
Okay.
now, and Mr. Smith can comment on that when he gives his evidence.
Thank you. Okay, and are there any other procedural matters that any party would like to raise before we commence?
If I might, it's not really a procedural matter, but just in terms of scheduling for today, I've heard Mr. Page's outline of sort of the order of events. I'm just conscious that for the ecological experts in particular, it sounds like they'll be going towards the end. I might suggest that either they go first so that Ms. Wright can be dismissed early, or that if we can try to sort of lock in a rough time when we think the ecological experts will be going, that might be useful. so that she can duck out and come back in at that point.
Does Ms. Wright have other commitments? Is that what you're saying?
She is available throughout the day, but I discussed that with her earlier. We're anticipating that the ecological evidence will be a relatively, small part of today's proceedings. So for the sake of efficiency, it would be an option, I suppose, that we schedule
Okay,
it in
thank
that
you.
way.
I'll let me put that to Mr. Page. Mr. Page, how do you feel about that?
Well, we would rather that you dealt with the main issues up front. And so reversing the order doesn't suit us particularly well. But I understand that Ms. Wright may want to leave the hearing and come back when Mr. Morrison gives us evidence, and we, if she's on standby and can log back in, that seems to be the way to deal with it.
Okay. So yes, if did you hear that, Mr. McIntosh?
Yes. Yep.
Yes. So if Ms. Wright is available, she can log in and log out as she chooses.
Sure.
Perhaps you can keep her in touch with when that presentation is due.
Sure.
And we'll continue with the line of expertise as pitched by the applicant at the beginning. Thank you.
Thank you. So you will have my opening submissions that I will speak to rather than
Yes, all the material has been pre-read.
yes.
And it's always helpful to have a high level summary, or
Yes.
focusing on the key issues would be.
All right. So if before jumping into the submissions, I want to orient you to the 42A report to explain why I've taken the approach that I have in my submissions. In other words, what am I responding to? And so if you go to page 11 of the 42A report, what you'll find on page 11 is the author's discussion of the permitted baseline.
Yes.
And in particular, the second to last paragraph in the bottom, the author says, I do not consider it appropriate to apply the permitted baseline to the dwelling, access road or broader landscape effects. These are assessed on their merits. Now, my submission to you is that is where the 42A report fundamentally gets off on the wrong track. Because what is unusual about this case is that you are being asked to trade one set of rights for another. The one set of rights that we're talking about is the rights that apply through the existing consent notice. In other words, the existing building platform that I think you went to yesterday.
Yes, we did. Yes.
And our client's right to build access roads under the Schedule 19.63 process that I'll come to in a minute. So there is a substantial body of rights that my client has to develop that land now. And what he's saying is that he will give up those rights in return for what is now proposed. And so we are dealing, put it bluntly, with a trade-off between what he can do and now what he wants to do. None of that flavour is captured in the permitted baseline analysis, because what the author is saying is that we're going to deal with the proposal on its merits, but not do a comparison between what exists and what the merits are. And that's where I think the report fundamentally gets off on the wrong track. And so when we come to the summary of the landscape issues 2 pages later on page 13 of the report, there are 4 bullet points on page 13. The first of which is the introduction of a large dwelling in the upper slope environment. And so that's a landscape issue that we'll come to. There's the substantial earthworks that are, that's bullet point 2. There is what is described as a broader domestication of extending pattern of domestication upslope. Again, that's a landscape issue. And there's precedent effect. So you can't really understand from a decision-making framework point of view, how to respond to those 4 bullet points unless you have a clear grip about what does the plan provide for, what is permitted by the existing consent notices. And fundamentally, my submission is going to be driving at is helping you to understand that what you are really doing is comparing what my client can do with what he wants to do. And you don't get a sense of that comparative analysis from the 42A report. And that's what I think your job actually is here. So, coming to my written text of submissions, on page number 1, in paragraph 5, I set out the 3 reasons why we needed consent. First is to amend the terms of the current consent notice. That's a fully discretionary activity. The second is Rule 473, Roman 7, which is a consent for a residential activity. That's discretionary, and we only need that because the proposal is not within an existing building platform. And so that rule applies anywhere in the rural resource area of the district, whether you are ONL or not. So it's not an ONL rule. It simply says you need a consent for a residential activity. And third is the breach of the standard for the maximum cut height for track access. So those are the 3 reasons why consent's required. The first issue is around changes to consent notices. The 42A report correctly identifies Ballantyne Barker Holdings as probably the leading case in the High Court at the moment, but in my submission it misapplies it. The Ballantyne Barker case wasn't a case that concerned with whether a particular building consent, a particular consent notice should be varied, but rather whether the High Court could rely on a consent notice as being an effective tool. Paragraph 44, the High Court said, in considering such applications, this court has emphasised that good planning practice should require an examination of the purpose of the consent notice and an inquiry into whether some change of circumstances has rendered the consent notice of no further value. And I've set out the context of the full quote there at paragraph 8. So what we're saying, or what my submission about Ballantyne Barker is that the first thing that has to be done is an examination into why the consent notice was registered in the first place. What purpose did it serve? What was the RMA function of what was being established through the consent notice? And whether that is still relevant. Ballantyne Barker doesn't require anything more than that. And so this is the trouble, because the 42A report doesn't tell you why that consent notice was registered in the first place. What it does is take the text of the consent notice and infer an intention from that. But the author hasn't gone back to the old consenting file and say, well, whose idea was it and what was being achieved by it? And so that's why the developer of the property, Mr. Brett Larson of GB Water Limited, has filed a statement explaining why that consent notice was registered. And you'll have seen Mr. Larson's statement. It was both filed as part of our package, but also GB Water Limited was a submitter, so it was the same statement was refiled for GB. And so what Mr. Larson does is explains that from a land development standpoint, the value of an improved building platform is it converts a discretionary to a controlled activity for a residence. So what it does from a marketing point of view is give certainty to a purchaser that they can build a house. Because, of course, as a discretionary activity, there's no certainty. As a controlled activity, you've got certainty you can build a house. So when a buyer is buying the land, as Joe did, he knows that he can build a house. So that was the purpose of the exercise. It was around certainty for the land developer and the purchaser that it was permissible to build a house. So a house on that property is a fait accompli. But what Mr. Larson explains is that that site, which is the existing consented building platform, wasn't identified through a landscape analysis about where it was or was not appropriate to build a house. It was simply done because that was a location close to services and it was cost effective from the construction of an access and services connection point of view. So there wasn't a landscape rationale behind the selection of the existing building platform position. So what we say, and this is what Joe addresses in his evidence, is that, well, if the intention was just to provide certainty that development was possible, well, then that's fine. But it doesn't serve the purposes of saying, but nowhere else is appropriate. That's not how that consent notice was conceived or registered. And so it's simply a question of landscape assessment about where an appropriate location for a building could be. And so that's the work that the applicant has done, and the outcome of that work is what's being presented to you this morning. So where the 42A officer recommends, and this is page 23 of the 42A report, if you have that. So page 23, the officer identifies 4 bullet points. What they say the consent notice does: concentrate development within a defined building platform. Well, yes, we accept that that's how it works. Avoid dispersal of built form across sensitive upper slopes. Well, there is just no evidence that that is what the purpose of this consent notice was for. And Brett Larson says, no, that's not what it was for. Restrict vegetation clearance and disturbance of schist rock outcrops, and provide a high degree of certainty to neighbouring landowners and the wider public. Well, again, and we say that last bullet point's a misunderstanding. Yes, a consent notice is a registered instrument that people can search and understand what it is, but it wasn't registered for the purpose of providing neighbours with certainty about where a house goes. That was never part of the thinking. It was around providing certainty to a purchaser that they could build a house. So we say that if you understand from the land developer's evidence, Mr. Larson's evidence, what the purpose of that consent notice was for, you should be approaching the application to change it, not that it was there to provide certainty to anybody else about a building platform, but it's around certainty to an applicant about the ability to build. In terms of has there been a change of circumstances, Mr. Hamlin's evidence discusses the grant of the helicopter consent to Scapegrace, which is just down the hill. You would have seen Scapegrace, as being a reason that Joe would prefer a more remote and private location. My submission in paragraph 12 is that the Scapegrace consent is a material change in circumstances. So to the extent that that's what Valentine Barker requires, you can be satisfied that. There's a second issue though, and that relates to ecological enhancement, because clause 16H of the consent notice requires the consent holder not to disturb vegetation on the site beyond constructing an access or a building platform. And so what we have now is a very substantial ecological enhancement covenant and a proposed predator-proof sanctuary. So we say that what's being presented to you is actually a much more developed and sophisticated response to the ecological issues on the site. And so 16H isn't required anymore. And that too is a change of circumstances that you can take into account. So the thrust of my submissions is that when you understand the genesis of the way that this site's been approached and developed by the previous developer and now by Mr. Hamlin, you shouldn't feel constrained in your power to amend the consent notice if you accept that the new location for a house is appropriate and from a landscape point of view. The next topic I want to shift to is the district plan itself. And the reason why this matters is because the application site, both Mr. McIntosh and Mr. Would recommend accept is part of Bendigo Station. It's formerly part of Bendigo Station, which is a Schedule 19.6.3 property in your plan. Now, the district plan itself says very little about why Schedule 19.6.3 exists. And so it's important to unpack some of the history of that to understand the policy trade-off that was approved by the Environment Court through the Royal Forest and Bird Protection Society case back in 2004. And you will have seen from my submissions at paragraphs 22, I've set out the reasoning that the court went through to adopt Schedule 19.6.3. So in effect, what is happening, DOC, Forest and Bird were seeking not only a schedule of significant natural areas, but also a general rule restricting vegetation clearance and a whole bunch of other things outside of those SNA areas. But DOC recognised that an exemption should be made for a general protection rule for properties that had been through tenure review. And the reason why DOC recognised that is because that DOC didn't want to discourage people to go through tenure review, because the tenure review process was allowing DOC to use the Crown Pastoral Land Act to identify significant natural resources and landscapes and have covenants that directly controlled, either through revision to Crown Estate or through covenants registered in relation to land that's freeholded under that Act. There was a process of protection that was available that had a public good element to it. And the Environment Court recognised that and accepted that properties that have been through tenure review should be listed in 19.6.3. and that those properties would have available to them certain exemptions to your district plan rules. And so this property is one because it was part of Bendigo. So there's no other property on the Dunstan Range that is in Schedule 19.6.3. Bendigo is the only one. All the others, most of them are actually on the Pisa side. So why does this matter? Well, from a precedent point of view, and this is a concern I think raised in the 42A report, only properties that are listed in 19.6.3 have the benefit of the O&L exemptions that I'll come to. So their precedent risk is extremely low. For example, Northburn Station immediately on the south side is not a Schedule 19.6.3 property, and so the same approach wouldn't apply here. So what's the consequence of being a 19.6.3 property? You'll see that I've set out the rule references in my paragraph 27, which is rules 472 Roman 6, which is the O&L rule, and 476L.1, which is the standard for tracks and earthworks in the O&L. So in effect, my submission is that being a 19.6.3 property effectively exempts the application of the O&L rule controls for this property. As a matter of fact and planning map interpretation, it's an O&L property. It is in the O&L. Both the existing building platform and the proposed new ones are in the O&L, but the rules are disapplied. That's how the Schedule 19.6.3 works. That's why I say at paragraph 28, effectively the function of Schedule 19.6.3 is to treat Bendigo as not being O&L even though most of that former station and the application site in particular is in fact mapped as ONL. So my submission at paragraph 30, where I come to, the 42-hour reporting writer's assessment is founded upon an inadequate understanding of the history of Schedule 19.6.3 and why the applicant property enjoys exemptions from the ONL standards in the plan. And that is compounded by an inaccurate understanding about the purpose that the existing approved building platform serves under the consent notice. In effect, I'm saying way too much weight's been put on ONL issues for this particular site. I want to now come to the Larks Bay decision. Larks Bay is the most recent Environment Court decision, which turned down an application for a building platform in the ONL. And you'll see at my paragraph 31, I've included an aerial photograph to show the site that the Environment Court was dealing with in Larks Bay. And my submission is that Larks Bay is a very different case to the one that you are now having to deal with. Firstly, Larks Bay was not a Schedule 19.6.3 property, and so there was no exemption from the ONL provisions. Secondly, in Larks Bay, the subdivision that created the application site did not contemplate residential use of it. It was developed for a vineyard, and I set out paragraphs 50 and 51 of the Environment Court's decision by paragraph 34. So in direct contrast to Larks Bay, here the site does have a building platform, and so residential use is a given. So there's not the same policy problem around is this an appropriate site for residential use? And thirdly, and this is what I deal with at my paragraph 36, in Larks Bay, the Environment Court held that the application site was a prominent part of the backdrop in views from Cromwell. And so that's why we've gone into such an amount of effort, and not only in terms of the landscape analysis, but also in terms of the visual simulations, to give you comfort that from the Cromwell side, from Peter Moorings around to Cromwell, you are just not going to see this this development. So coming to my paragraph 39, in contrast at Larks Bay, you're being invited to replace an existing prominent building platform with a specific house proposal that is in a much less prominent location and with a specific building design that's been subject to extremely detailed visibility assessment. The evidence of Barry Condon explains the architectural brief and why the design makes the building disappear into the landscape. Lastly, I want to talk about the access track. And this is where there has been some development in the evidence since Mr. McIntosh prepared his report. And this is what I address at my paragraph 41. The officer has recommended declining also to use the permitted baseline for the in relation to the access track. My submission, that's conceptually unsound because it actually undoes Rule 19.6.3. Rule 19.6.3 was deliberate as in relation to tenure review properties to enable the construction of access tracks in the ONL. Rule 476J makes it clear that the construction of access tracks is permitted provided that certain standards are met. And so we accept that the standards are not met for the access track that is proposed because the cuts are more than 2 metres high or more than 3 metres for 10% of its length. But what Mr. Latchford has done, subsequent to the 42A report, when we were slightly taken by surprise about how much weight was put on the access track issue, is to investigate whether it is possible to construct a new permitted access track that could link the bottom of the site to the building, to the what's now proposed for the house site. And the answer is yes, that can be done. And so Mr. Latchford's evidence explains how that can be done. And thirdly, in my paragraph 41C, the 42A reporting officer relies on an earthworks plan prepared by Mr. Latchford for the idea that 8-metre cuts will be visible. And that has led him to suggest that such cuts will be inconsistent with existing access tracks on the property. But what he didn't do was conduct a visibility analysis about from where can you see those cuts? And will they be able to be perceived by the public from off-site when looking up onto that face? That simulation work has now been done by Jeremy London at Paul Smith's request, and Paul's evidence, you'll see from his written evidence, is that you will not be able to discern from off-site where those cuts are. And that would have been obvious to you, I suspect, when you went up, because the really steep bits are pretty obvious to you when you're in a vehicle, but most of the big cuts are actually tucked into a gully, and you're not going to actually see those from off-site. And that's effectively the what Jeremy and Paul's work has identified. Now, it's important to understand that in relation to the construction of an access track being permitted, this is something that you're free to discuss with Joe when he gives his evidence. But even if the existing consented site was to be used as opposed to the new house site, a better access track from the bottom of the site to the top for land management reasons is intended. And so it's just a question of where's the best place for it to go. We suggest that the access track that is being part of the application is the right way. But you should anticipate that there will be a new access track to the top of the property at some point. You get to control where that is the short answer to that message. Turning to the overall effects conclusion, and you will find the summary of that in the 42A report at paragraph 25. This is an unusual kind of case because mostly when you are being asked to consider an application, the consequence of turning it down is that the status quo continues. So there's no risk involved of losing anything in value. But that's not the case here, because the applicant has existing rights that may be exercised, and the applicant will not have any obligation to offer the very positive ecological outcomes that are now proposed. There's an existing 1,600 square metre building platform that can be used. No account for not using that building platform has been allowed for in the 42A report. Much of the overall effects conclusion is actually quite positively disposed to the application, particularly in relation to ecological outcomes. And my submission to you is that those offers are on the table if the consent's granted, but my client's under no obligations to do any of that if he is required to use the existing building platform. So So the overall submission that we have is if you understand the site's history in the context of the plan, you should be much less concerned about O&L values than what Ms Wilson or Mr McIntosh are recommending. Site's own planning history puts us in a very different category of application to Larks Bay. Although it's in an O&L and we're quite properly concerned about maintaining the O&L values, you need to understand that in the context of those trigger rules and clause being disengaged by 19.6.3. So we need to be careful not to undo what that schedule is trying to do by pretending it doesn't exist and just treating this as a standard O&L case, because it's not. That's what I wanted to say by opening submissions.
I do have a couple of questions for you on your written submissions. So firstly, in relation to paragraph 8, you're talking about the Valentine Barker holdings.
Yep.
And so I am interested in the change to the consent notice and the submissions you've put forward around what constitutes a material change and circumstances. And so I note that the excerpts from the High Court focus on material change in circumstances, and there's a specific example provided, such as a rezoning for a plan change process. And I note that we don't have a material change like that in this circumstance.
No.
But I'm wondering, was there any further guidance or discussion by the court about scope of what a material change can?
No, there wasn't, because the court was dealing with a hypothetical in that case, because there wasn't a proposal on foot for it to examine.
Yeah.
And so there's a curiosity about section 221, because when the Act was originally, when the RMA in 1991 in its original form specifically required a change of circumstances for variations, not only under 221, but under 127 as well. That got reversed out of the Resource Management Act as a statutory requirement, I think, in about either the 99 or the 2009 amendments. So there's no statutory requirement which says you have to show a change of circumstances. What Valentine Barker was doing was saying, if you look at why the consent notice was registered in the first place, you should look to what has changed to make that original reason no longer useful. So it's not saying that there is a legal requirement for a change in circumstances, but logically, if there was a good reason for it to be registered in the first place, does that good reason still exist? And if it does, well, then we've got a problem. But if the evidence is that that reason either no longer exists or can be met in some other way, then there is no legal barrier to changing a consent notice.
And in terms of the, you've put, the applicants put forward the proposal to relinquish existing development rights.
Yes.
And instead, this proposal would replace those development rights.
Yes.
And this may be a question for one of your witnesses, but in terms of the legalities of the conditions imposed and the legal instruments to ensure that that would provide certainty longer term, is the applicant confident that that will be achieved?
Well, so what's proposed is that the consent notice be redrafted. So ordinarily in an application like this, there wouldn't necessarily be any consent notice because there's no subdivision involved. So you would simply have a resource consent which says you can build a house over here and it has to comply with the conditions. What we're saying in this case is that there is an existing consent notice. We're not saying remove the consent notice entirely. We're simply suggesting that there are drafting changes that should be made to it to accommodate what the new proposal is. So you've still got the dual consent notice resource consent conditions framework. Yeah. Would it be possible in the future to apply again to amend those things? Of course it is. It's always possible to do that. There's nothing much we can do about that.
Thank you. Paragraph 32. Today it's not 37, sorry, 37. Here you're talking about the precedent, and you did highlight some of the factors around whether a precedent would be engaged or not. And here you're talking about the property ownership in the Larks Bay case. So you've used that as a comparison. There is no such precedent concern in relation to this factor, I guess, is what you're saying. Can you just explain that paragraph in relation to this site in terms of the property ownership here?
Okay, so before getting to your direct question,
Thank you.
I'll explain why I'm contrasting this with Larks Bay, because in Larks Bay, the same landowner as the appellant in that case, because council turned it down in the first instance and Larks Bay appealed, also owned the 5 immediately adjacent properties to the north, which were materially the same in terms of elevation and visibility from Cromwell and had no building platforms. And so what's apparent from the Environment Court's decision is that they were spooked by that. If we grant consent to this one, how are we going to manage the applications for the 5 identical properties next year? So what I'm saying is that here we don't have that problem. And one of the reasons why we don't have that problem is because Schedule 19.6.3 was limited only to Bendigo properties. So there's the property immediately adjacent and to the north of Joe's is owned by Bendigo Developments, which is also associated with the Perriam family. That's also a former Bendigo station property now held by Bendigo Development. So that one next door is also Schedule 19.6.3, but doesn't have the other qualities that Joe's has, which is an existing building platform that's been registered. And so questions around is this an appropriate place for an appropriate property for residential use doesn't exist. So the combination of those things, my submission means you don't need to be worried about precedent effect in the same way as the Environment Court was in Larks Bay.
Thank you. It's helpful. I'll just see if we have any further questions for you.
Mr. Page, I have a question, and it's for clarification. There's been a lot of emphasis that you've put out today in relation and in your presentation in relation to how the provisions of the tenure review process carries on and on and on into smaller parcels of land. I understand the tenure review process in relation to Bendigo Station.
Yep.
But what I need to be satisfied is that how does that legally keep dropping down to smaller parcels of land and arguably within the district plan ability down to an 8 hectare lot?
Well, the short answer is that Schedule 19.6.3 doesn't distinguish between who the owner is or what the size of the property is. All that you have to be satisfied about was that the land parcel that you are dealing with now was a tenure review parcel. And so it's a question of going back to the original legal descriptions that fell out of tenure review and saying, is this parcel of land that we're dealing with now, was that part of the original freehold estate? And the answer is yes, it is. And so that status continues down through subsequent owners and subsequent subdivisions. Now, the council can manage that risk through the subdivision process through conditions and controls if it wants to. And so it's just a question about whether it has or it hasn't. But your district plan does not distinguish between subsequent subdivisions and landowners relative to the original tenure review land parcel. As long as you're within the outline of the original, what was freeholded under tenure review, then you're in.
So the answer is yes, it could fall down to 8 hectare lots if it was.
It could.
I do have another question. You said that the recommended building platform was only an indication of certainty of a dwelling being put on the property.
Yep.
Why were the 2 domestic tanks put in place in relation and so proximate to that building site?
Over the 2 water tanks placed there.
Domestic water site, the domestic water tanks that are on the property
Yeah.
that are there to service that building platform.
Yeah, well, Joe will know the answer to that.
There's 2 sets of tanks on the property, one at that, and there's another set of tanks at the other end of the property. One for domestic, one for irrigation, and they service the whole scheme. So those tanks are for the whole scheme, not just for that site. And the other set of tanks are right next to the accessway you drove up for the proposed accessway. They're just to the left of that
So they service the
scheme.
whole scheme.
Yeah, so the scheme's got an easement through my property to access those tanks.
And so you would have seen the water reservoir when you went through the gate and the pump shed there. That's all on Joe's property. But that's a scheme for the whole of the Bendigo Downs development.
Minutes, thank you.
It's intriguing. The tenure review process. The consent notice on that existing house lot. How would that have come about? Was that a bit of a sweetener in the deal, or?
But why did they put the consent notice on?
Well, no, but why that particular site? No,
Well, if you have a look at Brett Larson's statement that was filed with our stuff and with GB Water, basically because it was the closest location to services. It's the cheapest possible part of the site to develop.
cheapest, easiest place to build.
Yep. Well, not necessarily easiest, cheapest.
No.
The cheapest place to run infrastructure to, or Brett. The boundary was the closest to the transformers and the water pumps.
Convenience. Yep.
Okay, well, thank you, Mr. Page, for your submissions. We can proceed now
Right.
and hear from your witnesses.
Well, so Joe's going to go next, and so he has prepared a summary that I am going to hand to you. I'm wandering around handing things out without
Oh,
getting.
thank you.
Thank you.
Morning, commissioners. My name's Joseph Hamlin, sole director and shareholder of JKH Holdings, the applicant. I'd like to speak briefly and personally about why we're here, why I bought the land and why the proposed dwelling is where it is and what I'm committing to. Why this site and why this project. I'm a New Zealander. I grew up in Wairau and Hawke's Bay. I have a deep connection to this country's landscapes. I'm moving my young family, 2 and 5-year-old children, to Centro Otago to put down roots, raise my children close to my family and friends, and settle here for the long term. It's not a commercial or investment decision. This is a personal and a family one. I bought the site because it's a substantial piece of land with real restoration potential. I want my children to grow up somewhere I can demonstrate to them that with hard work, vision, and patience, you can positively impact the environment for future generations. How the dwelling location was chosen. The proposed location was not picked by me in isolation. From day one, I engaged specialist consultants in landscape architecture, ecology, and planning, and the location reflects their combined professional judgment. Landscape. Our landscape architect assessed multiple alternatives and concluded the proposed site best responds to the outstanding natural landscape, a higher setback from the roads and neighbours, and integrated into the landform to minimise visual intrusion. Ecology. Our ecologist directly evaluated the options and confirmed that the proposed location avoids areas of high ecological sensitivity and supports rather than undermines the wider restoration program. Planning. Our planner advised on the existing consent notice and policy framework throughout. I knew when I purchased the site that the existing building platform had been consented where it had been, and that moving it would require a new resource consent. I bought the property specifically to do a proper expert-led assessment, not to default to a location the developer chose for cost and convenience. As I understand it, the consent notice was intended to give a buyer certainty about the right to build, to permanently lock every other location on a 827 acre property. The license evidence confirms that this was not his intention either. The helicopter consent at Scapegrace. There's a further more practical reason I do not want to build on the platform. The neighbouring property holds resource consent 220379, authorises up to 30 helicopter movements a day, 15 landings, 15 takeoffs, 7 days a week between 10 a.m. and 9 p.m. The consented approach and departure path passes directly in front of the existing building platform. I built there, my family home would sit directly in front of the chosen flight path. We would lose privacy. Helicopters on approach would have direct line of sight into the dwelling and outdoor living areas. Proposed location being set back further at higher elevation provides considerably greater separation from that flight path and associated activities. My commitment to the land. This project has no commercial driver. It is probably the opposite for me. My motivation is entirely personal. To build a meaningful family home to educate my children around best environmental and ecological practices in a way that materially improves and secures the benefits for their children in the future. I've committed a substantial ecology and environmental program that goes into great detail around what I propose to action for the site prior to construction of the house. These include a 4.8 hectare predator-proof sanctuary, 3.12 hectares of enhancement planting, minimum of 14,000 native plants, full perimeter fencing of the site, site-wide pest and weed management, annual reporting of all aspects, registration of a covenant over 223 acres of the land. The proposed dwelling location is consistent with my vision. It allows me and my family to live within, actively oversee the restoration rather than sitting at the edge of the property, not being able to actively manage those enhancements. I'm aware that the 42A report expresses concerns about the earthworks associated with the proposed access. I will want to build an improved vehicle access to the top of my land for land management reasons, whether the new house site is approved or not. I understand that I'm allowed to do that. The alignment my team has chosen is the best compromise between reusing an existing track and achieving a satisfactory gradient for my family's use. However, as our surveyor, Mr. Charlie Latchford, will explain, there is other potential route options that I can use if you do not approve this proposed route. Closing, I ask the commissioners to see this application for what it is, a family making a long-term home and a location chosen through careful expert advice that enables a serious long-term ecological-led restoration of the land. Thank you.
Mr. Hamlin, are you happy to take questions? So in terms of the helicopter consent, when did you first become aware of that?
Due diligence in purchasing.
Okay. So when was that granted, that consent? Out of interest, was it?
I don't recall the date of it, but the consent application number is a 22 number.
I can confirm in about 30 seconds.
Okay. So it's not a critical factor, but if you can get that to me, I'm just.
I can save you the effort, Jake. It was 12th of June 2023.
Thank you very much.
Thank you. Right. Oh, so you were aware of that on purchase and you'd already contemplated that that was in existence. Thank you. In terms of your summary statement here, where you've talked about building improved vehicle access to the top of the property for land management reasons, regardless of whether a new house is granted or not. What land management reasons are they?
Just be to manage the security and the predator proofing of the property.
But right, okay.
At the moment, there's a lot of poachers on the property, so I've got game cameras and there's lots of poachers on that property. So,
Okay, so for security and pest management, right?
and you would have seen on the track yesterday that it's probably not ideal for family driving up and down.
Yes, yes. In general, better access. Yeah, thank you. And I see you've your commitment to the environmental program. Have you, obviously that's going to be a big effort. There's substantial amount of planting. And I imagine you've discussed with your expert or some of the factors that might be involved in terms of ensuring that that can be achieved at that scale.
Yeah, we've worked closely with Ruben and his team to make sure that we can achieve the results that we need to.
You're comfortable.
Yep, and our reporting, when we do management plans, our reporting that we'll submit every 12 months will show evidence of the establishment of all of those. Yep.
Yeah, I was interested in to hear that you didn't put the word in, but you mentioned it yourself, the word patience, when you come to Central Otago. So obviously, when you're talking, just following on of Mr. Clevens, the patience element. I just was wondering if you had any other experience in relation to dryland restoration, or is this a passion project, or is this something that you are genuinely just interested in, or is it site specific?
It is site specific for this one, the restoration of this site, because have I got experience in dryland restoration? No, but I've engaged with Ruben, who is from the area and has significant experience in that. Yeah, and forward to the challenge of it.
Okay, and you've mentioned several times in the very much the theme of your statement is that there is no commercial reasoning, and that it is for family and for you to have that, I guess, that privacy and that. Would you, was there any other intention about potentially looking at protecting in perpetuity the block as a whole? And not necessarily what I mean by a covenant for QE2, I'm meaning as protecting the block as a whole piece of land.
Regards to future subdivisions, or yeah, I think we've discussed it briefly, haven't we, Jake? But I don't think it's not an option. So I mean, I purchased that piece of land purely for the size of the land, and I'd look for years to find a piece of property that size, close to in the location proximity to everything. So that wasn't an overnight purchase for me. That took probably 4 years of searching and over 2 years of negotiation with Brett to come to that conclusion. So it's not something while it's in my ownership that will get subdivided.
With regards to the QE2 covenant, and obviously I note that at this stage it wasn't going, and this was obviously in your experts as well, that wasn't going to be something that was currently available in relation to funding from the QE2. Is that something that you want to do on your own and put into the QE2 that portion, that 223?
We offered it to them, and we offered, and they pretty much said they weren't interested. Yeah. They don't have time, they don't have resources, they don't have, I don't know if it was too small for them, Jake, but yeah, we engaged with them and they just pretty much said they're not interested. Strange.
Thank you.
Thank you.
Thank you
very much for saying that.
All right. Thank you, Joe. Next, Barry, could you introduce yourself? And while you're doing that, I'm going to hand up your summary statement and We're conscious that you'll be looking at screens as you go, as opposed to high quality A3 prints of the key documents. And so
Yes. Shiny lots of paper. Thank you.
there's more to come.
Thank you.
Printing bits as much as the here.
Yeah.
Good morning, Commissioners. My name is Barry Condon. I'm a registered architect and director of Condon Scott Architects. I've been practicing in Central Otago and the Upper Clutha for over 20 years, working extensively in sensitive rural and alpine environments. I will keep this brief as you will have read my full evidence. At its core, this project is a site-led design. Starting point was not a building, but the landscape. The building platform itself was identified by the landscape architect Paul Smith, specifically to avoid visibility from public viewpoints. It sits within a natural gully and is not part of the wider scenic backdrop to Lake Dunstan. This decision fundamentally shaped everything that followed. From an architectural perspective, our role was to work with the site as found, not impose a form onto it. The landform is defined by a rocky gully, schist outcrops, and a natural gap in the terrain. The building has been positioned within that gap, and the triangular form comes directly from those physical conditions. The design intent from the outset was to create a building that is recessive, discrete, and absorbed into its setting. The building is recessed into the landform with its height deliberately controlled to avoid any skyline exposure. It is broken down into 3 pavilions and arranged around a courtyard rather than in a single large volume, which reduces its visual presence. The garage and service elements are set into the hillside at the rear, so vehicles approach from behind and are not visible from outward viewpoints. That was a deliberate move to avoid typical visual effects associated with parked cars and access areas. In terms of the materials, we've used a restrained palette of earthy recessive tones to reflect the Bendigo landscape. Probably the best page to look at for that is there's a render on the last page, just gives an impression of how the building sits in the landscape.
Was that
It's SK07. It should be the last page in the printed material.
for those online? We're just looking at the what I call these. How are these attached to the applicant? Is it attached to your applicant?
Well, they are actually in the 42A report as well. I can give you a page reference number to. The reason for reproducing them is we wanted to be in charge of the quality of the printing that you've got in front of you.
It's really helpful. Thank you.
No, actually, that last image was part of the application documents, but hasn't been reproduced in the 42A report. Yeah.
Just, yeah, it'd be helpful for everyone online to know exactly what image. Can we share the image online as people to know? That we found.
That's our bound copy.
Oh, okay.
And that's his activity.
So in the copy attached as evidence.
There's a page in Paul's report.
Yes.
I've seen it somewhere. In
Yeah, it's page 10.
Yeah.
Thank you.
My graphic. Oh,
Excellent.
OMM's graphic evidence.
Thank you. So for those online, we're looking at page 10 of Mr. Smith's landscape expert statement of evidence. And we're looking at image SK07. Thank you. Thank you. It's just helpful that we all know that we're looking at the same thing.
Absolutely, absolutely. Just for reference, it should be noted that this viewpoint is from within the site. It isn't from a public viewpoint. It's from within the applicant's site. So in terms of material, we've used a restrained palette of earthy recessive tones to reflect the Bendigo landscape, and that is what this image is demonstrating. The glazing has also been carefully considered. It is low reflectivity glass that is orientated and shaded to minimize the potential for glare. The main facade faces north. At low sun angles, the surrounding landform reduces oblique light. At higher sun angles, the glazing is shaded by deep eaves. Top of that, the glazing itself has a lower reflectivity than standard double glazing. So there are multiple layers of design working together to reduce the likelihood of noticeable reflection. The way the building is experienced is also important. It is not visible from a distance. It is encountered gradually, emerging from within the landform rather than presenting a prominent object on the landscape. Finally, I would emphasize that this is not a generic design that could be placed anywhere. It is a direct response to this specific site, to its landform, to its constraints and its opportunities. In my opinion, the proposal represents a considered and appropriate architectural response. It has been designed to sit within the landscape, not stand out from it. No expense has been spared to ensure that landscape values are protected, and a rigorous design process has been followed to ensure that a casual observer will be unaware of the presence of this house. Thank you.
So in the client brief on your statement of evidence, the section headed client brief,
Yes.
you've talked about the retention and integration of existing rock formations.
Yes.
How challenging was that for you in this design?
Quite challenging. But when you had visited the subject site yesterday.
We went yesterday and we really wanted to understand the design and how integrated within the landforms that we could see.
Yeah. So when we arrived on the site, this particular location had been identified as the optimal location for the site. So what we were trying to do is basically design between these. There's a natural gully, there's two landforms, and then there's another rock formation behind. And so essentially what we're trying to do is just seat the building into that natural landform. And that's where that triangular, it is loosely triangular in shape, and that is where that plan form had its origins. And then further to that, we were conscious of domestication around the property and how we would handle that. So that is where that courtyard at the center of the home originated from. But yeah, it's very much a response to the physical landform.
Yes, and just for my clarity of understanding, was there any of the landforms that need to be displaced? Or specifically for the building?
No major landform. There is some excavation that will be required just to seat the building into the form. But generally speaking, it sits into that form.
So those big rock forms that we would have seen on site, they all remain.
Yes, they do. Yeah.
Thank you.
Whether there's one floor level or it's like, but I can't quite be on a slide. I can't see any steps on here, but you've got both 7.
So was your question, is there any
That's single level.
change? It is single level, yes.
Oh, yeah.
Yes.
Questions? Absolutely. No further questions from us. Thank you. That's very clear. And we've understood everything you've said.
Yep.
So we, are you going to be here for the remainder of the day? So if something pops up, we can. Yeah. Thank you.
Yeah, thank you.
And while we're on the subject of building specifications and performance, we move to Mr. Jason Tilley.
Good morning, everyone. Thanks for having me along. I'll just start by carrying on from my brief of evidence, just to discuss the lighting and how we approach that. So I'm part of the ECC commercial lighting team. I'm based in Christchurch, and my role within ECC is to work with residential lighting design, specification of product, and the facilitation of that for the project that we're involved in. I've worked extensively with Barry and his team at Collins Scott over a number of years on their residential projects and the lighting designs for those, or specifically for those individual projects. The brief that we were given from Barry and the team was that the lighting design would be for the interior, and it would be a minimal layout of design. The importance would be to have low glare functionality, and in this way, this enables the house to have less spill glare into the landscape. Our design was based around this brief, and you'll see with the documentation, you'll also see within the provided Dialux lighting calculations, which were provided to Jeremy, which he has put into his visual modelling. You'll see that the lighting outputs and the lux levels are very minimal. From a spill perspective from the home, and this takes into account the glazing that Barry has just mentioned, with minimal reflection, and specific glazing, and the specific automated blind system that has been implemented as well through the use of an automation system that will be in conjunction with the lighting design. So essentially, that's what our brief was. It's something that we specialise in. We haven't overlit the spaces, and that was part of that brief that was given to us by Barry. And essentially, that's it from a lighting perspective at this time.
Thank you, Mr. Tilley. I'm interested in your written evidence. You talk about the automation systems that can be used by the homeowner. Could you explain what sort of automation you're referring to, and what light relates to?
So it's really a control system, and that is usually part of supply from another entity. We don't do control systems ourselves, but all the light fittings and the fixtures that are incorporated into the design can be controlled. So those control systems, they can work with ultimately having the right amount of light in a space that the client is happy with. So it's sort of automating what you would normally have in a house with a dimmer. So going back to a standard house, you would have a dimmer, and you'd be able to reduce the lumen output or the lux level of the fitting. So an automation system will have the ability to preset and to be able to have the light level in a room at a certain rate, and that will obviously have or be able to be changed over time if needed. We see that from our experience, it's very rare that a home operates under full 100% lumen output from light fixtures. It's usually dialed down, so that in turn will reduce the light spill from the property. And I know that all of the calculations that Jeremy has put into his modelling, everything is at 100%. So that gives that worst case scenario, you could say. But we know that the client will be reducing the output in certain spaces over time.
Thank you. And have you yourself have seen the simulations, the visualizations?
Yes, yes.
And you're comfortable that they represent your understanding of how I wanted to say how the light will behave, but that's not quite the right.
Yeah, it's actually quite it's very much, it's not a this is what it could look like. This is so a Dialux mapping plan uses the file for that particular light fitting. So it is specific to that light fitting in that ceiling space in that location. And so those lux levels and the light spill and how the light is shown in those visuals is intrinsically linked to that light fitting. So it's not a this is what it could look like. This is actually what it does look like from a modelling perspective.
Okay, thank you. That's very helpful. I'll just check if there are any further questions for you.
Yeah, just obviously yourself and Mr. Connon have worked on this together with the eaves, and I note that there was the deep eaves to help lessen that light impact. In the event that there was potentially more light than you anticipated, would there be, what other mitigating factors could you put in place for the light?
So you can in that automation system, you can make a light fitting come on at a reduced rate all the time. So you essentially can dumb it down. So you can make the system say that light fitting should only operate at 40%, 30%, 25%. And so that's the beauty of an automation system and why homes of this caliber tend to have an integrated automation system, so we can be very specific.
Okay, and what about the access way that will lead up? Will that be
the brief was given that there will be minimal to no exterior lighting, because that would impact that visual. Where there are light fittings on plan at the entry point to the home, they will be operated by a timed motion sensor, and that will only come on and for a period of time designated when people approach at night. So these light fittings will not be on all the time. They will only come on when required and for a short period of time.
So will that, on that motion sensor part, will they be triggered by a goat, for argument's sake? Acknowledging that they're going to be predator proof in some parts.
Yeah, I think we'll need a predator fence there. There are like anything sensors, there are a number of them that have different parameters. And I know that for exterior and interior of a home, you can have sensors that don't pick up animals. So it has to be a human form. So that is something that would be specified by the automation suppliers.
Okay, thank you.
Yeah, this is probably a question for you, Barry, more than, but the glazing is low reflectivity. Is that one way or two way? Like, does that mitigate inside light spill to out, or is that just glare from?
Yeah.
I don't know if that's which one of you two. They work together.
It's generally conceived for light
Because
in.
that's LRV.
Yeah, just to lower reflectivity.
There's no component of that for light spill from internal to external with that glazing. Does that have any effect either way?
The glazing we've chosen has an effect on the light spill out. It's a 41% with grey tint in it. So we actually specified the glass to be used and the specific tint, which is modelled in Jeremy's models.
So that's
and also in the lighting conditions as well. I think we specified the exact glass to be used. Yep.
so windy up there. You're not going to be sitting on the balcony with the lights on. Certain of that. There's no need to.
There's no balcony, I think, is there?
Yeah, very little balcony.
You sit inside and you'll be.
Okay, thank you, Mr. Tilley. We have no further questions for you. That's all very clear. Thank you.
Thank you.
Is Mr. Tilley free to go so he can log off and depart the scene?
Yes.
We're happy to get him back again if you have questions that occur to you over lunchtime or whatnot.
That's quite okay. If we do have any further questions, we can let you know, Mr. Page. And yeah.
Thank you. Thank you, Jason. Righty-ho. So next is Mr. Latchford. So Barry, I'm going to invite you to vacate your seat so Charlie can come forward.
Sure.
We can do that.
No. Oh, might as well do it here. We make.
No, you come round. I'll sort that out while you sit down. Thank you. So, Charlie, what I'm going to get you to do is to introduce yourself, and your evidence has 3 appendices, and I want you to explain to the panel what they should take from each of the appendices. Would you mind doing that for us? Thank you very much.
My name's Charlie Latchford. I'm Director of Latchford Surveying. I've been in the district for over 20 years now. So I've been engaged by Mr. Woodward for looking at a couple of things, the surveying, general surveying tasks on the site. That included location where the legal boundaries are, contours, and then also looking at flying the UAV, the drone, over the site that was used for Mr. Condon for his kind of areas to find out where those rock forms or formation is. But predominantly, I've been tasked to look at the geometric roading design from the existing access way all the way up to the property. And I've generally used that existing driveway as the alignment because it's there. It's been there for a reason, and I'm just trying to use that alignment as best I can. I've got a couple of parameters that I need to meet, which is the gradient of the road, the cross-sectional shape of the road. So CODC have standard crossfall dimensions, crossfall grades and widths of the road. And that's what one of my plans show that. And then I've got the batters as well. What are the batters? So first of all, the site, because it's such a large site, was actually flown with a fixed wing plane. And it was from a third-party provider, and they created a point every metre over the site, and I've used that as a basis of the topological maps for my design, and I actually used infill from the UAV for around the building platform. So if you can see on Mr. Condon's drawings, you've kind of got a 3D rendering. It's SK01.
SK01.
It's the 3D rendering from the south view.
Yes.
That's actually from the UAV, and each of those points on the ground actually is actually a physical dot that the surveying device has actually measured, about 100 mils or less apart, probably at that detail, it's probably every 20 or 30 millimeters. And that's where we can get the shape of the actual rocks, those formations. And I use that similar things for the design of the roads. So my first design was using the existing alignments. And it's a very iterative process where I come up with alignment. I've got the start points and end points, and I actually move an alignment. It's got two components, got a horizontal and a vertical part. So I've got the horizontal straight down kind of map. I can move that to the left and right hand side. But as I move that, the vertical side moves up and down. So I can actually go through the process of getting the gradient of the road and balancing those cuts and fills on the uphill and the downhill slope. The best ideal way is trying to get the centre line of the road bang on the middle of the road, so any cuts get pushed out onto any fills on the side. So I've basically spent a considerable amount of time finding a route through from the start to the top. We then marked it out inside for Mr. Rubin for actually working out where the location is. And during that process, there were some landforms like large rocks that I actually had to move around the alignment to get around those large rock formations. And also from ecological views, I had to move the alignment a couple of different times. So that's where I kind of based my original design for. And then subsequently, I was asked to look at an alternative route. Given the size of the property, 300 plus hectares, I managed to find, and I think this one of many, if given more time, I could potentially find other routes. But I found a route from the existing platform that you went through yesterday, the lower one, up through a couple of spurs and over the top to virtually the highest point on the property. And it's come down on the back track. It's a quite a detailed route with a lot of curves and a lot of changes in curves in the area. I also looked at the possibility of going up to the elevation about the same as the building platform and then cutting across, following that contour all the way through the site. But that would have worked, but it would have opened up a very visual cut across the landscape. And so I decided to see if we could go over the top to the back property. Part of the design of the original one, I had to allow for widening for, say, a vehicle of an 8-metre delivery truck. So I've looked at that, and so that's why in the profiles you will see that it's a standard 4.5 metre wide, but I've increased the width of the road to allow for an 8-metre truck to actually navigate any of those type radius curves. And then the third plan that I've actually done is actually a cross-section view of the valley, and it shows a couple of sections through the valley. Based off of the Land Information New Zealand have the 8-metre DEMs, which they got off of the topographical maps, the 20-metre contours. And I've created a couple of cross sections through the valley. And you can see in the middle of that, you've got the lake and you've got some elevations going up through the contours. And also on that last page of that map, I have gone through and used Google Maps and selected or found properties that are visible on Google Maps and also areas I can download that have building platforms and identify those in the maps and with the elevations. That's the, sorry, I'm going through, just one more. I don't know. I don't think it's actually, there's actually the last slide, sorry, there it is, that's that page there.
Okay, so if you're looking at Mr. Latchford's evidence appendix 2, Charlie.
That's the overall map.
The second sheet.
Second sheets, yes, it will be sheet number
2 of 3.
2 of 3. Sorry, I've never done this before, so it's quite nervous for me talking to 10 to the dozen.
So I wouldn't have known. Very well.
So to can see in sheet 2 of 3 is that there's a whole lot of little white boxes on the plan.
Yes, yeah.
Which have got elevations written on them.
Oh.
So Charlie, can you confirm that those are existing buildings?
They are either existing buildings that have come from the Google Earth where I can find them, or I've downloaded approved building platforms that haven't been built yet.
It's for the panel's knowledge. This is attached to Mr. Latchford's statement of evidence.
Sorry.
Yeah. Okay.
Yep.
Okay. Yeah.
Yep.
Sorry.
So yeah, no, so that's how I've come to those locations. So I've got a swathe across the Cromwell Basin, going up to Bendigo and back into Cromwell on both the Bendigo side and the Pisa side of the range.
Okay.
And just so that I'm clear, what is this telling us?
It's just showing you that there are existing buildings at different elevations as you go up through the valley.
Thank you.
The next page shows the sectional view through the valley.
So this is sheet three
Yes.
of Mr. Latchford's appendix 2. And so just to,
Like a heart monitor.
yeah,
It is. Yeah, that's unfortunately that's what I work on regularly, looking at those sectional views.
depending on whether it's billing time or not.
Yeah.
So you can see the cross sections in Mr. Latchford's sheet 1, which are labelled sections 1, 2, 3, 4, and 5. And then if you go to sheet 3, that's the cross-section elevations from those sections. And so, Mr. Letchford, can you confirm that if we are trying to find the elevation of the proposed building platform, the proposed dwelling rather, we're on section 2?
Yes, section 2, and then you can see. Sorry, I've got my glasses on. I've got the right glasses on, but I can't see. You can see the proposed about halfway along there. The proposed dwelling. You can see the elevation at 555.7. And the little crosses through that kind of heartbeat monitor is actually the contour lines as you go through that section. So it actually shows that the building is lower than the mountains behind it.
Yes.
Because that was a question that came up about where it was actually placed within the Bendigo range.
Yes, so, and I think recall that that's a conversation about whether it's in the upper slopes or
Yes.
the middle slopes.
Yes.
Yeah. Thank you. That's very helpful to
Okay, and so just to be sure that we've all been looking at the same plans, if we go to Mr. Latchford's evidence at appendix 1, is this the access that you've designed?
It is.
That complies with the plan's controls?
It does. It's the reference to the alternative access routes. Yes, that is the compliant, and you can see that goes from the bottom of the site where the building platform is and kind of meanders up the site and then goes over virtually the highest point of the site and then comes down onto the original alignments that they're the farm track and then comes down to the south into the building platform.
Can you confirm that from the high point where the track then doglegs to the southwest, at that point you're on an existing farm
Yes,
road?
on the existing farm work as best as I can.
Yeah.
Obviously, I've got to allow for increased radiuses for corners and also a bit of earthworks for the widening because it's only a single track. But yes, it is the existing.
I don't know whether you went there, but that's a perfectly traversable piece of road. If you're going to go back and do another site visit, it's worth driving back up to the top.
Once you're on the top, that top ridge, it just follows the spur line all the way through, and it is generally a flat or an easy track, I would say.
Belong to Matakari Station, I think.
You're not far away from home, but if you do go up there, you come across some really cool old dry stone yards.
Yes.
And they're actually on Bendigo rather than on the applicant's property, but that's kind of on the boundary there. Quite cool to see all the same. At least they are to me anyway. Tracy might have.
And on my evidence, there's actually a plan view that actually shows a rendering of an aerial image and the contours and the actual roadway that goes through to the sites as well.
All right. So that's all I wanted to draw your attention to about those.
Okay. I do have a question for you. In your written evidence, you explain the definition of height and the relevance of that in relation to vertical change and ground level. Are you able to just talk me through the key message here?
You're talking about the batters and the height of the batter. So in part of my evidence, I've actually created a number of cross sections. So it's certain fixed changes as I go through the drawing. I've actually, the computer model has produced the centre line and the extent of the cuts and the fills and the batters. And the model actually produces these cross sections I find on the evidence there.
So we're now on appendix 3.
And if I go to which will be sheet 10 of 17, and it goes on for a number of pages there. Those are the cross-sectional drawings at 20-metre intervals between them. And you'll notice that probably change 660, which is page 12 of 17.
Everyone a moment to catch
Yep,
up.
I'll just catch up to you.
Sorry.
Going paperless is all very well, isn't it?
Yeah, yeah.
It does create a little bit of.
It terrifies the bejeebus out of me, as I'm sure you can see.
Yeah, yeah. I should have
To be quite adept at jumping around, so thank you for your patience.
And don't drop your laptop on the way into the hearing room.
Right, I mean, I'm at page 12 of 17.
Yep, on the right-hand side, the second from the end
Yes.
is change 660. And that's showing potentially the largest cut on the site. And you've got the centerline changes in the offsets, which is from the centerline point, you've got a change positive on the left-hand side and the right-hand side. Well, it depends which way the road goes around the corners. And you will say that you've got some heights there between the existing cuts and the existing levels. And that's just the model has actually produced a height from the original, well, the proposed design to the highest point on the ground.
Yes.
You'll notice that batter is a 1-in-1 batter. But that batter on my plans actually note that could change or could be reduced because of rock. There is, as you know, there's large visible amounts of rock on site. We don't know where the invisible underground rock is. So I've spoke to a geotech engineer who said that potentially if we hit solid rock, we could actually change that batter. It could be much, much steeper from the 1-in-1. It could be kind of going 1.5 or 1-in-1.25 if we find struck rock. Or strike rock.
And what happens in that case?
Then the batter lengths will decrease and the heights will be decreased as well because we'll be butting straight into solid rock. So the actual batters will decrease. We don't know exactly where all that rock is until we start doing some geotech investigation on the site, which will probably be part of the next phase. I'd imagine if this gets approved, we have to go to engineering approval and then we will do detailed investigations on there. I'll get a geotech engineer to give me recommendations on those batters. So when we have the contractor, they will say, hey, we found solid rock, we will do this detail. If we've found broken rock, we will do a different detail.
And is that quite normal practice that detail would be?
Yes.
The level of detail would then be explored at that point?
Yes, because otherwise it's going to be, Ms Hamlin's going to be paying a lot of time for my time for looking at that and then doing investigations before they've got assurance that the resource consent has been approved.
That's quite typical.
Yeah, they're very typical and relate to a property just down towards to Cromwell. Had the same process. They went through it, they did some investigation and they came up with specific details based on the rock and the type of rock. Because, you know, schists could be very solid or it could be broken rock and rotten rock that they would have to do different processes.
Thank you. That's been very useful talking through the technical nature of all of those graphs. Thank you.
It's very, unfortunately, it's very technical shown plans.
No, all very good. Thank you.
So, Charlie, can you confirm that what Appendix 3 shows is the locations of cut and fill that have then been modelled by Jeremy?
Yes, so pages 3, 4 and 5, 6 and 7 are just the cross. So that's a plan view that shows the cuts and fill. So it has the alignment in black of the proposed road. And the areas in red are areas of excessive of over 2 metres of cut. And the areas in green are areas of 2 metres of fill. And my software is a 3-dimensional software, a bit like Mr. London's. I can actually see as part as I'm doing the design, I can see that those batters in the road being created, not to the extent that Mr. London's done his work, but I can do that and see the design. And that's my iterative process. I'm going through the design and I don't want to have huge rate batters and huge rate cuts. And I don't want to go to gullies. So that's part of the iterative design that we go through.
You've answered many of my questions as we've been going through, talking to each plan. So thank you. Do you have any specific questions?
No, just I was really, my question was in relation to the next step process. Given the type of topography that you're dealing with and the ground, essentially, what you can't see is exactly what you're going to find when you look underneath it. So, but Thank you for explaining that, because that's going to be I'd say that's probably about 100% guarantee that you're going to find.
We will find
stuff
rock,
that you-
yes. So I had a drive over with an engineer who's a geotech and a civil engineer for the site, and had advice from him as well for the alignments. And that's his thing of saying, we've pegged out the location. At some point of these biggest cuts, we will go back and have a small digger, and they will test pit that location and come up with detail batters and design.
Charlie, can you confirm if I've understood correctly that what you have shown in terms of better slope size is effectively worst case
Yes,
scenario?
yes.
Because if you strike rock, you can make them smaller.
Yes, I can make them smaller. I can literally go virtually vertically, especially if it's solid rock. They all cut into it vertically. Therefore, the batter lengths longitudinally will decrease, and those heights will decrease as well.
But the reverse is also true, which is that the size of the cuts that Jeremy has modelled are not going to get bigger.
Yeah, exactly.
On this one, didn't you? How'd you work that out?
I did. The short time frame of the alternative design, I think I was given 15, maybe 20 hours. So it's not fully optimized, but I found a route based off that original location to get up on site. Yes, it is a long process. And moving anything left and right affects everything uphill. So I'm chasing my tail, moving things.
The microurban testing, when they were doing their test bits at the top, that's indicative of hitting bedrock at 0.6 to 0.9, their testing stops for most of it. Is that kind of commensurate with what you're expecting? They cut, like, is that going to make a significant?
Where they find rock, that rock will vary all the way across the site.
But it's reasonably shallow.
Yes,
I mean, looking at what you're predicting,
yes.
Your cuts in some places, and looking at where they've stopped their testing, it's not going to be an easy process. I think you walked to that already. You know that, don't you? So that's fine. But it's feasible if that rock was less than a metre. Every point on that road, that is still a feasible track.
Like
Alternative tracks are a better option.
Potentially, but the existing track that goes up to Scapegrace, you can see as that you climb up from the State Highway, and that first big turning, you can see that they found some broken rock through there, and they had to use excavators and rock breakers to break through that. But that was all. That's really fairly common.
Site like that, yeah.
Yes.
But yeah, I was interested. I thought it might be shallower than that, to be fair, to get to 0.9.
You just never know. You could go, and I've put some survey pegs out for, I don't know if they're still there, but for the extents. And I literally think it was ground, and you'd hit the hammer and it will go down 20 mils and you're striking rock. So I can't say categorically the depth of it. That's where the detailed investigation from the geotechs will come through.
But given how shallow it is likely to be, this is permissible. Just bit of work, but it's all achievable with that alternate road.
Yes, but it's virtually double the distance, linear distance, and I will have to. If we had to go to that alternative route, I've still got to optimise it for it. I haven't walked over that site where the first locations I've walked over it, marking those stakes. So I've optimised it left and right. I haven't done that for the alternative route.
In your opinion, in terms of the engineering of that, which is the preferable access?
You following the existing access way is much more. It's a shorter route.
Yeah.
Visually, it won't be a scar as such, because you won't be seeing cars going over the top. I think that's more of a practical route.
Thank you. No, good.
I think. So here we look. The district plan specifies vegetation controls over new matters. The environment up there is severe. Yes. Alex, my personal experience of seeing that it takes a long time for anything to actually establish. If you comment further on that, I mean, we're going to
it's probably outside my expertise, knows what will actually grow back on that kind of those slopes, but some sort of vegetation potentially. But I probably have to pass that to Ruben to say on that.
Yeah, Mr. Morrison will be able to help you with that when he gives us evidence after lunch.
Great. Thank you, Mr. Letchford. Are you around for the rest of the day or are you?
Yeah, I believe so. Yes.
Can be.
Thank you, Paige. Mr. Page, in terms of timing,
Yes.
we were at 12:20. We had scheduled, Aaron had scheduled lunch for us at 12:30. How are we? Perspective.
Well, we're well and truly on schedule from what I was anticipating. The next witness is Mr. London's evidence, which is largely formal insofar as he produces the 3D visual simulations. So that could either be quick or slow, depending on how many questions you might have for him.
Be good to get everything else out there patiently. Okay, let's proceed.
Should we crack on?
Yes, thank you.
All right. Good morning, Jeremy. Thank you for joining us. Would you like to introduce yourself and address your evidence, please?
Hello. Can everybody hear me okay?
Yes, clearly. Thank
Excellent. Great. So I'm Jeremy London. I am a qualified landscape architect practicing since 2008. And for the latter part of this period, I've specialized in 3D modeling, visual simulations, visualization, handling of geographic data, and so on, specific to our work as landscape architects. My role in this project has been to collate the project information provided by the various consultants, including Condon Scott Architects, Rough Mill Mitchell Landscape Architects, Latchford Surveying, Restore NZ, and ECC Lighting, and develop a unified one-to-one scale 3D model of the entire proposal, and to place that model accurately with the assistance of Latchford Surveying into panoramic photographs that represent the view that would be experienced from a set of predetermined viewpoints identified by Rough Mill and Mitchell. So the first step in my work was to head down to site, and I met Charlie Latchford on site. He accompanied me during my field work, where we located the viewpoints identified by Paul Smith that were to have visual simulations generated. And those viewpoints were viewpoint 3, which these numbers will be referred to in Mr. Smith's evidence later on. I should share my screen at this point. Do I need that to be activated at your end? Because the share button appears to be grayed out for me at the moment.
Thank you. We're just checking at this end.
Okay.
While you are checking at that end, I have prints at A3 of Mr. London's Appendix 1 that I can see some of you already have A3 prints, but not all of that.
Thank you.
Now, Jeremy, it should allow you to share screen now.
Excellent.
Thank you very much. Holy moly.
Yeah, but wait, there's more.
You built your house out of paper.
Thank you.
That's question.
So, Jeremy, the panel now have A3 prints of your Appendix 1. So they should be able to follow you along in paper as well as on screen.
Excellent. Okay. So the viewpoints that I have taken panoramic photos from are shown on page 7 of the appendix, of my Appendix 1.
Thank you. Yes.
And these viewpoints, as I mentioned, were advised by Paul Smith. So viewpoint 3 being the northernmost viewpoint on the western side of Lake Dunstan, progressing south to viewpoint 9, and then east to the margin of Lake Dunstan to viewpoint 10. These 3 viewpoints are presented in order as being the 3 viewpoints that actually have a visual line of sight to the house, the proposed dwelling itself. The order of my pages and images then progresses to viewpoint 7 and viewpoint 14, seen in the southern region of the viewpoint map. These viewpoints, I understand, were selected to represent views, potential views of the driveway, and the view sheds from those 2 viewpoints don't include the house, the proposed dwelling site at all. So you'll see in my appendix that things generally go in the order of viewpoint 3, viewpoint 9, viewpoint 10, then they go back to viewpoint 7 before progressing to viewpoint 14. So from each of these viewpoints, I set up a panoramic tripod which rotates the camera in such a way that it produces a seamless, accurate, and visually correct panorama from each of these viewpoints. The panoramas are presented in a 124 horizontal field of view by 55-degree vertical field of view, which is described in the New Zealand Institute of Landscape Architects Best Practice Guide on Visual Simulations, Best Practice Guide 10.2, is described as a typical primary human field of view. So the field of view that, of course, there being variation in everybody's optics, hence the existence of glasses, but the typical field of view that one has before you get to the blurred extremities of your vision. So these photographs are taken on site. Charlie Latchford on this occasion was there with me, and so he verified the geographic coordinates of both my camera position for each of these viewpoints and also the foreground camera control points that are used for the alignment of the alignment and the camera matching of the 3D model to the real world. And so if we jump over to, sorry, we revert back to pages 4 through to 7 of my appendix, you'll see each one of the daytime panoramas marked up with the camera control points that are used for the alignment of the virtual camera within the virtual 3D environment where the 3D model is handled. These control points are used to effectively recreate the real world position of the camera where the panorama was taken. It creates a corresponding virtual camera within a virtual 3D environment so that anything modeled and captured by that virtual camera can then be placed accurately within the photograph. I hope that makes sense.
Thank you.
And so,
Yes.
and so in each of these photographs, you'll see, for example, on page 4, viewpoint 3, you will see camera control points in the foreground. I will switch my cursor over to the hand so you can, the pan tool, so you can see more. Can you see on the screen where I'm gesturing with the?
Yes.
So here we have nearby control points on the tops of posts on the vineyard, just on the other side of the fence, top of a fence post here, another fence post, a cat's eye on the road, another cat's eye on the road. And then you'll also see in each of these images, there are more distant viewpoints. These are located on the application site itself. And so the foreground points near where the camera was were captured by Latchford Surveying at the time that I took the photographs. So page 4, we see viewpoint 3 and viewpoint 9, progressing to viewpoint 10, viewpoint 7, and on the final page, viewpoint 14. So Latchford Surveying captured the control point, the geographic coordinates of the foreground control points at the time of the photography. And each of these photographs was subsequently marked up and accompanied by a map and supplied to Latchford Surveying to provide me with the camera control points for matching the more distant control points that were also used in conjunction, such as the ones you see here. Several picked up on the other side of Lake Dunstan, not on the property. So all of these control points are used for the alignment of the virtual camera, which allows the position of the model to be placed in the photograph with a survey level of accuracy. And so the difference there being that my understanding of the architectural render that you were shown earlier, and most instances of a architectural model being placed in a photograph, that is, I understand that was done to some degree by eye, whereas the process we have here is one which relies on a survey level of accuracy to align these cameras. Following the alignment of the camera, the 3D model of the proposed architecture is received from Condon Scott, and materials applied to it in accordance with the architectural documentation. Predominant materials that were visible from the external views were the concrete walls, timber cladding, tinted glass glazing, and a basement level with a clad in stonework. The driveway design was received from Latchford Surveying, which was then applied to a terrain model, and the batter slopes were feathered into existing ground in accordance with the documentation provided by Latchford Surveying. The landscape architectural plan depicting areas of proposed revegetation was then draped over a terrain model. The proposed planting specified by Restore NZ was scattered at the specified spacings over those areas. The species were modelled to the anticipated height and spread of each species, also advised by Restore NZ, and a predator-proof fence, which was modelled based on examples found on this website, was also draped over the terrain model following the alignment shown in Ruffmell Mitchell's landscape plans. This is a close-up view of what that predator fence might look like. So these are the components that are collectively depicted in these images. I should actually add that following the photography, the daytime photography accompanied by Latchford Surveying, I returned to each of the viewpoints 3, 9 and 10, each viewpoint that has a line of sight to the property. I returned to these locations and took nighttime panoramas. This was done in November, so the the photography was done between 10 p.m. and 2 a.m. to capture complete darkness. And those panoramas were then the resulting nighttime panoramas, which were effectively complete darkness apart from artificial light, the stars in the sky, and a faintly visible ridgeline. Those panoramas were constructed and then overlaid precisely on the daytime panoramas so that the camera matching could be right on for both the daytime and the nighttime. And the architectural model, added to the architectural model was the lighting specified by ECC using the photometric files that Jason Tilley described earlier, whereby every commercially available light fixture has a photometric data file accompanying it, which technically describes the exact throw pattern of each light fixture and its maximum intensity. And so for every light fixture that this data was available for, the photometric file was placed in the location specified in the lighting plan, and the brightness of each fixture was driven by the data contained in the photometric file itself. In addition, there were a number of bespoke and artisan light fixtures specified on the lighting plan, and those that didn't have a photometric file were modeled to the specified as a generic light source to the specified luminosity from each of those lighting suppliers. The glazing on the external glazing on the building was also modeled with an opacity based on data provided on that particular product. I'll just have to switch back to my methodology statement, which confirms that the glazing product is referred to as Solus Ultra Plus Grey, which has a visible light transmission value of 41%, as advised by the supplier of that glass. And so that was modelled in the 3D modelling program. That level of transparency was modelled for the glazing. And so with the entire proposal developed into this 3D model, the image from each virtual camera is then what is referred to as rendered, whereby the software calculates the illumination from the daylight and its interaction with every material in that 3D model, including the building materials, the plants, the ground surfacing and the like. And so it performs a physical calculation based on real-world physics of how light interacts with surfaces and materials and passes through transparent materials and so on. And it generates a rendered image of the model of the proposal, which is then overlaid onto the photograph to produce the after image, if you like, the proposed image as opposed to the existing, and that then allows the two images to be compared, the before and the after. And so, would you like me to work through these images on screen, one by one? Or at this stage, does anybody have any questions?
I'm going to suggest that we do work through the images. They are of critical importance, not only to understand what Jeremy has done, but also to understand Paul's evidence. So I think we need to spend some time on this. Do you want to take the lunch break before we embark on those? Because this might take us a little while.
Idea. It's a good place to break. Thank you. So everyone online, we're going to take a lunch break now and we'll resume with this presentation, Mr. London's work when we come back.
12:30 till 1.
Should we say back at 1:15? We'll just take a short 5 minutes. 1:15.
Okay. Just making sure that Mr. London is back online and with us. It looks like he is.
I am. Is my audio coming through okay?
Loud and clear.
Excellent.
Thank you. We'll resume the hearing and hear from you further. Thank you.
Okay, so moving to the actual images, I think it would be helpful to look at viewpoint 9 and viewpoint 10 first of all, the two nearest viewpoints to the dwelling that have a line of sight to it. And from there, one can make more sense of what they're seeing from the more distant viewpoint 3. So on screen now is viewpoint 9, that is on page 16 of Appendix 1. And what you're looking at here is the full 124 degree by 55 degree panorama, which represents the primary human field of view. And to get an accurate sense of the scale, this image would have to fill that field of view. So as noted at the top of the screen, this can be achieved by printing it or displaying it at about 1.5 meters wide and standing about 400 millimeters away from the image. Obviously, you're seeing that much smaller in the A3 document that you're looking at and at the distance that you might be viewing your screen. And so in this situation, the full panorama image that you're looking at is useful as a reference for the portion of that field of view that you will subsequently be looking at on the next few pages. And you can see above the image that there is the second line of text, and the reference line next to it shows you the portion of the full view that you'll see standing at this position on site that we are shortly going to be looking at zoomed in. So page 16, this is the existing view. Jumping over to page 17, you'll see the corresponding proposed view. So this is I'm just going to, there we go. My screen's refreshed now, so I can flick between 16 and 17 seamlessly. And if you're looking on screen and watching what I'm doing, you'll see between about where the cursor is now and where it is now, that's the area in which the visual change resulting from the proposal is contained within. And keep in mind that the visual change that we are seeing in these images is not limited to the dwelling itself. It also includes the modelled vegetation, so the revegetation scheme proposed as part of this consent application. Following on from the daytime view, page 18 and 19 show the existing and proposed nighttime views, which we will come back to. And then over on page 20 and 21, you will see a zoomed in cropped portion of the panorama, which, as noted above the panorama, represents just a small part of that view that you'll see. And this image here is specifically sized so that it can be printed and viewed on an A3 page at a distance of 500 millimeters from the eye, so half a meter away from your face if you were to hold an A3, this image has been cropped and scaled to give you a as accurate representation as possible of the scale of what you will actually see standing on site. So in this image, I'm showing the existing image on screen at the moment. About 1/3 of the screen width from the left margin. The dwelling proposal site is located on the, I guess you could call it the foreground ridgeline.
Jeremy, just confirm that you're now on sheet number 21.
I'm on sheet number 21.
Yes, and so that's the simulation. So the building is actually simulated into that image.
Yes, it is. That's correct.
And
And
could you mark?
Sorry, go ahead, Phil.
Yes, so you were doing that anyway, but just to confirm, can you circle where the house site is with your cursor so that the panel can see where to look on their printed version?
Yes, indeed. So I'm holding the cursor on the screen just below the house site right now.
Good, thank you. So that's, if you look at the top of the page where it says print, it's vertically directly below the letter P of print. We find the house site. Thank you.
That's correct. And if you're looking at the screen, I am alternating between, so I'm showing the existing view, unaltered view now, and I've just switched the proposed view. And so the dwelling is basically a small dark smudge just above the cursor, the hand cursor in my image. So once again, I will flick to the existing view and the proposed view. You will have noticed that there are visual changes occurring to the left and to the right of this location over a larger area of the hillside. And it's important to note that these visual changes are predominantly the depicted revegetation scheme, as well as a couple of very short sections of the proposed driveway.
And just to further below where you've got your cursor on sheet 21 at the moment, there's a black horizontal line in the tops of the line of trees that we can see.
Yes.
Is that the scapegrace building?
I will zoom in and have a look. It is there somewhere. I just couldn't be certain. Yes, it is. The scapegrace building is just sort of half hidden by the tree line there.
And the importance of identifying the scapegrace building in that image, because when we come to the nighttime views, is the scapegrace building's lights modelled in the nighttime views, so that we can see the relative position of what's shown in the nighttime views.
Well, I should clarify that the scapegrace lighting appears in the photographs of the nighttime views, as opposed to having been modelled.
Yes, thank you.
So yes, this is existing and proposed. And keeping in mind that the image we're looking at here is just one portion of the full image that you will perceive from viewpoint 9. And within this cropped version, this cropped portion of that view, the building is the proposed building itself is limited to that small dark patch just above my cursor on the screen.
Is it worth pointing out the consented platform? So that's if you go down Scapegrace's thing, there's a transmission tower, and it's just on the very top of the transmission tower to the left on the grassy patch. So go up, Jeremy.
Just to here, isn't it?
Up and left a little bit more. Yeah, around there. That would be the consented platform. Up a little bit higher. In that grassy knoll, yeah.
Thank you.
Would you like to switch over to nighttime views at this stage, or progress to the viewpoint 10 daytime views?
I think while we're on viewpoint 9, let's have a look at the nighttime, and so you can identify what we've just shown in the existing image as the scapegrace lights, and then in the simulation identify for the panel the proposed building?
Certainly. So switching over to the nighttime view, this is the existing view taken from exactly the same spot. And these are the lights somewhat filtered through the trees, the treetops that you could see in the daytime image just there. This is the external lighting of the scapegrace building. And this image shown on the screen now, which is page 23 on the printed appendix, shows the modeled lighting of the nighttime lighting of the proposal. The important thing to keep in mind here is that all of the light fixtures specified in the ECC lighting plan are displayed, are shown at 100% brightness in this image.
No blind filtering, is that?
Sorry?
And that's one of the statements in the notes where I says that the blinds are down on the northern facing bedrooms in the study, but this is without.
No, this is this is with the lights. Sorry, this is with the blinds closed, but with all the lights in the building within the 3D model turned on at their full brightness. So
just to be clear, which blinds are closed, Jeremy, just so we don't get confused?
So the blinds in all of the bedrooms, including the master bedroom and guest bedroom 1, 2, and 3, and the study.
Point 13 says that. So is there a visual simulation of those lights on without blinds down?
No, that wasn't requested. As my understanding is that the blinds, I'm sorry, are automated to close upon sunset or upon dusk, and that there's two understandings I have of the lighting proposal. One is that the blinds will close before darkness in all of those bedrooms, and also that after 10 p.m. the interior lighting, or all of the lighting, will be limited to 30% of its maximum. So what we see in the nighttime image here is the potential scenario whereby all lights in the building, and including the motor court and the entrance, are at their full brightness, so prior to 10 p.m. But after, during the hours of darkness when the blinds are completely drawn, so the blackout blinds and all of those north-facing bedrooms are in the closed position.
Just to be clear then, there are no blinds shown in the simulation from the living, dining, kitchen area.
That's correct. There's the blinds are only shown in the bedrooms, the north-facing bedrooms, and the study.
Okay.
You might notice if you look closely at this image that there is a main area of illumination visible in the proposed building, and then there's a faint glow to the left of that, separated by a patch of darkness. That faint glow is the light cast onto the landform that was picked up by Charlie Latchford's drone survey. So we have a fairly detailed three-dimensional representation of the rocks and the landform around the building in its immediate vicinity. And that faint glow you see to the left of the primary illuminated area is the lighting from the driveway and from the garage doors in the open position, allowing light from in the garage to spill out and illuminate the adjacent landform. So this, every light fixture in the entire building is shown casting the maximum possible amount of illumination onto the out into the landscape and onto the surrounding landform.
Thank you. Can we move on to visualization 10, viewpoint 10, please?
Certainly. So this is the daytime view, the full panorama from viewpoint 10 on the margin of Lake Dunstan. Once again, the horizontal line that I'm tracing with the cursor at the moment marks the portion of the full view that you will experience standing in the spot on site that is represented on the subsequent zoomed in pages. So just quickly showing, I'll allow both images to refresh on my screen, and then you can flick between them. So this is the existing view, the daytime existing view, full panorama from viewpoint 10, and this is the proposed view. So at this distance, the change is very subtle, as you can see. The most obvious change is actually the appearance of the revegetation and batter slope planting adjacent to the driveway, which appears just under where my cursor is sitting. I will flip from one to the other there. As far as the proposal site goes, I'm going to need to zoom in and orient myself just for a moment. This is actually going to be more easily done by returning to this image, having looked at the zoomed in version.
Or should we go to that then, if that's easier to identify the building platform?
That's right.
That's sheet 28.
That's so on sheet 28, the building platform is right here above the cursor. So we are seeing in the zoomed in cropped portion of the image, just on page 28, just above the cursor here, that's existing. And then the proposed, that small dark horizontal patch just above the cursor, that represents the building.
Okay.
So having sorry, go ahead, Phil.
So can we go back to 28?
Yes, certainly.
Just to orient ourselves, can we see the Scapegrace Distillery building in that image as well?
Yes, that's the Scapegrace building.
Thank you.
Above my cursor right there. So pretty much center of the image.
And can you identify where the consented building platform is in that image, or
I understand that it's in the vicinity of where my cursor is.
Yeah, on top of that, just go 1 centimetre up. You're right.
There we go.
Joe was saying, you can see the access way that you drove up, and you can see the scar base photograph just to the slightly up and to the left of the Scapegrace building. You drove to get to that consented building platform. I used that as my wayfinding point. That sort of took me up to the top of there's a small sort of knoll of vegetation that sits just on that. Sorry for cutting across here.
Yep. Now, can we do the same exercise with sheet 29, which is the simulation?
Yes, here we go. So this is existing view, this is proposed view, and the proposed dwelling sits between these two. Well, there's 3 visible rock outcrops in this area. So existing and proposed just above my cursor. Again, you will see visual change occurring over a wider area of the hillside here, and that is the revegetation scheme and driveway batter slope planting.
Yep. And our viewing distance to the site, according to sheet 24, is 3.8 kilometres. Is that about right?
That's correct, yes. So having identified that location in view in page 28, returning to page 24, the house site is approximately over my cursor, above where my cursor sits right now.
Can you just confirm, sorry, can you just confirm that when, with regards to the plant, because obviously there's a significance in planting, that's at fully mature, is that on the basis of a fully mature plant?
In these images, it's based on 10 years of growth, with the plant size at that age advised by Restore NZ. I recall that Restore NZ noted that it was fairly close spacing for the planting of these areas of 1.5 metres on centre, with the intent that the that density will assist in plant establishment. So you're seeing quite a dense planting of the specified species there. So switching in this view, shown on screen, switching from the existing view to the proposed view, the building, pretty difficult to make out at this distance, but it occurs just here above this dark mass of hillside vegetation. Particularly difficult to spot because it is visually continuous with that vegetation. Again, we've got the panoramic view of the existing and proposed nighttime shots. Once again, the horizontal line above the image here marks the portion of this view seen from viewpoint 10 that is represented in the nighttime shot here. So once again, this image is scaled so that printed on an A3 page, viewed at a distance of about 500 millimeters from the eye, this represents the same portion of what you would be seeing on site. So here from viewpoint 10, you can see the scapegrace existing nighttime lighting. And on corresponding page 31, you see the simulated lighting of the proposed dwelling. Once again, all north-facing bedrooms and the study have the blinds in the closed position. All interior lights are switched on, and all internal and external opaque doors that would otherwise prevent light from passing through are in the open position. Hence, once again, the faint glow of illumination to the left of the main building lights, representing that glow that would occur onto the hillside. And from what was described earlier today, I understand that would be some of that lighting is motion activated, so it would only be on for a brief period. But this image captures that moment where the garage doors open, the interior lights in the garage are on, the driveway lights are on, and they're casting that glow onto the slope beside the house. Any questions there?
Yeah, I have one. Have you been asked to model the site after development, but before plant maturity?
I haven't been asked to generate visual simulations depicting that for the viewpoints 3, 9, and 10. But for viewpoint 7 and viewpoint 14, which concern views towards the driveway, I have modelled I have produced visual simulations that show the planting immediately after planting, where the planting is simply represented by plant protection sleeves, and then at 5 years of age and 10 years of age. At this point, would you like to progress to the viewpoints looking towards the driveway?
Thank you. Just before we do move on to the driveway, I just wanted to check the kilometre distances from each viewpoint.
Certainly. So from
So-
viewpoint, go ahead.
So viewpoint 3, the kilometre distance to proposed dwelling.
So the distance from viewpoint 3 to the to the dwelling is 7.2 kilometres.
Thank you. I think I got 9, which then was 2.6. Is that right?
Yes, I'll just double check those.
Little white box
But
down
the-
there. What the distance.
So yes, 4.5 kilometres from viewpoint 9 to the dwelling site.
That's it.
And viewpoint 10 is 3.8 kilometres to the dwelling site.
Thank you. Right, we can proceed now to the driveway. Yes,
Excellent.
thank you.
So viewpoint 7 here on the west side of Lake Dunstan. Once again, we're looking at the full panorama, representing everything you'll see standing on the spot where the photograph was taken. The portion of this view represented in the zoomed in images is marked here on the towards the left of the center of the screen on this this time. And we're at a distance with this one. We're once again viewing the full panorama on screen. It's very difficult to make out much change at all. There's shifting between the existing and the proposed. Here we do have planting shown at 0 years growth. What you do still see, however, on the surface, on the land surface where the proposed planting is a slight change in tone, because the recommended root protection sleeves in the ecological report have been scattered across the land at 1.5 metres on centre, corresponding to the plant positions. So for this picture, we have an existing view. We have a proposed view at time of planting. We have a proposed view after 5 years of plant growth, and we have a proposed view after 10 years of plant growth. So now that those images have loaded onto my screen, I can flick between them seamlessly. That's existing, proposed at 0 years, 5 years, and 10 years. Moving on to the cropped inversion portion of that image. So this is the one where an A3 displayed at A3 at about 500 millimeters from the eye. You're seeing it at approximately its true scale. This is the existing view, and the nearest point on the driveway is visible. I'll switch over to the pan cursor over here on the right. This is the nearest point on the driveway. So it's slightly difficult to distinguish foreground landform from the landform of the site right here because of the similar color, but my cursor on screen is currently tracing the foreground landform that exists between the viewpoint and the property. If I switch now to the proposed view, you'll see a portion of the proposed driveway curving up and arcing around to the left on this piece of land, and then the driveway reappears and makes a similar movement, ascending up to the right and curving round to the left out of sight. So once again, existing and proposed. What you're also seeing just above this rock outcrop, beyond it, is the extent of the batter slope in its, I guess, freshly excavated form, where you're seeing the bare sandy coloured rock that forms the hillside in this area. Now over here in these two gullies, you do see a change from existing to proposed at time of planting, and that total change that you see in these two gullies is the result of those root protection sleeves scattered at 1.5 metre centres over the entire area. So you're seeing a bit of a tonal shift on the land there. Also, just above my cursor, there is another small portion of the driveway which becomes visible following its modification as described in Latchford Surveying's documentation. So just above the cursor, existing, and then proposed, you see another short section of the road. Moving on to the 5 years of growth and the 10 years of growth, you see the anticipated development of those planting areas, keeping in mind that by their very nature, the visual simulations don't depict the natural growth and development of other vegetation in the image. So in some sense, what you're not seeing is the degree to which all of the land which is afforded protection by the proposed predator fencing will have potentially also developed over those 10 years and potentially spread and increased in height as well. So it's an important thing to note when looking at these predicted growth representations of revegetation, is in reality you'll likely also see change to those areas that aren't being specifically planted and managed in the same way. Any questions about this set of images?
So based on the data that you've used,
Yes.
and this is on map number 39, you're saying that the driveway will be completely shielded by year 10.
By year 10, what these visual results are telling us is that the actual surface of the driveway will be more or less obscured. There appears to be a small portion of it here on the right-hand side, just above where my cursor is, which based on the earthworks depicted to achieve these driveways, there would appear to be a small portion of the driveway right on the right-hand side there above the hand, that because there is no batter slope required to achieve that particular section of the road, the landscape plan doesn't currently show planting there, which would obscure the surface of the driveway. But the visual results suggested by these images do indicate that those portions of the majority of those portions of the road that will be visible from viewpoint 7 upon completion of the road will subsequently be obscured by the planting in the long run.
This is all based on the existing. So this is the what was in red, Charlie, on your, is that correct? If the one that you annotated as purple was the alternative, is there any change on these? I'm assuming that's the lowest, like we can see so clearly in that 5 year. Is there any change to that path that low down, or is it?
Jeremy hasn't actually done any modelling on the alternative path. So I can't say that, and I think the alternative path is further south as we're looking at it on the left-hand side, as you can see, Scapegrace. Oh, Scapegrace is here, so I get Scapegrace. I think you'll find it's that gully around to the side.
It goes that way.
Yes.
Thank you.
In relation to that.
Yes, it's fine.
I just have a question for you, Mr. Hamlin, just while we're talking about this. Given this is a rural piece of land and there clearly is farm tracks over all of, over the whole site and also the surrounding areas, was there any, I guess, concept of keeping it as a, not as a, obviously as your driveway, but as a track, so it was still visible as opposed to planting?
We sort of wanted to integrate it into our restoration of the property.
That's all right. I was just asking to see to see if it was going to be maintained as a purely rural character or if it was going to be. Thank you.
What I can say, Commissioner Patterson, is that's entirely a matter within your control. If the panel forms a view that it would rather not be vegetated because that looks less like a traditional farm track, then that's a decision that you can make.
Shall we take a look at viewpoint 14?
Thank you.
So viewpoint 14 is right at the foot of the proposed, or the existing track, which is proposed to be modified into the driveway. And this is probably most useful to depict at a much closer distance, at a much shorter distance, what it was that you were seeing in the previous images in regard to the driveway. So once again, full panorama, 124-degree horizontal field of view. So this horizontal line represents the portion of what you would see on site that we're looking at in the coming images. First of all, I can show you the full panoramas. We're close enough to the proposed change that it's actually worth looking at these. So this is the existing view. This is the proposed view based on the received driveway design. And at this distance, you can actually see that in this view, which depicts the planting having just occurred at 0 years of growth, the majority of the specified species are only a few hundred millimeters tall, and they're completely contained within these what are referred to as tri-guard, 600 millimeter high triangular plastic protection sleeves held underground with a stake to give these plants the best chance of establishment in an area that I understand is prone to pests. So those are the plant protection sleeves scattered at the specified spacings of the plants themselves. These are the specified plants at their anticipated size after 5 years of growth, and again after 10 years of growth. The species mix specified by Restore NZ is scattered at random over the over the entire surface of the area marked for planting. Here we have the centre portion for a closer view. That is the proposed at 0 years of planting. And you can see that the batter slope doesn't occur all the way along every portion of the driveway. And in some cases, it is so close to existing ground that there isn't a resulting batter slope generated by the driveway engineering design to be planted, to be included in the proposed batter planting. So just to clarify what I was referring to earlier when I described a portion of the driveway, excuse me, that may not be obscured by the planting that we are proposing. It's simply because that portion of the driveway didn't require a batter slope and therefore didn't fall in the category of driveway batter planting currently shown on the planting proposal. Here are those plants at 5 years anticipated growth, and then at 10 years anticipated growth. So hopefully having an opportunity to see this up close helps to frame what was being presented in the more distant views that you've seen previously.
Jeremy, while we're looking at image 45,
yes,
the digital representation of the surface of the driveway looks absolutely pristine. Is that how you actually expect it to look?
That's what I expect the general colour and tone of the surface to look based on observation of what you see in the foreground on the right here. It's based on the general tone and colour of the raw material that the earth is made up of here, immediately following disturbance, which will occur when that earth is moved around.
Would you expect over time weed and grass growth to occur amongst the surface of the driveway?
On the surface of the driveway itself?
Yes, that's what I'm getting at.
Oh, I'm sorry, I misinterpreted what you were saying as referring to the surface of the batter slopes.
So I'm talking about the driveway. It kind of looks like concrete in the image. That's what's, I think, perhaps alarming Commissioner Patterson.
Yeah, it's
a lot of concrete.
If we go back to this, if we go back to these images, you can see that let's look at the existing image. So this is the existing general tone and color of the I guess is it referred to as Bendigo Downs Drive, the internal road that passes across in front of the site here?
It's an internal subdivisional road that has been finished. Some of it's chip seal. This portion we can see is chip seal. As it goes past the batters, it's just the excess chip being pushed out. And then as we climb up the hills, it's just back to the native kind of ground. So I'm expecting that the top surface be an AP20 and AP40 surface, which will be more browner than that being a coloured grey.
As opposed to it being concrete like, and I accept that there is there's a condition in the consent that it says it's unsealed, so it
will be, I've got advice from a geotech and pavement engineer, that for safety it will be a gravelled surface, not a concrete surface or an asphalt surface.
And I should clarify that what I was attempting to depict in this image was a continuation of this stone, this loose stone surface continuing on up the slope, as the simulated surface representing the same unsealed rock recedes away from the camera, the detail does diminish. And so if one spent a lot of extra time, one could introduce more natural variation and undulation in the surface to perhaps more accurately depict the the irregular stony nature of the surface, but the overall color and tone of the driveway is based on a continuation of this surface. So it's not intended to represent concrete, but I can see how it could have been interpreted to do so.
Mr. London, I had a question around the planting projections.
Yes.
And obviously you described to us the methodology with all the different inputs and overlays that you went through and you were, in a systematic way.
Yes.
Where did I just want to understand where the growth plant predictions have come from, the reference for that. Has that come from the applicant's ecologist?
Yes. At my request, the ecologist provided a complete species list, which included anticipated plant height at 5 years and 10 years of growth, and those values were set for each species. The scattering, the digital distribution of the plants over the surface is done, included in that. I introduce a 10% variation in width and height, just to avoid a artificial looking regular, to break it up and give it a natural variance that could be expected, which helps in the naturalistic appearance of it. What can happen if you scatter the same plant of exactly the same size over an area digitally is that it gives an artificial regularity to it that can detract from the message of the image. So there is a 10% variance in size of each species as the plants are scattered across the terrain.
Thank you.
Right, but it's not concrete.
Yeah.
You'd have to own Monsanto to keep it looking like that.
Is that the end of your presentation, Mr. London?
It's the end of what I had lined up to cover, but I can go back and present and clarify anything that you might wish to revisit.
Thank you. It's been very, very helpful having you talk through the how to apply those images and what we are specifically looking for. We had a good go yesterday, but today it's a few aspects that are clearer to us now. Thank you. Do we have any further questions on Mr. London? No. Happy? That's what explains things. Okay, we're all happy. No further questions of clarification for you at this point. Thank you very much for your time today.
No problem. Thank you.
Thanks, Jeremy. So now we come to the evaluative part of that evidence, taking that and plugging that into an assessment framework, and that's what Paul's done. And so, Paul, I'd like you to introduce yourself and present a summary of your evidence.
Good afternoon. My name's Paul Smith. I'm Senior Landscape Architect at RMF. Mr. Page is going to just provide you with a copy of my graphic document in a paper format. It's been printed out in A3. It's an extra copy.
I promise you, leave it up.
Famous last words.
Yeah.
Thank you.
Thank you.
It's not.
You've you set yourselves up with all the paper on the desks. I'm glad I was the only one who had to print stuff out for today. I really will provide most of it. But yeah, I wasn't looked upon kindly in the office. I've been working in Central Otago and in the Queenstown Lakes District, whilst I don't live here anymore, for the last 14 years, since finishing at university quite some time ago now. Being that I worked for Vivian Espy, I've worked for Becca, and now working for RMM, where I've been for the last coming up 7 years. Been engaged by Mr. Hamlin for the last two and a half years working on this project. We were engaged from the very outset to assist with locating the dwelling and the design and how we can integrate a better designed dwelling onto the site that could be more nestled into the landscape. But before I get into my evidence, I do have to say that there is an error in my evidence. So I want to draw your attention to that. And this is something I picked up on site yesterday. And this is something that you said that you were briefly on site yesterday, and it was pretty poor condition. So I'm not sure if you would have noticed, because we were up there for a much longer period of time. And it was only the second time I'd been up there, because everywhere else, when I was doing site visits, was more focused back towards the site. But the thing that I did notice was that I'm incorrect in saying that the proposed dwelling is not visible from State Highway 8. I apologise for that. Can I draw you to sheet 30 in my graphic document? If I go there, if you sheet 30. Sheet 30 shows a ZTV map based on 8-metre DEM data from the current building platform location. When you look when you look north of the small red dot, you've got the State Highway 8 sign on State Highway 8, and then you can see two sections of red located on top of the orange highway line. Now, when I was on site yesterday, I was standing around the centre, and I could see those two stretches of road. And so therefore, like line of sight looking back down, I could see those two little bits. They're actually at the bottom of a large bluff. And so after doing that site visit, I went back down to the state highway. I had to go to the Bendigo toilets and then turn around there to come back, and there's a nice pullover area at the very bottom of the bluff. It's nice and wide and super safe to pull over on. Had to awkwardly cross the road and stand on the downhill slope beyond the barrier and then look back. And standing there for quite some time, I was able to depict the large outcrop, which identifies that the large outcrop at the southern end of the dwelling jut into. So based on what I saw on site on State Highway 8 yesterday, does mean that the front facade will be visible as you travel along the 200-metre stretch of State Highway 8 there. You do a slight dip, and then there's another 100-metre stretch there or thereabouts where you'll see it from again.
Are you looking for it?
You do have to be looking for it. It is right up on the skyline, and so there will be, similar to viewpoint 10, there'll be a very small breach of the skyline either side of that of the rock outcrop.
Were you able to scale off a topo map how far you were from the building site at that point?
Yeah, so we scaled off a topo map on site, but then I also double checked it back on Google Earth when I was back in the office, in the hotel room, and it was 4.1 kilometres from the initial bluff to the dwelling location. And when you do see it, you're travelling around that bluff at about 90 to 100 kilometres an hour. And from my experience driving that stretch of road, my eye's never really been drawn upward towards that ridge line. It's usually drawn out towards the lake. If I'm driving, I'm focused on the road, or if I'm looking out towards the Pisa Range, Pisa Moorings.
the section on that map directly to the right at the end of Lake Dunstan, where that looks like it crosses over a reasonable portion that's almost a north-south orientation of the road there. Is that also a viewing corridor there? Used to be that the trees.
Oh, is it? Oh, so what, the stretch below the State Highway 8 sign on sheet 30?
Yeah,
that's
comes back round in the kind
No,
of
you-
south direction.
No, you can't see it from there.
So that's not it.
No, you don't see it from there.
But this is the ZTV plan for the original approved building platform, not the proposed one.
Yeah.
Yeah.
Do have a lot of plans in front of me. We all do. The note I had down here was, there's a dwelling on, as you're travelling away from Cromwell, there's a dwelling on the left-hand side, on the Lake Dunstan side, and there's a small driveway that cuts back on itself. It's just after there.
Yeah.
But again, you have to be travelling south to see it. So when I was looking at this last night or yesterday afternoon after being out on site again, due to the distance, the travelling speed, the brevity of the view and the dark recessive appearance of the dwelling that was set up there, I do not consider that it will be prominent. It won't be prominent to the point that it won't draw the eye. And therefore the effects on road users travelling along that stretch of road will be very low to low. So when you look at my evidence and it says that it's not visible, it is. The other thing that we did focus on when I was on that stretch of road, we were able to identify the existing building platform location as well, which is also visible from the same vantage point.
And in terms of existing building platform location, in terms of looking upwards or across, is that obviously it wouldn't be quite as high as
it's not as high. It's having a look at the photos that Jeremy was running us through earlier. When you look at viewpoint 9 and 10, the key thing to look at is Scapegrace has this if you run a horizontal line across from Scapegrace, the existing building platform sits halfway between Scapegrace and the Sean, so it's slightly lower down.
Thank you.
I did have an order that I was going to run you through the graphic document because I hadn't prepared a proper lot of text to run through. But based on this morning's question, would you like me to draw you to, I think it was sheet number 23, and maybe provide my answer to that question first and foremost?
Thank you. That would be very helpful. Is this in relation to the landscape character, the classification?
And sheet 23 is not the right number. Sheet 26. So your question this morning to Ms. Wilson was around, did that change her opinion in any way? And she's provided an answer. With regard to the question, in regard to Ms. Wilson's answer, I do agree that, I've always said that the site's an O&L, so the whole thing, including the existing building platform. The landscape study was done in 2008. These maps, the version that we've shown or included is the latest version, which was dated August 2008. I've had that confirmed last week by LA4 because I was a little bit concerned if there was a newer version because there's nothing actually on council's website. And
Who was LA?
Oh, sorry, LA4 is the landscape architecture firm who did the landscape study. I think they started that off in 2005 or 2006. And again, those things do take a number of years. And so there are some in our evidence, Ms Wilson and I agree on the landscape values of the ONL. But beyond there, it's really important to recognise that the ONL of the Dunstan Mountains is vast, it's very large, and the character and the values do vary across the extent of it. And the reason why landscape studies like this are important is that they do drill in, even though it's a still high level, they do drill into the nuanced differences of different parts of that landscape. And in this instance, the landscape study has identified areas where there is extreme sensitivity and where we're located with less sensitivity and a higher ability to absorb development. Now, the way that we undertake landscape studies as professionals do slightly different because we have Te Tangi Atu Manu, the landscape assessment guidelines that do assist us. When I look at all the recent work within Queenstown Lakes District regard to their landscape priority areas, is a key part of those priority area descriptions that outline the attributes and the values and the character of those areas, but they also outline the potential threats that risk, degrading the quality and the values of those landscapes, and the ability, firstly, the ability for those landscapes to absorb certain types of development. And so the methodology undertaken in this landscape study still follows similar methodology that has been done maybe to a better level now. And so in my opinion, the landscape study and the moderate sensitivity rating is important, and it does contribute to how a landscape assessment should be undertaken for the proposal.
Thank you. And so looking at this, it's your view that the site and the proposal falls within number 6, which is moderately sensitive. There's a portion of 5 that juts in. Sorry for the inaccurate, it's not a very technical term, but you know what I mean.
Yes, I do.
Do you have a closer, I can see the proposed driveway, presumably that black squiggle.
Yeah, so.
And does any of it fall within 5 or 6? And does it, yeah.
Oh, yeah, to cut to the chase, it doesn't materially change my assessment. When I look back on landscape assessments that have been done over the past 15 years, and again, because I've done so much work in QODC, Dr. Marion Reid, the landscape architect who prepared the ONL study in 2015, identified that when she was doing that work, she was using a pen on a 1 to 100,000 scale plan. And so most of the lines that she was drawing were at about 20 metres wide. Mr. McPherson, did you have a question? Sorry. So when you apply that same principle to what was done in 2008, it was a very similar approach, that these lines are a little bit awkward compared to the GIS systems we have now, that it is a 20-metre wide line. But when you are on, the critical part is that when you are on site, that little blue line, or the 20-metre wide blue line that you can see that separates 5 and 6, represents the top of the scarp face that encloses Devil's Creek.
Sorry, could you say that again?
Oh, it represents the scarp face, or the northern side of Devil's Creek. And so when you're looking at the access way location and the dwelling, it's quite clear that it's not within Devil's Creek itself. It's outside there.
If you turn over to your sheet 27, does that show that what you're talking about now?
Yeah, so the zoom in on sheet 27. Thank you, Mr. Page. Yeah, it shows that you're on that west-facing slope. So it's outside LCU 5.
So it's all contained within LUC 6.
LUC 6.
That's what you're saying.
That is what I'm saying.
And
yes,
Ms Wilson, I think, referred to the 2006
Even,
2007,
yes.
what do you understand?
From the email correspondence I had with LA4, the landscape architecture firm, they said that the Word document itself was completed at the end of 2007, but the plans were still being updated through that process, through the start or the mid part of 2008.
What's the document that is relied upon in the district? Is it the 2008?
So, yeah, so because there's a Word document, and that's where I copied the text from on sheet 15 of my evidence. And then there's the plans that go along with it to identify those areas. Yeah. Yeah. So the landscape study is one, it's only one study.
Yes.
The Word document, the Word side of things, and photographs and plans. So
Thank you.
with regard to landscape unit 6, and I've mentioned this a few times through my evidence, it's really important that the description is taken into consideration as well as not just the maps, and that this landscape has the ability, it's been identified as having the ability to absorb development, very much dependent on where it's located and how it is designed. And that's a really important part. And that's been a primary driver of the design from the very outset of this project. Are there any more questions on that? We can always come back to that as well as we work.
If you'd like to proceed, and we can come back to that if any questions.
Cool. I'll put that over there then. So my plan of attack was to run you through the graphic document from start to finish, and focus in on important parts. The other consultants this morning have extensively gone through the proposal. And so I've captured the proposal throughout, the first third of my evidence, through my evidence and the graphic document. There are important things to note on each page though. And so on the overall proposed development plan, on sheet 3, so if we're just starting there, throughout this entire project and assessment, you do have to bear in mind that there is an approved building platform. It is 1,600 square metres in area. It is at RL 360, so it's about 155 metres lower, or we're 155 metres higher than that location. There's a 16 metre height limit, 6 metre height limit above existing ground level, which does mean that you can actually go lower if you wish. And when you drove up that access way, well, it is still a controlled activity, and I bear that in mind when I say that, but when you drive up the driveway, you could cut in lower and have a 2-storey house, or you may be able to bunker in a garage or something like that below, as long as you sit below there. There was no curtilage, so therefore, and when I say curtilage, that's usually your outdoor living spaces, and it's evident with regard to the other housing sites within this development that they do sprawl beyond the development, that there's large lawns and plantings and all of those things as well. So when I consider that, when I talk about that, key thing, and probably well timed, Mr. McPherson, is that what's approved would actually allow for a lot more domestication within the site, which can be taller than what's actually proposed. And so what we have designed as we walk through the proposed house is actually a lot more contained and confined. And I think one of the words I've got on there is clutter. And I think Mr. Barry Condon talked about clutter, or visual clutter, and that comes to the driveway aspect, and that all of the cars and things like that are actually going to be visually screened by the proposed dwelling, where that's not always the case when it comes to just a normal dwelling. And a bright white motor home or a new jet boat or something like that could also be parked in a visible spot down around that approved building platform. So moving on to sheet 4. Got the visuals and we've got the proposed building location and some visuals of the close-up proposed dwelling. You saw this on site yesterday. I know it was very brief though. But the dwelling has been really well designed and located. So it's cut into the hillside to integrate with the 3 rock outcrops, with the southern corner being flush with ground level. I might be assuming, but when you're looking at the plan on the left-hand side, when you came up the access way, did you sort of follow where the proposed driveway is as you entered that dwelling, or did you come in from the left where the rock mound is? Yes.
It did come in the way, came in the way it is.
Yes. Yeah, cool. So when you sort of rounded that first rock outcrop, if you actually parked there and stood there, you're actually on roof height. Yeah, so you're all very well aware of that. And so everything is a lot lower. It's actually on site. When you're looking at that 3D visual from the south, you can see that that's the earth bund that's been illustrated. And that was really critical from the very outset again of the project, is that that small mound, it hasn't been fully designed because we're going to be using material from the site and vegetation to ensure that the house is not seen from Cromwell, Pies and Maureen. So those are the 2 most populated areas. And I think seeing the house from those areas would have higher adverse effects than what has been assessed. And so again, that was talked about on site from the very outset. Again, when you're doing this with the consented building platform, it's really important that it is really well screened from most public vantage points, as we've noted, and seen that it is very difficult to depict. We'll talk about that more. Moving into sheet 5. It's just a zoom in of what the dwelling actually looks like, but key thing we've talked about was the wind from yesterday, or just the general wind on site. A small detail is that the outdoor, you can see with the outdoor area that the glass balustrade actually stops on the very corner of the living room. And so just want to outline that because it shows that the outdoor living area is actually very well contained just to the very left-hand side of the dwelling. On it, because the grey colour continues to go across, but it's highlighted by the Juliet windows that there's actually no living outside the dwelling to the north for most of the house. Moving on, we've got the lighting plan that we've talked about today. We move into the elevations. Dwelling. The key thing here on sheet 7 is that the dwelling itself, excluding the foundation podiums, is 3.85 metres high. So it's very short, very low in the landscape. And that was really critical. It does have a big 1 metre eave, which is to assist with shading the windows and reducing that potential glare that Mr. Condon talked about. But one thing that he didn't mention, which is also important, is that the schist foundation is also that the house actually extends about 1.8 to 2 metres above that schist foundation. So that cantilever of the house will also assist with shading the schist, which it is a dark recessive colour. But again, having that constant shadow on it makes it darker, so less prominent. I'm also happy to take questions and things as we walk through this, so we can have open dialogue.
The balustrade, is that subject to the same glazing as the house itself? Will that be that being specified? Because obviously the glazing's got the shading component to it. The balustrade be under those same conditions?
Yes.
Yeah. Same time. Thank you.
So we've talked about the dwelling at length this morning. Moving on to sheet 11, we've got the proposed access way. These plans were, sorry. I didn't provide an overall plan of the access ways. Mr. Latchford had already provided that. Focus of these plans was to analyse how visible the driveway actually was from the viewpoint where the visual simulations had been prepared from. So then we could actually focus on the stretches of the road, the access way that are not permitted and how visible they might be. With regard to the colouring, those lines I've just put on the left, the middle, the right, and then just slightly off the access way, but they relate to the whole access way, that whole stretch of access way. So Mr. Latchford walked us through the access way alignment this morning. So the purpose of these plans is to just understand where the access way is visible from, with a focus on the sections that breach the district plan standards. And I have summarised that in paragraph 80 of my evidence. When you walk through this, you can see that on chainage 120, there's the red blob there. There's a very small red blob at chainage 80, and then again at 180 on that first sheet. These additional cuts are very small. We would see them from 3 kilometres away or so. They are theoretically visible, but in my mind, they would be too difficult to discern the difference between what is permitted and what is where the breach sits. And I have to say that that's probably that is the case for the majority of the stretches of access way that do breach the district plan standards. One of the interesting part that when you look at sheet number 12, you've got the large, you've got a max cut of 5.8 metres. Majority of that cut there is actually not visible from the surrounding public places. And that can also be said for when you turn over to sheet 13, the majority of that cut there where that, there's already an S bend up there, and there's the old four-wheel drive track up there as well. The majority of that cut, which goes up to 6.4 metres at its maximum, is not evident from outside the site. So whilst there is a physical change to the landscape, the majority of these changes to the landscape are permitted, they're actually not visible, so they won't change how, they won't affect the amenity that people gain from those surrounding public places. We also look at the, yes, when you go into the detail as well, and you can see the red text I've overlaid on the sections that Mr. Latchford's prepared. If we look at easy sheet I've got in front of me is sheet 12 at the moment. Okay. Ended up calculating all of those breaches to understand the extent of how big or how small. So I thought adding them in red would assist as well. That's important when you look at those numbers, that is the full cut height, noting that up to 2 metres is already permitted. So the difference, like when you look at chainage 520, the cut height there is 2.38 metres, but the breach is only 0.38 of a metre. So it can be quite small and in a lot of instances, they are quite small. From a design perspective and assessment, Mr. Latchford did prepare the additional alternate access way that we've looked at as well. And when I've been viewing the site from the surrounding public places, as I've been here on holiday while this project has been going on, or looking at other sites in the area, quite clear that upgrading the proposed access way, in my mind, will maintain the status quo. If the alternate access way was used, if building was put onto the existing building platform, in my mind, that alternate access way would be a lot more visible from surrounding places, and that access way would not have to have all of the rehabilitation that's proposed along with it. And it could result in, whilst it's permitted, it could result in worse scarring. So from a design perspective and from an assessment side of things, upgrading that existing access way is a much better outcome in this instance with regard to that access way. It has contributed to where I've landed with regard to the adverse effects on the landscape being very low. And Mr. Hamlin has talked about using that as, whilst top section does provide access, talking about the alternate access, Mr. Hamlin has talked about the fact that whilst it doesn't have to go the whole, there's already an existing track that goes along the top to the proposed dwelling. If he built something within the existing building platform, he would still need a user-friendly or a family-friendly access way. And that might be the preferred option. Happy to take questions as we work through each section.
Just a question, and this is in relation to page 11. You've got, just because it wasn't necessary for that page, that you didn't put the pump station in at the bottom of the, which is at the gateway?
Oh, no, sorry, that hasn't been shown on there. These plans were very much just focused on analysing the access way and its visibility.
With regards to that pump station, that's going to have, that's going to be a pump station at the end, or is it a mitigation planting around it, or? Right at the driveway.
Yeah.
I understand you've got a couple of pump stations going up.
There's 3 pump stations or multiple, 3 pump stations, 3 transformers. The water there and the electricity up there. Supply all the irrigation that's required.
None of those pump stations going to be visible. What's the cladding on those pump stations?
Pump stations not decided yet, yeah.
Yeah.
Obviously the transformers will be the green boxes, but I think they're all in the gullies at the moment. We've tried to locate them, and that can be fine tuned with my crude detailed design as well.
If required, we could put a condition on or add extra planting to ensure that they aren't visible. Moving on to page 18, where we talk about the proposed revegetation, or I illustrate what Mr. Rorison has prepared or provided. So the purpose of these plans is to capture the work that Mr. Rorison has undertaken, and regarding this illustrates the proposed revegetation rehabilitation along the access ways and the lizard sanctuary. Mr. Rorison's evidence was being prepared sort of at the very same time as updating these plans. And one thing that it hasn't captured was there was a 90 hectare area that he talks about in his evidence. So I'll let him, when it's his turn, he can talk about the location of that, because that hasn't actually been identified on these plans. The covenant area. Covenant? Not a fence area, it's just a covenant area, but that hasn't been shown on these plans. I just wanted to clarify that. So I can't answer any questions around that, I'm sorry. But it's really important on these sets of plans just to highlight the positive ecological outcomes for the site, as you're all aware, that they will enhance the landscape values of the Dunstan Mountains and the site. And that these positives won't be realised if the proposal doesn't go ahead. And that's what Mr. Hamlin has discussed. And a key part in pulling it back to the district plan is that policy 4.8.9 does focus on the positives of pest management. So when you're looking at a 330 hectare site on the Dunstan Mountains, we're willingness to focus on pest management as well as positive ecological outcomes benefit the landscape values of this area. And so the following on pages that go through to page 22 are just closer in plans of illustrating the areas where proposed planting will go, the area of the lizard sanctuary will have the predator-proof fence around it, and how the dwelling will overlook that. And essentially it also shows the areas of existing access way that will be rehabilitated. So I assume that would be some soil and removing some gravel and putting some soil on top, and then replanting over top of those access ways, which again, that's unlikely to occur if this weren't to go ahead. Moving on into the receiving environment plan on sheet 23. One of the key issues that has been raised, or the terminology around, I guess, upper slopes, middle slopes and lower slopes that has been used by myself, Ms. Wilson and Mr. McIntosh. I just wanted to sort of touch on this, just to this sheet here on sheet 23, and then flicking across to sheet 25. It's really important to illustrate that the proposed dwelling remains on the Dunstan Mountains lower to mid slopes. The Dunstan Mountains ascend up to 1,600 metres above sea level. It's about 1,400 metres above lake level. The proposed dwelling is sitting at 355 metres above lake level. And it's at RL 555.7, but again, it's 355 above the lake. So it's, yeah, sorry, just to confirm that. So it's not sitting at that upper end. Yeah, and it is below that ridge line that visually contains the lake. So that's really important aspect when considering house. It still is low down on these slopes.
On the legend, you've got the dashed black line as being the receiving environment. Is that your interpretation of that delineation of mid to upper?
No. That is my interpretation of the receiving environment as a whole. When we talk about the upper slopes, you'll see that to the right-hand side of the site, the black dash line follows that ridge line.
Yes.
And that ridge line there actually lines up with the bound, or is there or thereabouts with the boundary between LCU 6 and LCU 5 as well.
Okay.
Because it's that slope that visually contains Lake Dunstan, and that contributes to the scenic outlook.
Thank you.
That's gained. When you look at the receiving environment as well, it does contain all of Cromwell and that long stretch of State Highway 6, where the visibility assessment has occurred from. Yeah. We've gone on to sheet 26. We've traversed this. I think the key thing is that, as Wilson and I we did have different starting positions, and that in her peer review, her starting position was that Dunstan Mount, or the site was within an area that was extremely sensitive to change. And so that is a big difference. Then moving on. So we're in the district planning map. The house has always been intended on being in the O&L, and that's just consistent with the existing building platform. Again, just focusing on the O&L and those values, my evidence and my original report was considered that the O&L values are its highly distinct and legible landform. The high degree of openness that it has, high degree of visual amenity and scenic values that it contributes to the amenity of the area, and the sense of place and the way that the Dunstan Mountains contribute to Central Otago's distinct character. So I've always considered that those values are high going through my assessment. But that's also important, whilst recognising that the landscape study has identified that this part of the landscape is a little bit more capable of absorbing development. And that's due to those craggy and rocky outcrops and the dark colouring of that vegetation, where there are quite clear areas on the Dunstan Mountains that don't have those attributes. And that's closer to Cromwell. And it is more of a tawny brown colour, and the slopes are just more gentle and roll. Well, I won't say gentle and rolling, I apologise, just more visually open. But they don't have that same ability to absorb development. If you put a house in there, it'd be clearly evident, and it would detract from the amenity. I guess that's what was found in the Larks Bay case. We've seen all the viewpoint locations, and there was a very heavy, focus of covering off everything from represented by state viewpoint 45th parallel track, which is a very popular walking trail. Pies and moorings, because that's a very populated area, becoming more populated, and then to the north of pies and moorings as you're travelling back from Wanaka or Lugga Track Cromwell. Then one of the things that the landscape assessment report didn't cover off was views from Devil's Creek. And so I wasn't able to walk that track at the start of the year. So a staff member from the Wanaka office did that, which was really awesome. And I can walk you through, if you want, I can walk you through those photos first, because they're probably the photos that we haven't touched on at all. We would probably have traversed, or Mr. London has traversed viewpoints, 3, 9, 10 at quite length. But I will probably pop back to those after going through the Devil's Creek track. Photos. So head to page 46. Yeah. So the key there is that the photographs, always bear in mind when you look at photographs, is that they do focus towards the proposed dwelling location or the subject site. And so they're always facing towards there. you know, when you're actually, well, when you're on site, which is very similar to the track, you see a broad range of views and you get those great views over the lake. But it's quite clear that the proposed dwelling from viewpoints 14 and 15, and then also 16 and 47, no, sorry, 16 and 17, all of them, is that the proposed dwelling sits behind the ridge line or the earth mound. So I've done my best in annotating where it's located within this landscape and identifying that. And then, yeah, and the same is to be said from viewpoint 20. What you do see though is if you're walking up that trail or if you're walking down that trail, which Doc has said that it's a pretty difficult track to be on, is that you do see the existing access track. And then I've also outlined those sections of the access way where there is a breach with regard to the cut being too deep. That's changed 600 to 710. Oh, sorry, looking at viewpoint 15, I think that's probably the best one to be looking at there, which is probably the worst case, or viewpoint 16, is that you can already see the zigzag of the existing access track. And so again, what you'll be looking at from that vantage point is you'll see a slightly more upgraded access way. And then in time, you'll see planting and things around that access way and residents' vehicles coming and going. But again, that's very much maintaining the status quo in my mind.
Here, but it may be for Mr. Hamlin, and we're just referring to viewpoint 15 from the dock walking track. You mentioned right at the start of the day about illegal hunters on your property. And where do you think they're accessing your property from?
Front gate at the moment.
Your front gate, yeah, potentially, but is there other places do you think they're coming in from?
I think 95% of them just going over my front gate at the moment. From what we've seen from access and cameras, whether they can still come up from Devil's Creek eventually, but if there's no test on there for them to shoot, then I'm assuming they won't come anymore. Because at the moment with the pigs and the goats, then it's a bit of a easy spot for them to go.
Yeah.
We go crack.
Yeah.
Walking up the trail.
Yeah.
Yeah.
The weather wasn't very conducive
Trying to come.
Bloody arthritic knees gave was.
We blame the old fella.
Just blame the old fella. You know?
Yeah.
Well, I hope the photos help.
Yeah, thanks.
Cool. And again, they are very much focused towards the site. They're not focused on the other views that you do get from up there. So that those last photographs cover off Devil's Creek track. We'll go back. I think the last page is bullet one. Focus on, and that's just on visibility rather than the visual effects. But again, it just goes through and clearly outlines where the consented building platform is visible from and where the proposed dwelling is visible from, and that it's quite clear that the proposed dwelling is seen from a lot less vantage points and than the consented building platform. And I think the key one there is actually when I was standing on building platform again yesterday, is that the view from towards Pies and Moorings is really open from that consented building platform. So this is going to remedy that effect of seeing what could be quite a large dwelling and quite a lit dwelling at night time. That
So
does
the blinds down.
There's no condition on blinds, or there's no conditions on lighting, and nothing on size. There is a condition on outdoor lighting, which is there, but it's definitely not to the point or the extent that is proposed. And that's really critical. So whilst we are, and from the outset of this project and in my landscape assessment report, I do identify that the issue at hand that we are talking about is the elevation of a dwelling and the domestication of the hillside. And that is what has created an adverse effect on the landscape, and that's where I've landed at a very low effect. But I have had to balance that against what can occur at the consented building platform with everything else that is going along with the proposal. And so I haven't shied away from that. I'm not, that is the concern. Yeah. There was only, so I've walked you through my graphic attachment. I've had a couple of notes, and I think I did touch on it before. But I think the key thing is to draw you back, if you can, to the visual simulations of Mr. London's. Give me a moment. Sorry, Miss. Yeah. Well, it's just the one that I wanted to draw your attention to was viewpoint 10 on sheet 29. The only one that because this is the worst case view. The viewpoint 10.
Sheet 29.
Sheet 29. When you're standing right on the lake edge. Imagine you might have popped down there yesterday and had a look.
Yep.
And I look at sheet 29 because it's the one that we should be looking at when you're in a room, because it is, you look at it from 400 mil away. Again, I mentioned it before, is that you've got scape brace. And so I've drawn a horizontal line across the scape brace. Where you go up and to the left, and you can see the access way to the consented building platform. And that will sit on a slight knoll of vegetation, a slight ridge. And directly above there, you can see the proposed dwelling at at the same height difference between scape brace and then going up again up to closer to the ridge line. And so you can understand that. I haven't lost you there. Cool. And then when I look at sheet 31, and we look at the lighting, same spot. So again, you're looking at a very well-designed lighting plan for a house that, has done its absolute utmost to be as recessive as possible and dimly lit as possible. I note that the lights on this image are at 100%, and there's a condition that they're actually meant to be on at only 30%. That's 70% less than that. If you come again halfway down between the proposed dwelling location and scape grace, that's where the consented building platform is going to be, or that's where a dwelling can go. Again, there is no restriction on lighting in that spot. So when I look at this, I look at a potential dwelling that could be quite lit on that hillside. And I consider that the difference between a very well lit dwelling in the consented building platform compared to a slightly more elevated dwelling that is a lot less lit. And that's where that effect is, why that effect is sitting at that very low to low mark. Yeah. So that's going through all of the graphics and everything that I've covered off. There's no other key real points. I can walk you through my conclusions, but you've got them in front of you as well. But I do not, when I was, the key point I actually wrote down is that undertaking my original landscape assessment and working through a lot of technical information, preparing my evidence. Key thing that I've actually found is that the further work that we've undertaken to prepare my evidence has only assisted in supporting the conclusions that I originally made in that landscape assessment report. And so I do note that I did make that error with regard to State Highway 8. But again, I don't resolve from my overall conclusions.
You covered off some of my questions already, but I do have a few more.
Fantastic.
So at paragraph 82, of your evidence statement.
Yes.
So Ms Wilson, as you record here, has raised concern regarding plant growth rates within the exposed environment
Yes.
and consequently their ability to mitigate the areas of exposed soil. So in your experience with this, like I realise we have an expert on ecology that we will be talking to soon.
Fantastic.
But clearly this is a comment that you've made, and so you're used to assessing perhaps the success or otherwise of mitigation in relation to landscape. So I was going to ask you this question. How confident are you that the plant growth rates can be achieved and then actually the outcome will be as envisaged?
Pretty certain, pretty high. And it's based on Mr. Rorison's evidence. But it's also when I was on site, or with the photos that I have on site and when I've been on site, as you travelled up the gully, there are certain areas on the site that in that gully environment where it's quite evident that plant growth does occur. In the photographs from Devil's Creek, it's quite clear that that area is actually quite green, and that was taken in January, those photos, so that there is plant growth in that space. The growth rates are more Mr. Rorison's expertise, but I think the key is that the key thing for me is that I'm confident that the plants will grow, especially if the pest management is removed. And whilst we've sort of said what they'll be at 5 years and 10 years, there's always room for like a 1 year to 2 year difference at times. Yeah.
To submissions that we've received, you've made comments about the submissions from Irunaka. Paragraph 109.
Oh, thank you.
Both of these submissions from Te Ao Marama and Okaha are concerned about the proposal's adverse effects on the cultural landscape values. So obviously we don't have any expert cultural evidence in the room to speak to those cultural landscape values. You've obviously cast your lens over as a landscape architect.
Yeah.
So you'd accept that you're unable to provide cultural expertise and because of your qualifications. Yeah. So, and then at the paragraph 110, you've said that your evidence has thoroughly covered off issues A and B. And I wondered just what you were meaning there.
From a Pakeha perspective,
From your
from my qualifications as a landscape architect, I've covered off the adverse effects on the landscape values, excluding the cultural through A and, that's what I mean by A and B.
Right.
Yeah.
Okay. Thank you. Getting back to question around the different starting point. So I think that's an important one for us.
Yes.
And we'll obviously tease that out with council staff as well. And the reference points from an evaluative assessment from a landscape architecture perspective is quite fundamental. Is that correct? So if we've got two landscape architecture assessments and they've both got a different starting point, that can result in quite different conclusions.
Yes, it can.
And so I've heard you say is that I think I'm just doubling back again. But basically what I've taken from that is you still have a disagreement. You still disagree with Ms Wilson's assessment in terms of the more nuanced, detailed the specificity of the landscape unit that is helpful in terms of the values that sit within the broader ONL, and that you've got a disagreement still remaining.
So it was around the difference, in my opinion, based on what Ms Wilson has put in her peer review. In her peer review, that she says that the site is extremely sensitive to absorbing change. And my assessment report and evidence outlines that this has a moderate ability to absorb change. And
That's the core.
That's the difference. So it's the ability to absorb change is the difference.
And is that the key difference?
Yeah, so we both, in my understanding, we're both in agreement that it's in an ONL.
Yes.
And we're both in agreement on the landscape values. It's just that ability to absorb change.
Thank you. That's very useful just to have that super clear. Great. I'll see if we've got any further questions for you.
I guess the only thing that I, and whether this is directed for you or not, and because you mentioned the gold mining in your evidence here, you talk about, well, it's a reference to that. And from Ms Wilson's peer reviewed, do you foresee any issue going forward with any landscapes issues going forward with what's going on along those mountains?
Okay, so the reference I had with regard to gold mining was an associative value with the landscape, and how that Wilson said that gold mining is associative value of the Dunstan Mountains. My opinion is that that is further away above Bendigo, and that value doesn't actually attribute to this area. I'm not here to undertake an assessment of the gold mine over there, but I would probably say that being on site, you can't see that. Well, I don't think you can see that, so therefore I'll leave it there. Cool.
Thank you, Mr Smith. That's been very helpful. Thank you for taking us through all the images. We may loop back to you at some point.
Absolutely, I'm here.
Thank you.
Thank you very much.
Hopefully that's the end of the contentious expert evidence. Because my reading of the 42A report is that everybody's agreed that there will be positive ecological outcomes from the proposal. And so Ruben's here to explain how that works and hopefully answer questions about growth rates.
Yes.
Yes, that's essentially what I've landed on as well. It's that I'll do my best just to give a quick summary of my evidence.
Well, hang on just a moment before we move on.
Summary?
We were going to have somebody come back for the council.
Sarah's
going to rejoin us. Good. No, she's back again. Sorry, we can carry on.
Thank you.
And then I'm happy to take questions throughout, but if you'd prefer, I can get through this quite quickly and then answer questions. So, hello, Commissioners. My name's Ruben Morrison. I'm an ecologist based out of Queenstown, and I'm the Managing Director of Restore NZ. I hold a Bachelor of Science in Ecology and Plant Biotech, and I've worked in quite a few resource consents locally, especially relating to rural land development, as well as quite a few major infrastructure projects across New Zealand. So my evidence focused mostly on the key ecological matters that were raised post lodgement of our consent application, and that included the Wildlands peer review, the Department of Conservation submission, the Section 42A report, as well as a brief further survey of the ecological values in the house pad that's being relinquished through this consent. So firstly, I addressed the relinquished building platform. And so that area, which you did go and look at yesterday, has really high values, even though it's closer down. It has really high quality cushion field, as well as two quite large rocky outcrops that are really nice stacked stones. And from our survey of the wider property, including right next to that building platform, that's where we actually started our wider survey. We found that those large rocky outcrops of stacked stones were holding massive numbers of lizards. So I think I'm quite confident in saying that there are really high values in that platform, and that impacts to those are going to be completely avoided by relinquishing that house pad. I then went on and addressed the wildlands peer review, which formed the basis of my post-lodgement work. So first thing that I wanted to do in my evidence was just to clarify how I assessed ecological significance. So my ecological impact assessment uses the ERNZ guidelines to structure the report and present my ecological values, but the assessment of significance itself uses the MPSIB criteria. And those frameworks both use the same 4 key attributes to assess values as assessing significance. So the way I present it in a report format is I just group them together in a table, list the 4 key values, and then assess value and significance. It's not a departure from using the significance criteria from the MPSIB. I just find it easier to present in a report by doing them both in one table. I then responded to each of the key points that Wildlands raised in their report. And an important part of those key points was that I've accepted Wildlands' view that the Cushionfield reinstatement should not be relied on as mitigation and instead as an enhancement measure. And so in doing that, we now fall into compensation when we're following the effects management hierarchy, which wasn't part of our original application. So I then undertook a full assessment of the proposal against the MPSIB compensation measures, which I had provided a much more high level version through email to the council planner, or to our project planner, who forwarded it on to the council planner. But in my evidence, I thought I'd do a much more comprehensive and detailed version. And that assessment confirmed that the proposal meets the principles and it's going to deliver a substantial net gain in Indigenous biodiversity, which is a theme that has been reflected through my work as well as through the Wildlands peer review and DOC's views. Which brings us to the third section of my evidence, which was Department of Conservation engagement. So DOC lodged a submission which broadly aligned with everything Wildlands had said. They also agreed that there's potential for positive outcomes, but it's going to have to be very carefully managed with conditions, which is standard for resource consents. And so following that, we worked very collaboratively with DOC to come to an agreed set of conditions. That included taking them up to site and walking over the proposed driveway alignment, or sections of the proposed driveway alignment, as well as the house pad and the relinquished house pad. And that was conducted during the survey window for spring annuals, which are the threatened plants, which have been mentioned quite a few times. And it also included one of DOC's expert botanists. After that site visit, we had quite a few rounds of engagement back and forth, just refining conditions to a point that we were all happy with. And DOC subsequently withdrew their submission on the consent application. So in my view, I think that demonstrates that all of the ecological concerns have been appropriately resolved and that DOC was happy to withdraw.
On that note,
yeah,
they've not withdrawn their submission. They're keeping a neutral submission. They're just not wanting to appear. Is that correct?
They've withdrawn their right to be
Thank
heard.
you.
My bad.
Thank you. No, all good. Just wanted to be clear. Thank you.
Thank you. So section 4 of my evidence was just in response to Ollie's section 42A report. And overall, I agree with Ollie's conclusions, particularly that ecological effects will be no more than minor and outweighed by positive long-term outcomes. The only point that I disagreed with, but Ollie, I'm glad you brought it up because I think it needs further clarification, is with regard to pre-consent botanical surveys of the proposed house pad and driveway alignment. In my view, there's no additional survey necessary. The reason for that is that the site itself has already had extensive survey, very detailed survey done of those two areas. And then that was further supported by the site visit with DOC. as I mentioned earlier, was during the appropriate seasonal window, and there were no additional concerns raised with regard to those areas by DOC's botanist during our back and forth following that site visit. Only further survey that DOC requested is done is within the planting areas and the sanctuary fence footprint. And so that remaining uncertainty relates to those areas, and they've been appropriately addressed through the consent conditions. So in conclusion, from the outset of this project, it's been driven by an objective of achieving a net gain in Indigenous biodiversity, which Joe was very clear about wanting to achieve from day one. The ecological assessment has identified the site values appropriately. The proposal has been refined to avoid higher value habitat, and the remaining effects have been addressed through a robust and agreed set of conditions. Both the Wildlands Review and DOC have acknowledged that the proposal has the potential to deliver a substantial net gain, and the outcome is now secured through conditions. So therefore, I'm very confident that the proposal can result in a positive ecological outcome and over the medium to long term. Thank you.
I have some questions for you. And it relates to the effects management hierarchy and when something moves from a mitigation to an offsetting or a compensation. And in line with that, in your evidence statement, you also talk about additionality. So I'm interested in, I guess, if you can succinctly just describe what this proposal does in the categories, that would be very useful.
Yeah, so our effects management hierarchy, firstly, we do avoidance.
Yes.
So we've done multiple different rounds of doing our best to avoid key habitats. And as Charlie mentioned, we've done a lot of iteration and refinement to avoid key areas. And then we minimize. So that is mostly where I was annoying Charlie throughout the process, just to really refine small areas and tighten things up. And also following the DOC visit, they brought up areas they wanted minimised.
So that's in with the access way and the survey.
Yes. And then we get to remediation, which is what I had originally really put a lot of weighting on in this proposal, because we were picking up large areas of cushion field and we had lots of area to reinstate that in. But following the Wildlands peer review, which acknowledged that there's uncertainty as to whether that cushion field is actually going to establish, we agreed that it's no longer appropriate to rely on that as part of our effects management analysis. And so we've moved into compensation, because offsetting is not appropriate for the same reason that the cushion field can't be used as mitigation.
Thank you. Yep. Okay, and so compensation is that you are replicating an outcome somewhere else.
Yeah, compensation aims to derive an ecological outcome in a way that isn't like for like, in the sense that offsetting would be. We can't plant more cushion field.
Sure. Yep. And additionality?
I'll just pull up what I said about additionality.
So that was at paragraph 71. So from my reading, it almost appeared like the additionality was, in its pure sense, positive effects in addition to everything else.
Absolutely. So essentially, the original proposal as I wrote it was, we think that this sits within avoid, minimise, remediate. And Joe is going to propose a substantial amount of additional things because he wants to. And we've now reassessed our project as far as the effects management hierarchy goes, but there is still a significant amount of additional things that Joe is proposing.
And they're volunteers, they're not required for mitigation.
No. No, if we were going to do specifically actions just to compensate enough to get this proposal over the line ecologically, you'd be looking at a substantially reduced compensation package.
It's important, Commissioner, to record that as an offer, because so that you
Yes.
can comply with condition, section 108.
An OGR.
Yep.
Yes. Thank you. I've got a couple of questions, but I'll hand over to my fellow commissioners. I'm sure they have some as well.
Yeah, just noted that your initial site visit was the 11th of October. Was there no schedule, did I see, that set out the dates that you went back and performed site visits? And especially what I'm getting at, and I can feel Commissioner McPherson on my side here, in relation to springtime visits. And I know that has been mentioned, as you brought up before. Those that springtime evaluation is particularly important to any dryland side of things.
So I engaged the senior botanist Simon Beale to lead the vegetation work on this project. His site visits were constant throughout spring. I'm not sure how many in total, maybe 4. Just going back to view different areas and to really get a coverage over that month. But the exact dates I don't have in front of me now. I could get those if you wanted them. But like I said, we've accepted that Wildlands and DOC both want a specific dryland expert to go and review the planting areas. And so we'll do that, and it can be up to that expert as to exactly when they want to come and visit the site.
So I'm just referencing 41 of your evidence here. You've referred to, you accept that Roland's point about a targeted botanical survey to be taken in the spring, and you're proposing to do that again in October, November this year.
Yep. So
that'll be the spring annuals you'll be looking for specifically.
Yes, sir.
Yep. Got to think about spring annuals.
Yeah.
They're very cool little plants.
They're very, very small little plants.
Yeah, me and Simon. So I think it was figure 4 of my impact assessment where I had my GPS recording as I walked tracks around the site. That only represents me. And so that figure alone shows like very good coverage of us walking back and forth. And that's 50% of the people standing there looking for these plants. And while I acknowledge we're not specific dryland botany experts, we actually had a print off of the exact plants we were looking for out on site, and we were on the ground steering very closely to find these plants, and we did not find them. And I think that point, which I conveyed to DOC while we were on site, is part of what made them quite comfortable to get to the position that they're now in.
I have a question in relation to the growth rates, which you might have, I'm much under here. I am really interested to hear your opinion as to what is going to be required to get them at where you think they're going to be at 10 years.
Yeah, so I'd like to separate out 2 different types of planting area. We've got the barter slopes and the enhancement planting areas. So are you asking specifically about the slopes on the accessway or all planting?
Well, you could please tell us about both.
So with regard to the enhancement planting areas, those have been selected based on like deeper gullies that you can visibly see have more moisture because there's a lot of hemlock growing in them, which is a noxious weed, but it's very green, very herbaceous. And then it goes out into the wider slopes, which are where we're finding cushion field in these really dry, harsh environments. And so in those areas, those are where we've selected as enhancement planting areas, and where they are has deeper soil already. So just by the nature of that area, I've much more confidence in the actual ability for it to grow. I did put in there the ability for us to make some practical changes to our planting areas in the species selection if we find it needs it. And on top of that, we're also irrigating those areas, which is really useful for plant growth. Plants grow very well when you irrigate them. The barter slopes on the driveway are a slightly different matter, and I've put together a varied plant mix for those based more on species that will grow fast. But I think on further refinement, we could even include a higher prevalence of carnuka just because of its ability to seed in such harsh environments. So your carnuka can grow in like very, very shallow soils. It can grow in like hardly any soil if it has a crack that its roots can get down. And so it will just depend on the cut face itself. If it's bare rock, we're not going to attempt to plant things on that, I imagine. But where there is a cut face, if we can't be planting on it, the downhill side of that on the fill side is going to have soil that's been pushed there. So that's going to make like the opposite, really good planting on that side. So I'm quite confident in how fast things will grow.
And you're happy with the amount of irrigation water that you've got, you'll be able to suitably.
Yeah, it's not an easy
Irrigate
site to irrigate, and Joe's put an irrigation plan in that takes irrigation right up to the house. And then the way we've designed the planting areas is that as the driveway progresses, we'll plant them to make sure that we can irrigate them as we go. So we're not going to be planting plants in an area where they have to go through an entire grow season with no irrigation and dry out.
And I have a question about the lizards. And it's on the basis that when the perimeter fence has gone in, there is a lot more growth, which because obviously there won't be goats or anything else, pigs, things eating the natural grasses, which will regenerate. Will this be positive or negative for the skinks and the lizards?
I have enlisted the help of one of New Zealand's best lizard experts in this project, so I don't want to speak out of place when I talk about lizards here, because I've used someone that's far more intelligent than me in this space. But so across the wider property, when grass grows in, I think that's not going to affect the rocky habitats as much because there's no grass growing in the rocky habitats. And then, yeah, I'd be really interested to know what Carrie thinks about the spaces in between. But we also found a grass skink on site, which benefits from grass growing. So I think it's less of a question about what will the impact be on them, and it's more of what sort of an equilibrium is the site going to settle in as we go through this natural change that is more or less occurring no matter what. I don't think you can avoid ecological succession. If we look sort of to the north of the site, that property is like very covered in carnuka at this point, and that's just happened naturally. And so ecological succession is going to happen no matter what, whether it's carnuka growing in to replace the cushion field or whether it's grass coming in because Joe's doing some control. But in our conditions that we have agreed with DOC, we're going to keep some cows on the property just to keep that grass growth down.
I should do my questions.
Yeah, it's just done. Sorry. You're good.
All right.
Bear with me here. Section of your evidence at paragraph 93 speaks to science and mātauranga Māori. And I was wanting just to ask a couple of things of you here. So at paragraph 94, you've about engagement with tangata whenua by the project planner. So is that, ask you about that?
That would be Jake Woodward, yes.
Okay, thank you. And at paragraph 95, you said, you talked about the opportunity for stakeholder participation, and you've said ongoing engagement can occur during implementation of the ENP where appropriate. What did you have in mind there? I couldn't see anything in the proposed conditions that spoke to that. Did you? Yes.
Speak. Jake said he's happy to speak to that.
Okay.
In general, I'm always happy to incorporate people to come along to site with me.
So that was a more general kind of comment from you. Okay, thank you. That is it. Oh, that's right. In terms of back to the planting and the achievement of the conditions and the scale and volume of tree plants that you require, where will they be sourced? Several thousand, I think 14,000 trees.
Yeah, I know there's a lot of nurseries locally, and my experience is that when you have a substantial amount of plants like what we're doing here, you'll engage a nursery early and you'll let them know what you're planning on doing, and you essentially pre-order your plants and they start growing them from seed stock. So I imagine that'll be the process that gets followed.
Okay. Is there any risk that that couldn't be achieved, or there'd be a significant delay, or have you got any experience with that occurring in any other projects?
Wouldn't expect it to be a significant risk. I think it's not unreasonable to say that there could be a delay if you didn't anticipate, the time it's going to take to get those plants to grow. Can also use multiple
We have a very good
nurseries.
voluntary group here based in Alex. Who are currently restoring a block on State Highway 8 coming into town, which was Warren Pines. A real challenge, but
Yeah.
they are quite unique and going to say successful to date. Yeah.
In their wilding pine removal.
They've got rid of the pine, though. This is the replanting of dryland species. Yeah, they've got a nursery out of Clyde. Hayapa Trust. We're not aware of them.
I haven't even heard of that one. There's quite a few little hidden nurseries.
They are here and they are getting a lot of experience with dryland planting and restoration work, which is groundbreaking.
That's really encouraging. And I think I put in my management plan as well, there are options to help with the establishment, things like putting rain crystals into your soil matrix to just try and hold on to some water. And then, luckily we don't have wilding pines on our property here, because that introduces another change to soil chemistry that you have to deal with in your planting.
Thank you. Mr. Warrington, that's all our questions. Thank you for your helpful summary and responses to our questions.
Thank you. Jake, do you want to speak to summary of your evidence, please?
Rangi te mau te maunga, ko roa mahanga te awa, ko take te mau te waka. Atahununu ki Wairarapa, te iwi, ko Jake Tokunua, tēnā koutou, tēnā koutou, tēnā koutou katoa. I might use one who I am. I'm Jake. Consent planner. Here for probably over 10 years now. I'm relatively familiar with the subject site and the surrounding area. I represent and have and continue to do resource consent for North Burn Station, Bendigo Station. All of the consenting for Scapegoat Distillery. I've done due diligence on all of the properties adjacent to the state highway as it relates to the subject site. And I was initially approached to provide planning advice for Rocky Point. Due to capacity reasons, wasn't able to take it on. So somewhat familiar and relatively familiar with the subject site, specifically having gone over the site with all of the relevant submitters. I was in attendance for not all of the survey, but a part of it. And Joe kindly lets me go out there and remove some goats and rabbits. So
Control.
it's control. Before I just crack into a very brief summary, I will keep it very brief. I'm conscious of the time. I was just taking some notes as some of the other specialists were speaking. It's just a couple of points to clarify. And I have been involved from day one. Just speaking to Mr. Rorison's evidence, perhaps the key point that didn't quite come across just in terms of the effects management hierarchy. We have to recognise that avoidance played a key role at the very start of the process, insofar as we initially had a number of different driveway alignments, which traversed a number of different gullies. And so a combination of both landscape and ecological reasons. the decision was made to try and, as best as possible, utilise the existing access. You would have seen, and as per all of the ecological evidence that's been produced, there's extensive Indigenous vegetation across the property. So any degree of permitted earthworks or anything like that will inevitably have a degree of adverse effects. So the avoidance criteria go much beyond just simply avoiding a couple of rocks and certain vegetation. So that's a key point to bear in mind. The second point there is that the district plan explicitly permits the Indigenous vegetation removal on the site. There is no resource consent trigger. In fact, the only reason why we've engaged the ecological team is purely to deal with the consent notice conditions that were imposed that explicitly talks about no vegetation removal or rock removal unless it's associated with the dwelling or the driveway. As we've heard from Mr. Larson, or rather, as we've read from his evidence, those conditions were merely just volunteered. There were no expert evidence involved. So for the most part, the ecological side of things has a significant ecological benefit, but there's obviously just in terms of the planning criteria, a significant amount of removal could occur. The question around the planting and the availability is a very relevant one, and being involved in a significant number of resource consents where we do rely on vegetation, it is actually an issue that we need to constantly monitor. The reality is that if there is a shortage, there's a shortage. The fact of the matter is that we have volunteered and proposed conditions which are agreed with DOC, which did not allow Mr. Hamlin to build the house until all 14,000 plants in the ground. We will go through the conditions in due course. The problem here and in practice is that it'll just delay the construction. Pump station will be in reference to the irrigation plan that we submitted. Those particular structures, we talked about that within the first several days of receiving that infrastructure report about a year ago. Those particular elements wouldn't trigger a specific resource consent per se, and that's consistent with utility buildings that we've applied for on the Scapegoats property and other farm. So any sort of utility structure, for all intents and purposes, are permitted. There's probably the wider question around a proliferation of those structures in the landscape, but we are talking very small, very far distance, viewing distances, and structures that can, for all intents and purposes, be designed to be sympathetic in the receiving environment. Yes, all glazing would be subject, including the balustrade, and we volunteered a condition to that effect. Mr. Smith confirmed, and you're well aware that the profile poles represent the height. You were basically parked at the height of the roof of the building. So appreciating that a couple of the poles have snapped, hopefully there might have been enough to be able to get a sense of, okay, this is the profile of the structure. So those were just a couple of key points I wanted to touch on without interrupting the various subject matter experts. And I don't intend to read my evidence in full because it's a little bit long-winded and not that interesting, but I have produced, and I believe everyone got a copy of just a very brief condensed version. So I don't intend to read to that either, but I'll just sort of speak briefly to it. So I'm just going to cover just, I guess, 4 or 5 key matters. And so please ask any relevant questions at the end of this. But firstly, I just want to touch on the landscape evidence. And Mr. Page has already briefly spoken to the permitted baseline, and I'd just like to add to that. So there's essentially 2 key elements at play here. We've got the driveway, okay, and the associated effects of constructing it, and of course its presence. And then we've got the effects associated with the dwelling itself. So the permitted baseline in this particular case is very relevant, particularly as it relates to the driveway. As the panel will be aware from various resource consents, section 1042 empowers you to, or at least enables you to disregard any adverse effects on the environment if the district plan permits that activity or permits an activity with that effect. The key point there is it's in relation to the effects. It's not the activity itself. Why this is important is because the section 42A report would suggest is that the permitted baseline should not be applied in relation to the earthworks on the basis that the permitted activities, namely rural earthworks or tracks and so on, are fundamentally different, and I quote, in kind and purpose from the residential development that is proposed. What that is telling us is we can't apply the permitted baseline as it relates to earthworks because it's associated with a dwelling. So respectfully, I hold a different opinion to that of the section 42A report. The relevant consideration, as I mentioned, is in regard to the effects. So as Mr. Page has outlined in his legal submissions, we know that the district plan expressly permits earthworks or access tracks and driveways, so long as it meets a standard. We've heard from the various subject matter experts that it is, and the intent of the proposal is to utilise, for both landscape reasons but also ecological, the existing access. There are only certain elements that are being excavated for the sake of achieving a much more user-friendly access. We have to remember that we're not dealing with a right-of-way that is subject to council standards. Rather, the standards that are being imposed are for nothing more than firefighting and the ability for someone to drive a heavy vehicle up here. But the district plan doesn't govern or dictate the gradient of a driveway per se, unless it's a right-of-way. We've seen evidence, we've seen the survey evidence to suggest that a wholly permitted access could be produced, which wouldn't require resource consent. And we've heard from Mr. Smith that could result or would result in far greater landscape adverse effects. Fundamentally, this is not an uncommon outcome, and strict adherence to a permitted performance standard in a district plan can sometimes result in undesirable environmental outcomes. And we see it all the time. And a good example would be building designs that try to comply with, say, a recession plan to simply avoid a few $1,000s on a resource consent. You could end up with urban form that is very out of place, out of keeping. And this proposal represents a very clear example of that principle. We could do a permitted driveway and have a scar going across a very significant frontage, almost 1 kilometre wide, I believe, and not get a resource consent. Or we can utilise the existing access and do a couple of cuts that exceed the 2 to 3 metres. We then heard from Mr. London and of course Mr. Smith that there are that the components or the aspects of the driveway that require the resource consent are tucked away in some gullies, or for the most part, just not visible. Anywhere that is visible, we're talking about viewing distances in excess of several thousand metres, kilometres even. So no person in practice would theoretically be able to look up at the hillside and say, that particular spot there in terms of earthworks requires a resource consent and therefore the effects are. The reality is the driveway and the effects of the driveway are contemplated by the plan. And I heard a comment from Commissioner Patterson earlier today that you would have seen the scarring, so to speak, across the wider hillside, particularly if you cast your eye. Not to harp on about the point, but the fact of the matter is that the Section 42A report in the council peer review, landscape peer review, raises significant concerns around landscape values by not applying the permitted baseline. It is at your discretion to apply the permitted baseline, but we have to recognise fundamentally that some activities can occur as a permitted activity, and for those reasons, there's an opportunity to extract some of those elements that are entirely acceptable. So in terms of the landscape effects and in terms of one limb of the issue that play, dwelling in the driveway, I consider that the driveway compliance with Mr. Smith's landscape evidence be no more than minor. Paragraph summary 18. So turning briefly to the dwelling itself, the permitted baseline is a lot more complex in that particular case. But I do reiterate the page's legal submission that the district plan effectively reduces the emphasis of the O&L, rather the O&L values, on land that enjoyed the specific exemption under Rule 476L. The panel will be aware that all dwellings, every residential activity in the rural resource area of Central Otago requires, at a minimum, a restricted discretionary consent, at a minimum. You can only get a controlled activity consent once you get your restricted discretionary platform. So that's our starting point. You then have a property that has an O&L overlay, you're elevated to the next level of scrutiny, which is a discretionary activity. So we've heard from Mr. Page that that did not apply to this site. Those exemptions remain. Notwithstanding that, we've obviously got a significant amount of landscape evidence and peer reviews in front of us. So it's not like we're simply disregarding the O&L. And I don't want to harp on any more about the landscape matters that Mr. Smith has presented to us, but what I would point out there is that we have seen evidence today to suggest that the proposed building is very difficult to see. Visual simulation would suggest that unless it's pointed out to you, it's unlikely that you'll be able to pick up on where that dwelling is during the daytime. During the night time, we've seen those visual sim and all of the information provided by Mr. Tilley. And we have incorporated those recommendations around the dimming and the automated blinds and the conditions of consent. And I know that Commissioner Brown had several questions around the automated blinds and so on. And in due course, we can talk briefly about the proposed conditions, but they are inherently part of the conditions framework. This activity could not go ahead without those conditions. It's effectively what we are volunteering and proposing. Putting that to one side, those visual sims represent 100% illumination. And the visual sims and the graphics attachment obviously focuses on that very specific point, but we have to peel back a wee bit and think about it in practice. And anyone that, I get the reality is that unless you're driving along the state highway and not paying attention to the road and looking past all of the lights in the foreground on some of the vineyards that are in front of you up into the blackness of the hills, and you manage to pick out a dim glow, the question then becomes, well, how significant and important is that particular degree of adverse effect? Notwithstanding, we obviously have to recognise that this proposal is not seeking to increase any degree of domestication. It is simply translocating, as per Mr. Smith's evidence, a more visible site, which I think is clearly understood has far less restrictions than what is being proposed. So the panel have before them effectively a specific site considered sympathetic design, which encompasses a suite of conditions, which provides a relatively good understanding on what those potential effects are, which, in my opinion, would be less than those that are contemplated by the underlying consent framework and the consent notices that are at play. With that being said, I wouldn't mind just jumping ahead in my summary to paragraph 48. Just to quickly talk about the policy framework as it relates to landscape. Now, this hasn't been touched on today, but the objectives and the policies as it relate to the outstanding natural landscapes is around protection of the values associated with the landscapes. But it does not go as far as to suggest that nothing can happen in those environments. And certainly when you review chapter 2 of the district plan, it talks about outstanding natural landscapes generally. And specifically, it goes on to talk about the fact that many people in this environment in Central Otago rely on the high country and the Awanau for their well-being, cultural, social and economic well-being. It goes on to talk about the fact that the Awanau can be subject to human influence activities. That includes tracks, fencing, any other types of human-induced modification. But that doesn't automatically suggest that the values are taken away. So while it's very difficult to see a building, in this case the proposed dwelling, one person that might be able to potentially pick it up, maybe one of the residents down Smith Way who hasn't put in a submission or anything, manages to pick it out. Is that going to take away the values from the wider Dunstan range? A very significant, vast viewing landscape, which has a high degree of modification in the lower ranges. The Awanau framework, again, the key matter there is the protection of the values. Then it goes on to say from inappropriate development. Specifically, this is objective 4.3.2. So when I rely on the landscape evidence that's been presented, those attributes of the landscape, which includes the distinct and legible landform, the high degree of openness, the strong visual amenities, the scenic value, and the sense of place associated with the wider mountain range. We heard from Mr. Smith today that those values weren't being compromised. Probably relevant just to reiterate the fact that, particularly with the schedule that's been provided in the landscape material, that details the more significant or the higher number of locations that the consented platform visible from compared to that proposed, in turn would suggest that there's very few locations associated with the proposed development that would have any potential risk of compromising a very significant landscape that is important for Central Otago. I guess just to really summarise on the landscape information there, is that the panel has been given the benefit of some very compelling information to verify just how difficult it is to see. And should one be able to observe the structure inherently compromise the values of the Awanau. And relying on Mr. Smith's evidence, my opinion is defects are no more than minor. I don't intend to talk about any of the specifics of the ecological values at this point in time, but I just want to move on to matters. So the panel will be aware that the application was publicly notified. A number of those were positive or rather in support, and only 2 were in opposition. From Runanga submitted on behalf of by Ōkaha and Te Ao Marama. So on receipt of those submissions, and this is not written down by the way, I'll just give you a quick spiel. On receipt of those submissions, we invited Runanga to come up to the site and to talk to us about their intrinsic relationship to the property and just what is meant by cultural values. So I was met by representatives from both Tāmi and Ōkaha. I drove them up to the site and we basically just cordialed on site for an hour or so. We walked around, but I just let them be. And through that process,
Can I just check who were these representatives?
I can give you their specific names. So from Te Ao Marama, we had I'd have to go through and send you a list, but we had Te Ao Marama and then we had Okaha. Yeah,
And do you have any communication?
I do.
Or any,
Yeah, well, I've got the email correspondence confirming, please come up to the site. Yep.
You've got no records of what you discussed, what we discussed up there with?
There isn't a set of minutes per se, but Te Ao Marama came back basically maintaining their position. We didn't get any further response from Okaha. But I can distribute those emails. Certainly, following that meeting, so I guess through the process, I just explained some of the other key values or the other components of the proposal that are intricately linked to this application. That includes the ecological side of things as well. And certainly the offer was extended and actually remains in place for tangata whenua to be involved further through the implementation. So you had a question, Commissioner, for Mr. Ruisan just around what that might look like. And that can be in the form of many things, whether that's inviting tamariki to come up and be involved in the planting, to be involved in the restoration process, pest management. There's an opportunity there. There's some significant kōwhai trees on the property. The collection of seeds, anything like that, that allows and maintains that connection to the whenua is available. How that gets implemented into conditions would probably be quite difficult. How would one enforce those conditions? How would we monitor those conditions? But it's really just the applicant's willingness, just a general ethos of being collaborative. And that's reflected by the degree of information and the transparency throughout this entire process.
Would there be an opportunity? I see that in the conditions, there's conditions and for doc comment, for example. Would it not be quite simple to include mana whenua groups within such a condition?
Potentially, yep. So that was so that's just an overview of the process, and then following that process, I specifically invited both parties to provide any comment, particularly around the potential for mitigation should there be a decision to grant the consent, whether that means having iwi on site to ensure that specific rock outcrops are maintained. So, but the response from Te Ao Marama was simply it remains inconsistent with Te Tangi or Tauira iwi management plan or Miruhike. So we've left it at that. Time is of the essence, and here we are in the hearing. So in terms of my evidence, I want to clearly acknowledge that neither myself and to a degree perhaps the panel are best placed to determine the extent of cultural effects in terms of cultural landscape in isolation. But the panel will be aware that there is a clear statutory policy framework that will assist in the decision making of a resource consent. And we know that as iwi management plans. And as we know, iwi management plans are effectively documents that are prepared by iwi, or at least in consultation with iwi, that identify their key issues, their policies and their values of particular importance to them. And it provides us with a slightly more formalised way of at least working through a consent process. In relation to this specific application, the district plan explicitly refers to, in chapter 3 in the mana whenua chapter, explicitly referred to the Kaitahu Ki Otago resource management plan as the guiding document in terms of cultural values. I've addressed this in the assessment of effects, and I point out that the submissions themselves don't refer to it explicitly, but that doesn't mean they have to. Notwithstanding that, I have gone back through Kaitahu Ki Otago, and paragraph 29, that document is broken up into a number of different chapters, with chapter 10 relating to the Clutha Mata'o district, which relates to the subject site. And within that chapter, it's broken down into 5 sections. Okay, the first section relates to just a general description of the catchment. The second section talks about wai Māori, so water. The key issues in that particular section talks about the damming activities, significant excavation activities, primarily gravel pits and so on, discharges to water as a result of wastewater, and also dairying activities. The proposal does not offend any of those particular policies and issues raised by iwi in any significant manner. The only thing that you could potentially argue would be wastewater, but of course the site is subject to a consented baseline for residential activity, and that's being swapped out. The third section addresses wāhi tapu, and that extends across a various number of iwi management plans. And it has been accepted and acknowledged in the submissions in the Section 42A report and in my application. There are no registered or listed wāhi tapu sites or nohoanga sites. However, it's standard practice and generally well understood that that doesn't necessarily mean there's nothing there. Notwithstanding that, as originally submitted in the application, we have volunteered or offered up the provision of accidental discovery protocol. That reflects the conversation with Ōkaha and Tami on site that, look, if there's anything of relevance that need to be maintained, that will be subject to a condition, and we can even go through a further process if required. But the panel will recognise that the activity maintains a relatively consistent alignment with an existing driveway, and the development footprint which you have walked over inherently doesn't have any obvious signs of wāhi tapu specifically at a surface level. But in any event, best practice would suggest that those conditions be fine. So the third section of that iwi management plan is, in my opinion, we're not inconsistent with. The fourth section relates to mahikakai or mahingakai and biodiversity, particularly in relation to the Clusa River. This proposal, there is no evidence to suggest that there was any potential adverse effect, particularly on water bodies, which in turn would have adverse effects on mahingakai. Quite the contrary, in fact, this proposal delivers quite a significant positive outcome, as you would have seen in relation to biodiversity and ecological that Mr. Rusin speaks to. The final section talks about cultural landscape. Now, I've omitted to point out that the submissions from iwi more or less focuses just on cultural landscape. But what I'm trying to point out there is that iwi management plan, as I mentioned, and as it defined in the district plan, talks about the values and those things that are important to iwi. And I've just gone through 4 out of 5 sections of which proposal, in my assessment, wouldn't necessarily be deemed to be inconsistent with all due respect, recognising that iwi have their positions and their values to convey. So we can only say so much. But the final point really talks about cultural landscapes. And what I want to point out there is that Tahuki Otago doesn't explicitly reference the Dunstan Range. It doesn't explicitly identify the Dunstan Range of any specific values, nor is the subject site reference. It does have a number of sub-policies, and it has 2 very distinct policies, which include development up the maunga, up the side of the mountain, and then this idea of development resulting in a disassociation with cultural values with the site. So that the first point in terms of development up the side of the mountain is again, with respect, we can only rely so much on the landscape evidence that's been presented, but what's being presented is that it's a very difficult structure to ascertain, but of course it's not a new structure. It's a new structure in the sense of its direct geographical location, but it's the same catchment, it's the same viewing catchment, it's the same landscape classification unit, it's the same site, albeit with a slight relocation and platform. I couldn't quite get the information to suggest was the consented platform of any concern. I didn't get an answer to that. So there's a little bit of a, I guess, a lack of information to suggest that there was any degree of values being compromised by the consented platform. All we can say is that this proposal is not inherently increasing or adding to any degree of domestication. Beyond those 5 sections, there's nothing within the Kaitahi Ki Otago Natural Resource Management Plan that would suggest that we're inherently inconsistent. In Tami's submission, they refer to Te Tangi a Tauira. Now that iwi management plan, I did not consider in detail in the assessment of effects. And there was a reason for that. In my paragraph 39 in my submission, or my summary rather, I included what is effectively on the 3rd page of Te Tangi o Tauira, the spatial extent to which that plan encompasses. And due to a formatting error, the yellow box that I was supposed to put on has shifted. But effectively what you can clearly see there is that the eastern extent of Lake Duncton is not actually within that spatial extent of Merihiku. Notwithstanding, I've gone through that document just to understand what those key values are, and a number of paragraphs here, but I'll just sort of cut to the chase that, again, Tami's submission relates to cultural landscape concerns and concludes in their submission that the proposal is inconsistent with Te Tangi o Tauira. On the basis that Te Tangi o Tauira applies, similar to the Kaitahi Ki Otago Natural Resource Management Plan, there are a range of policies and values that are not discussed in any detail or not even referenced in the submission. That includes policies around protection of Indigenous taonga species, of which the proposal is inherently promoting. Management of pest species and vegetation, which this proposal is clearly offering. And so on and so forth. But I guess fundamentally, Te Tangi o Tauira is not just solely focused on one siloed point. It has a range of values. And so to suggest that the proposal is inconsistent with the iwi management plan, particularly based on a narrow selection of policies, would overlook the broader alignment of the proposal with the policy framework and the key, I guess, the key matters which iwi are trying to maintain or protect. That's, I guess, a planning lens on an iwi management plan that I suppose can only be so qualified to be able to comment on. But there's another key point to recognise, and that's kaitiakitanga, which we know stems from Part 2 of the RMA. And we have to take a moment to think back to the opening address from Mr. Hamlin in terms of what his vision is for the land. He purchased the land with the intent of enhancing its biodiversity and ecological values. He purchased the land with the intent of bringing his family back to the land, but also with an intent to teach his children about some of the key values in terms of ecological biodiversity values. Kaitiakitanga is all about guardianship and stewardship of the land, and if that's not kaitiakitanga, then I'm not too sure what is. Effectively, you've got someone who is promoting quite a significant ecological enhancement package, which is subject to a strict conditions package, i.e. he can't build a house until he plants everything and removes all the goats. As we've heard from Mr. Royson, isn't inherently necessary from a mitigation perspective. It's entirely permitted to do vegetation clear it's entirely permitted to do a tract. You need a restricted discretionary activity to build a house, which has been arbitrarily located down the bottom. So for those reasons, we don't have a cultural impact assessment, but the panel has the guidance of a district plan. And that district plan guides you to focus on kaitahukia target. That document has a range of policies. And much like the planning lens that we apply to the objective and policies framework of a district plan or regional plan, it will help with your decision making. Happy to take questions on that one in a moment, Commissioner. Just the final couple of points is I don't think I'm going to touch on precedent because I believe that we're largely traversed by Mr. Page, other than to recognise that precedent really, unless it's an adverse precedent, the question is, so what? This subject site has a very specific district planning framework, which is significantly different to the majority of other land parcels within the district, namely in the form of Schedule 19.6.3. Notwithstanding that, this proposal represents a range of mitigating factors, or at least positive measures, which, unless it's readily replicated by someone else, I wouldn't necessarily take the position that this proposal would inherently result in an adverse precedent of a proliferation of buildings in the ONL. It's a significant commitment to do predator-proof fencing. It's a significant commitment to do a boundary fence around 336 hectares, particularly in the gully down at Devil's Creek. It's a significant investment to buy 14,000 trees. And it's even more of a significant investment, see Joe there thinking, goodness me, to do all the reporting and the consultants' involvement with that. So I think to suggest that this proposal immediately presents a precedent is incorrect. That was pretty much all I wanted to touch on. The last thing I wanted to talk about was really just the conditions and whether the panel wanted to work through just what we have recommended in terms of a change. And I just sent a very crude, as part of my primary evidence, just a track change version of the evidence, which effectively just incorporates, I guess, the changes that have been promoted throughout the proposal, or not really changes, but enhancement. I'm just wondering whether the panel wanted to talk about my evidence first before we went through the condition, or whether I just finish off by stepping you through the condition.
Right, I'm just thinking about time.
Yes.
Past 4. Take a short break. 5 minutes, even. Just a short 5-minute break. I do have some questions about the draft conditions.
Yep.
That I would like to walk through, and then I'm also mindful about the staff who have been online all day, or almost all day. So how much longer do you think you are?
I could really just punch through them. If really just there's only a couple of copy and paste really, but yeah, the conditions, if anything, are just an enhancement of what's already been proposed. And I'll just we don't have to go into them in great detail if that's not.
I think a summary would be useful, like a succinct summary of the conditions.
I'm sure we can do.
And then we'll have some questions for you as well on your evidence.
Okay.
So yeah, we'll break for 5 minutes. What is the time? We'll come back at 4:20. Okay, we'll resume. Thank you.
Commissioner, so just moving on to the conditions, look, I'll be very brief, but ultimately these are attached to the chat change version should be attached to my evidence. Just follow along, and hopefully you've got a colour version in front of you, but ecological condition that we've promoted in the Section 43A report, we have simply opted to swap that out, the table that was agreed between ourselves and DOC, the applicant. And that includes a suite of specific management plans as well as the timing of when specific activities can occur. So moving on several pages from there, we move to the landscape conditions. The numbering actually hasn't been refined, so apologies for that. But the landscape condition, we've just added in the glazing reflectivity requirement. The nighttime lighting conditions, we have simply, again, we just opted to replace the Section 42A suggested condition, which what is largely the same, albeit expanded upon. And in reading those conditions, there's a specific requirement for the automated system to sort of come on at certain times, the lighting to dim down to 30% as required, and so on, as well as the motion activation. Moving on to the earthworks and construction control, we haven't really touched those conditions, other than to say that just in addition there to require the implementation of a landscape management plan. But we have added I'm not too sure why that's highlighted black, but we've included the construction phase or the staging condition. That's under condition 15 of this particular document. Going from there, there is a condition that talks about no cut batters shall exceed a 1-to-1 slope. Yet we heard from evidence from Mr. Latchford that if rock was identified, that could be reduced. So my recommendation would be to just remove that condition altogether on the basis that we've submitted a very specific earthworks plan, which would be referenced as the condition of consent under condition 1. Yeah, so condition 1 is generically worded to say the proposed activity shall be undertaken in accordance with the approved plan. That could be expanded upon actually to have the specific plans referenced, so there's no ambiguity. Just moving on, some of the extra changes as it relates to earthworks. There's a suite of requirements for revegetation to be undertaken within the first planting season. I've simply recommended a change that just in accordance with the EMP, the Ecological Management Plan, to make sure that all the timing is consistent. The condition around wildfire risk mitigation, we've made 2 changes or recommended 2 changes to those conditions. The first one is deleting the maximum gradient of the driveway. It says here maximum gradient not exceeding 1 in 6. The reality is that the driveway maximum gradient is about a 1 in 5. A 1 in 5. However, I have added here another condition at the end of the firefighting, which says all firefighting may be provided by any other means as approved by FENS, which is consistent with a lot of subdivision conditions whereby you would have an initial condition that might require you to have a firefighting tank or something rather, or alternative means if it was deemed appropriate by FENS. Now, the reason for that addition is I accompanied Mark Marwini from FENS up on site as in response to his submission, or FENS' submission, and the concerns that he had when he was on producing the submission were more or less alleviated by being on site in terms of, okay, I think the risk of firefighting is very minimal. We produced additional evidence from him confirming that, something as simple as a drenching system for the planting down slope of the dwelling should be enough. What that suggests is that there's an opportunity there to obviously come up with some alternative means of mitigation. rather than just restricted here to this is what it should be.
So that condition was deleted earlier up and then replicated,
The maximum gradient condition,
or the means as approved by FENS.
that was added as part of our evidence, so it would be, that was included as part of my evidence submitted.
So with the track change, there's an addition under the track change, but there's also a strike through earlier. And it's
I think that, no, that was because that was because it was elsewhere in the plan and we relocated. Yeah. And then, sorry, the last change really was we just included the accidental discovery condition, which is just more or less a copy and paste with a slight reword. Of course, these are just a work in progress, and should the panel be of a mind to consider approving the application, certainly happy to collaborate with council in terms of the specific wording. Tend to happen these days. So yeah, happy to take questions on all of those points.
I do have some questions, but it has occurred to me, rather than going through line by line, would it be potentially, we could put those down in a minute following the hearing for any questions that we might have on conditions, and that could be addressed as part of a right of reply. Would that be suitable, or would your preference be to talk through that now?
I suppose that intends on what your preference is about the end of today.
Yes.
If you don't want to close the hearing because you might want to do another site visit and deliberate on what you've heard so far, and potentially either reconvene or issue a minute or a written response, then that's fine. We're happy to accommodate that. If you wanted to get to the position where you've closed the hearing so that you can then move into the next phase of your process, then I'd prefer that we carried on and dealt with what's at the front of your mind now. If you wanted an oral closing tonight, I can do that, because we haven't heard from what the staff say yet.
That's right.
And so I don't know what may or may not come out of that. So if you have a view now that we're not going to finish the hearing today, then I think a written response to detailed questions about conditions might actually help you more in your drafting.
Yes, so my understanding, and we've discussed this, that we'll be adjourning today. We won't be closing today because there might be some follow-up questions. We might want to consider what we've heard today, and we may visit the site tomorrow. So on that basis, just in terms of efficiency, some of those more detailed technical questions that I have might be better on paper rather than kind of taking you through the mechanics of how the conditions work now.
That makes sense.
Okay.
Yes.
Thank you. So in terms of your evidence statement, I notice you haven't talked about part 2. Mr. McIntosh does address part 2 in his assessment. What is your, Mr. Page addressed that in his legal submissions. What is your view on part 2 and its relevance for our consideration?
I think it would be an expectation that Mr. McIntosh would have addressed part 2 because of his recommendation to decline. So obviously, the Section 42A report has taken the position that the proposal is inconsistent with the district plan. And as we can appreciate from earlier case law, part 2 is only part 2 is invoked where there is that inconsistency with the district plan. My assessment confirmed that the proposal, well, at least my opinion, that the proposal is not inconsistent in terms of the relevant objectives and policies. Part 2 is addressed in the assessment of effects, but certainly haven't gone as far as repeating that in the evidence.
Take me through your understanding of whether we need to assess part 2.
Yes, you would assess part 2. Well, part 2 is the overarching principle in which we're considering a resource consent. Yes.
In terms of the incompleteness or validity of the district plan. Yeah, cross purposes here. So legal submissions, Mr. Page, you addressed part 2 of the Act and the legal submission.
I say you don't need to go there. Because there's no incompleteness in the planning instruments that require you to go upstairs.
Yes, and that's what I'm interested in, your view from a planning analysis perspective.
Certainly there's no incompleteness from my perspective, no. I mean, we've got a policy framework, we've got a rule framework, which for the most part is clearly understood. And of course, our assessment has been based on and produced with the assistance of expert evidence and pretty much all facets of the environment. So I think there's certainly no doubt to the panel that they can make a conclusion around what the adverse effects are and whether it's consistent or not with the policy framework.
Thank you. I'll see if we've got any questions for you.
You, Mr. Hamlin mentioned this morning that you guys had discussed the idea of protecting the whole property, and that obviously that did not come about. Do you have any further comment in relation to that as to why?
Proposal provided, I guess, a very specific proposal in terms of what consents are required and so on and so forth. And the panel will appreciate that there are, I mean, we appreciate that the residential component requires a resource consent, and that's under very extensive scrutiny. But I think we have to be careful not to go as far as providing a whole range of restriction for hypothetical activities that are not promoted as part of this application. If there's an inference in terms of subdivision, that's subject to a further consideration anyway. But certainly through the preparation of this application, it's been specific consideration on what do you need a resource consent for, what are the potential adverse effects, and that's what's been presented.
Commissioner, can I ask, is there a concern that the applicant might come back and have another crack at the consented building platform so they've got 2? Is that what?
No, I think my concern is that given the location of the building platform, not the current one, the proposed, is that are we going to? And I know Mr. Woodward has talked about precedent, as have you, is that there is, I guess there is a bit of a concern that I have in relation to setting a precedent on domestic activity moving further and further up that type of landscape. And I did have one further, just jogged my memory. Given your experience, especially in relation to the Bendigo land, is there any other residential activity in the Bendigo land across that you're aware of at that elevation?
Not at that specific 555 elevation that I'm aware of. I think the highest one might be around just above Blue Mines Schoolhouse, above Bendigo Loop Road. There was an extensive, we call it the Schoolhouse subdivision. I didn't actually do that resource consent, but that went through quite an extensive appeal process. I believe Mr. Page knows all about it.
Both Paul and I did that one.
Yeah. But the elevation of those ones, I think I would have to go back and have another look. But there's no sort of residential dwelling specifically at that elevation. I think that's more or less been presented in Mr. Latchford's, I guess you call it bird's eye view graphics, with all of the houses plotted.
Yeah, I'm thinking even further along that, along with the vineyards and all that, just beyond that next rock.
Yeah, there was so you've got the Carnegie recreational block, which creates that demarcation. I did secure a consent for a building platform right on that boundary. That was about 2 or 3 years ago. But I'd have to recheck what the specifics are, but I probably wouldn't necessarily, it's kind of hard to sort of visualize the visual or the elevational distance above the road because they're different, slightly different contexts, but certainly when you're driving along the highway and you look over across Bendigo Loop Road, up towards Prophets Rock and the nose, you can certainly see sort of a proliferation of development right at the base of the SNA. That SNA, which the panel may or may not be aware was the subject of a 10-year review and the offering up.
That's where, it's just that, it's that pushing of the increased.
What I can signal is that Joe's not closed-minded to offering you something to resolve your concerns, but what we haven't quite got a firm grip on yet is what it is that we would be solving. So if there was a way of articulating that in a way that we can respond to and offer a solution, then we're open-minded to doing that.
I guess I think I put this to you this morning in relation to the Bendigo land in particular. The fact that it could go down to 8 hectares within that block. And if you look at the map, especially now that we've had that 5 and 6 settled, that's the predominant part of the property is all within 6.
Yes.
So the reality is if you break it down into 8 hectare lots, there could be pockets of domesticity all the way around. Admittedly, I'm not suggesting that Mr. Hamlin is definitely his intention does not appear to do that, but I'm thinking, how does that?
Yeah. Yeah, well, I mean, the problem you've identified is true of any plan rule. A zone or a rule doesn't change according to how big the site size is. And your district plan in relation to 1963 is no different to that. But anyway, I think we understand your concern now, so give us the opportunity to think about that.
I have a question for you, going back now to permitted baseline. And I guess the distinction between that, or have the relationship between the permitted baseline and the receiving environment. I note that Mr. McIntosh has addressed the existing building platform, etc., within his assessment of receiving environment. So I'm just wondering on the distinction there, what the difference is there and how you would see that differently.
I suppose as a starting point, the evidence isn't necessarily standalone. So if there's any sort of concern of any obvious omission, we have to recognise that in producing the assessment of effects, a lot of those matters have been in the actual AU as well. With that being said, obviously the permitted baseline is all those activities that are inherently permitted by the district plan. And the section 42A report in reference to the receiving environment talks about the consented building platform, but probably doesn't go as far to define the fact that a dwelling inside that particular platform is nothing more than a controlled activity consent. And as we can appreciate, the controlled activity consent is one that the panel council cannot deny. So the receiving environment is critical in this case, and my evidence repeatedly references the fact that there is a consented environment that is contemplated.
Yes.
So I guess in simple terms, the receiving environment is defined by all those activities that are subject to existing resource consents, including those that are unimplemented. But then I suppose there's sort of a broader understanding as well of what is reasonably anticipated. Whether that falls into the specifics of the receiving environment, the fact of the matter is a controlled activity consent or dwelling on any size is contemplated.
Okay, that's all our questions for you at this point.
Thank
Thank
you,
you
Commissioner.
very much. So that takes out Mr. Page, that completes your team.
That is our evidence.
Thank you. So moving now on to council staff online. You've had a long day, Mr. McIntosh.
Indeed, and I am very conscious of the time at this point. So how would you like to proceed with us? I have a roughly prepared notes that address Mr. Woodward's evidence in particular, but I'd suggest it's getting a bit late to go through that in any detail, and I'm happy to circulate those. Might be more helpful at this point, and then just simply take questions. And I'd suggest, yeah, perhaps if you have any questions for Ms. Wilson or Ms. Wright, then let's maybe address those now, and then whatever questions you have for me, I can try and answer and then circulate my notes, if that suits the panel.
That's absolutely fine. Thank you. So, well, yes, let's start with Ms. Wilson, landscape matters. Can you hear us okay?
Yes, I can hear you okay.
Thank you. So returning to the matter that we addressed at the start of today's proceedings, you would have heard some of my the panel's questions to Mr. Smith around the reference point for the landscape assessments. And so I'm interested in exploring that further with you in terms of that beginning reference point and the importance of the particulars of the landscape classification as distinct from that broader district planning ONL overlay.
So in terms of the base, do you mean in terms of the baseline from which I have assessed or done my peer review from?
Yes, thank you.
So as I sort of touched on this morning, and what I want to reiterate is that whilst I have identified in my peer review, obviously incorrectly, having now realised that there is a 2008 study that this site is located within a moderate area of sensitivity, and I accept that. However, that's not where I started my assessment from. It helped to inform my understanding of the values, and Te Tangi Te Manu directs us to do that. Sensitivity in Te Tangi Te Manu is outlined as a kind of primitive way of understanding landscape and landscape values. You more need to understand the values of the landscape and the effects on them. So to be really clear, my baseline has been on the, I guess, broadly agreed values. We touched on the Bendigo gold mining discrepancy, and yep, certainly I can see Mr. Smith's point. We're not in the Bendigo gold mining area, but that's been the overarching values were my starting point, and the fact that this has a moderate level of sensitivity now doesn't change my baseline. This is an outstanding natural landscape. These are the values. That's the critical starting point, I think. And from there, I've done my peer review, not based on solely the reliance on the fact that it was extremely sensitive in the 2007 version I have. Does that clarify that point?
Thank you. Yes, and so just so I'm clear, so this morning you were referring to a 2007, but now you're happy to accept that it's 2008?
So that's great to know from Mr. Smith that the Word document was completed in 2007, because I'm looking at that right now. But I have the mapping from 2007, which is interesting because it aligns quite closely with the outstanding natural landscape that's been drawn. But now I know there's a 2008 study, happy to accept that as the current document, as the current mapping rather.
And so in terms of the elevation, have you described that as being in the upper slope at all in your peer review?
No, I refer to it as mid slopes. The upper slopes I would think are beyond, getting into those really upper, remote, mountainous areas. I've described them as mid slopes.
Thank you. And so having, were you able to tune in and see all the simulations, the visualizations that we?
Yes, I've been here all day, yes.
Great. Thank you. Is there anything in particular that you would like to address in terms of the visualizations that were presented to us and the evaluative conclusions drawn by Mr. Smith?
I think not. So I think to answer your first question with regard to the visual simulations, I'm not disputing at all the visual simulations. They are done to best practice and they have helped me to further understand the levels of effect. On that note, I'm happy to say, having read the conditions and looked at the simulations, I'm happy to say that in my view, visual effects will be no more than low to moderate, which equates to minor. So in my peer review, I provided a spectrum, but I'm happy to say that they'll be minor. But I think this is a key, one of the key discrepancies between myself and Mr. Smith's evidence is the reliance on visibility as an indicator for landscape effects. And I think whilst visibility isn't actually the core issue here, it's clear, and I'm happy to say, I think the applicant has done a commendable job of trying to integrate this into this landscape. I don't doubt that at all. But there is still going to be an effect on the landscape values with regard to that domestication. And I think coming back to your question, the reliance on the visibility as a determinant of landscape effects is I see as a pitfall and a difference between our evidence or our opinions.
Thank you. And so in terms of the visual effects, you've adjusted your view there to low to moderate, which equates to a minor effect.
Yes.
What can you please remind me what you had concluded in your peer review?
Certainly, I said moderate to moderate.
Thank you.
Yeah.
And so in terms of the landscape effects and the your evaluation and conclusion of the domestication within that landscape, you remain of the same view in your peer review, is that correct?
Yes, yeah, it's what your the other, sorry, I don't have the name of the commissioner that was just speaking, but that concern of that creep into the ONL, domesticating an area that is currently not valued for structures modifications. It is highly remote. It does have recreational, physical, perceptual, and other associated values associated with it. And so my overarching opinion hasn't changed, no.
And in terms of your reference points, if you like, and the conclusions that you've drawn, to what extent have you considered the impact of the existing potential for built form on the existing building platform when you've undertaken your assessment?
With regard to what you can do as of right, is that what you're meaning?
Correct. Yeah.
I've considered it in terms of landscape, I guess landscape patterns and landscape character. So yes, you can build more as of right within that building platform. And the proposal is proposing less area and condensing that, I guess, area of domestication. But I think I referred to it in my peer review that it's my view that whilst yes, that domestication is, that area is smaller, it's my view, and I understand why the applicant wants to move, but I've got my landscape hat on here, is that whilst that area is smaller, the landscape character and landscape pattern, I believe, would be better aligned on the lower slopes. Where there is a clear, and it's visible in the simulations, where there is more development, there's a scrapegrass distillery compared to the mid slopes rather, where there is less structures and modifications and things like that.
And so is that, in terms of your conclusion there, Is visual effect a component of landscape character?
Visual effects help to inform landscape effects, but it's not the sole, it's not the only indicator.
So what is it about, if we're putting visual effect aside, what is it about the landscape character that you see as favourable for the existing building platform outcome?
Kind of up higher, or
the consented building platform.
Yes,
So
is more favourable.
I heard that you, if you were considering the both of those, I heard you say that it was preferable from a landscape character perspective, and I don't understand, and I'm trying to understand why you've arrived at that view from a landscape character perspective.
Because it's associated with existing dwellings, modifications, more modified land use on the lower slopes. So it's containing it to that transmission line and other areas of modification that aren't otherwise present on the upper slopes.
Thank you.
Or mid slopes, sorry, I keep saying upper slopes.
Thank you. And have you been able to consider Mr. Smith's appraisal of the relevant district plan policy?
Yes, I have looked at that.
And is there any, have you got any comment there or response to some of his critique on your appraisal or your peer review, I should say?
So this is with regard to amenity and only consideration of amenity?
Yes, and there's also some emphasis on a policy or an objective that emphasises pest management.
With regard to, I'll just find it in his evidence, apologies. So are there two parts to this question with regard to?
Yes.
The first part, yeah, sorry, I'm just breaking it down. So the first part is with regard to the pest management and the, I guess, enhancement associated with that. So whilst I agree, this is obviously a positive effect. Obviously not being an ecologist, I can still see the benefit of the planting. But it doesn't assist in mitigating wholly the domestication of moving a dwelling into those upper slopes. So that's the first part of my response to that. The second,
when you, just to interrupt you there, when you said upper slopes, what did you mean? Mid slopes.
Apologies.
Yeah.
Just find the second. Apologies, do you have the paragraph number? I recall reading it with regard to amenity.
I haven't got that right in front of me at the, oh, 1 minute.
Commissioner, I think it was 0.8.9.
0.8.9.
Yes, but it's an environmental outcome as opposed to policy.
Environmental outcome.
So that'll be at the bottom of that chapter.
Within Mr. Smith's evidence.
I believe so.
1.8.
I refer to it, I think, in paragraph 80, maybe.
Paragraph 80.
Thank you.
I just recall some comments there that I'd like to explore with you. Sorry, I haven't got it right in front of me.
Paragraph 80 talks about the additional
105.
105.
105.
Thanks for bearing with me there.
No, thank you. Apologies. Oh,
that's it. Yeah, also about the pest control program.
Ms. Wilson has placed no weight on the environmental outcomes. Yes, I mean, I agree with what he's saying. It will assist in improving environmental outcomes, and it will have positive effects on the physical, some of those physical values of the ONL, but it's not mitigating the domestication of those mid slopes. That's the tension, I think.
Thank you. Thank you for that. That's all my questions. I'll check with the panel. Okay, that's the extent of our questions for you at the moment. Is there any other comment that you wish to make, Ms. Wilson?
No, thank you. I think that's all that needed to be said. Thanks.
Thank you so much for your patience today. Okay, Ms. Wright. You hear us okay?
Yep, we're all good.
Right. Okay, so we saw you tune in to hear Mr. Rorison's evidence. And would you like to comment on anything in particular that you've heard today, or any outstanding matters you'd like to emphasise for us?
I think we're all good. I think I think we're okay. Yeah. I'll say something if something else comes up.
Okay, so when you say we're all good and we're okay, does that mean that you're in complete agreement with?
I'm happy if the doc. I'm wondering who the doc expert is that came along. I'm assuming it was John Barkler or Richard Ewens in regards to the spring annual surveys. But
It was Richard Ewens.
yeah, awesome. I'm happy. I think the main thing around vegetation clearance is just with my experience in that those habitats, the described mixed exotic herb fields does tend to have, relatively large amount of at-risk species, but I think that's actually covered.
Thank you. And so you're comfortable with where things landed with DOC and the proposed conditions of consent?
Yeah, especially if Rich is happy.
Okay. Yeah. And any comment you may have heard us discussing the planting success or otherwise for the enhancement planting. Did you have any comments to make there about the likelihood of being able to achieve those growth rates?
Well, you're always going to have a certain amount of die-off, and as long as it's monitored over time and infill planting happens. But yeah, no, I think I'm happy. Some of the species that got added to the planting list are quite fast-growing species, and when they're planted closer together, it achieves canopy closure a lot faster. So, do you have any questions?
Does that relate to the suggestion that more kānuka could be planted, for example, or?
More kānuka being planted is good. Just with growth rates, like there are some fast-growing species that have been added to the list. I think I'm happy.
You think you're happy, or you're happy?
Sorry. Yeah, I know I'm happy.
Any questions?
Watch yourself, Martin. You're out on this table.
The 14,000 plants, it's a big number to start with the die-off rate. Is that to be replaced, and that is the continuity number? That's what we're maintaining. That's what you're hoping to maintain. It's going to cost you a bit more than 14,000 plants probably, because not all of them are going to go. I'll go nowhere near your garden because I kill them all. The die-off rate would be potentially quite high there, so that's a significant investment in time, and but that's something you're happy with, yeah.
Covered in the annual reporting as well.
Yeah.
So the die-off rate and the replacement rate.
Yeah, and potentially a change of species if you are seeing that.
Yeah.
There's enough coverage there, so
If one adapts better than the other, then they'll be replaced and the die-offs will be replaced with those ones.
to that number.
Yeah.
Thanks, Ms. Wright. Thank you for tuning in today. Appreciate your flexibility with the timing.
Okay.
Thank you. So that takes us to you, Mr. McIntosh. It would be helpful if you were able to just provide a summary, if you like, of some of the key matters that you may still have concerns with, any response to what you've heard today. And yeah, that's it.
Sure. I'll try and make it fast as I can and leave the detail for my written response. But to me, I guess there's at this point in the process where there's in some respects not a lot in this, and yet there's a few important principal matters that I think are at play, and whichever way the panel land with their decision, I think it's important that some of those are addressed directly, and probably first and foremost of those is in relation to the permitted baseline. It's quite clear that there's remains a difference of opinion between the applicants and myself around that. I guess to cut to the chase, Mr. Woodward describes what the district plan permits in relation to vehicle tracks and earthworks, and in general I agree with those descriptions. However, I disagree with the conclusions that he draws from those. In particular, I think it's fanciful to compare the proposed driveway with a track that would reasonably be constructed for a permitted farming or rural activity in the upper parts. I'll come to my use of upper in a moment, sorry about that, but in the upper parts of this site anyway. In practice, this site is already serviced by low impact four-wheel drive farm tracks that are typical of extensive pastoral use. Those tracks, in my opinion, reflect a level of access that's actually required for most permitted activities on those sorts of sites. And by contrast, the proposed access involves significant formation, cut butters and engineered construction. Really, it's of a completely different scale and character, and that's driven by the requirements of it servicing a residential dwelling. A residential dwelling that needs to provide safe, comfortable, all-weather access for the residents, but also provide suitable access for firefighting appliances and such. I think, to me, a key point that's overlooked in the applicant's evidence is that the driveway is neither a standalone activity, nor is it ancillary to a permitted activity. Rather, it's integral to the residential activity that requires consent. And it's in this context that it's my opinion it would be poor resource management practice to artificially decouple this driveway from the dwelling and assess it as if it were a separate permitted rural activity. I note that the district plan itself reinforces this in a number of ways, but for example, if you consider the restricted discretionary matters under Rule 4.7.3 Roman numeral 7, the standard rural dwelling rule, those matters repeatedly require explicit consideration of the building and associated development. Now, development is a very broadly defined term within the plan, but it certainly encompasses the sort of works associated with driveway formation. And further to that, matter 2 of that rule specifically requires consideration of whether or not the siding of the building and associated development will give rise to earthworks, including access carriageways, which would adversely affect the open space, natural character and amenity values. It's my view that this indicates a clear intention within the district plan that these elements ought to be assessed as part of the overall activity. And to apply the kind of permitted baseline put forward by the applicant would, I think, seriously undermine this intention. The permitted baseline arguments put forward there's a few elements to it. So I'll try and quickly touch on. The other one was purpose. Mr. Woodward contends that applying the baseline doesn't depend on whether the purpose of the permitted activity aligns with the purpose of the development. Rather, we just need to consider whether or not the effects are comparable. What I think this overlooks is, again, that the permitted baseline is discretionary. And it's my understanding that it would be not only appropriate, but beholden upon the consent authority to inquire into the purpose when considering whether or not it would be sensible to apply a permitted baseline. Another interesting aspect that comes into it is the consent notice and the relevance of that to the permitted baseline question. I accept that conceptually these are 2 separate matters. But like I was saying, permitted baselines are a discretionary matter for the consent authority to consider. So when considering whether it's sensible or not to apply a baseline, the full planning context is relevant. And in this case, that context, importantly, I would suggest includes the consent notice, which clearly constrains development to a defined location, as well as limiting disturbance beyond that. Has the panel got any questions they'd like to direct to me at this point before I carry on?
Yes, thank you. In terms of a consent notice, we've heard today from legal counsel and other experts around the purpose of that consent notice, and that the origin, of that did not relate to landscape concerns.
Indeed.
And have you given some thought about your appraisal and whether you have properly assessed the purpose and original origin of that consent notice?
I have put my mind to it, and unfortunately, this is a theme that I think arises all too often in CODC anyway, where the report for the underlying subdivision unfortunately hasn't gone into the level of detail that we'd probably all like to see today to answer some of those questions. In my opinion, while I appreciate what Mr. Larson has said was his intentions around the consent notice, I think that's somewhat beside the point at this stage. What may or may not have been the developer's intentions for them at that point in time, I think is less important than the fact that that was the context in which consent was granted. And I can only assume that, the the proposal before council at that time, which included the platforms in those positions, satisfied council in terms of effects as well as the suitability of those lots. And yeah, it would be, in hindsight, it would have been good for the report to have gone into greater detail there, but in my experience, I think, in my experience, council would have been cognizant at the time that those platforms provided some degree of certainty with respect to those effects.
Thank you. And so when you say that the underlying reports, that you don't expect those underlying reports to detail such details, is that because you have yourself gone to look through council records and have determined that those records don't exist? Or is that because you're making the assumption that the purpose is not recorded anywhere?
I have gone back and looked at the council report for that underlying subdivision, and it is very light on detail around that. It's light on detail around directly addressing the purpose of the consent notice. I would infer from it that, infer from the effects assessment in that report that quite clearly that assessment took into consideration the location of those platforms at the time.
Thank you. In terms of the access way and the permitted baseline, so I understand what you're saying about your view on whether the permitted baseline should be applied. But in terms of the example provided and the cut batters of approximately 8 metres and the data and inputs that we've seen today, on the merits of that access way, are you concerned that are you still concerned about the visual and landscape impact? What I'm saying is the permitted baseline determinative or fatal in your view to this application, or have you been able to consider the evidence that we've seen today by the simulations and the visualizations, I should say? Did that give you any comfort, being able to look through those and see the extent to which the access way may or may not be visible in certain components and the actual extent of those earthworks?
Look, it certainly gives me some comfort, and credit where credit's due. I applaud the applicant for the quality of information that they've presented throughout this process. I still have some concerns, more so around the appropriateness of the effects than the level of direct effect. And Ms. Wilson, your line of questioning, I think, to Ms. Wilson touched upon this a bit before. I also think, you know, a new aspect that was presented coming into this hearing by the applicant was this notion of an alternative access track, quote unquote permitted access track. For the same reasons I've already outlined around the permitted baseline, I don't accept at a fundamental level that there is such thing as a permitted access track that would serves the purpose of providing access to for a residential activity. But certainly I wouldn't, if the experts, and it's clear that from the evidence presented that alternative track while it may it may fit within some of those permitted activity standards, would actually be a worse outcome, then certainly I wouldn't be encouraging that track be adopted purely because it conformed better with the district plan standards. Yeah. Does that answer your question, Commissioner? Or have I?
Yeah, I think so. Could you just repeat that last bit about the alternative track? What I didn't quite catch what.
I simply because the alternative better conforms with district planning standards. If it's the evidence of the experts that that's going to be a worse visual outcome, then I certainly wouldn't promote that track be adopted over the applicant's preferred track, if indeed the panel are of a mind to grant consent.
Thank you. And in terms of your understanding of the landscape classification unit, I do note that you have used the term upper slopes consistently throughout your report. And I did clarify with Ms. Wilson that she hadn't used the term upper slopes. So I'm wondering how the term upper slopes, kind of the vernacular of that, became quite a key feature of your appraisal.
Yeah, I think when I drafted that, I didn't realize that terminology was going to be so contentious. My use of the term is just simply in relation to, the proposed site relative to the consented platform. I've gone back through my report, and some places where I've used that terminology, it's clear that, it's clear to me that what I was referring to is that it is upper slope in comparison to that consented platform. In another part of my report, I think what I was trying to convey is that from some of those views from that Lake Dunstan catchment, the slopes that you can see, it is in the upper portion of. I accept that the Dunstan ranges then continue to rise significantly as you move further east beyond that, but that's not what you see from most of those locations. Most of those locations, what you see is really just to the top of this site and that ridge line there. And so from those views, it is the upper part of those slopes.
Thank you. And another question from me is regarding your appraisal and the extent to which you may have or may not have accounted for the benefits of not using the existing platform. And in particular there, I'm thinking about some of the positive effects that the applicant has put forward around relinquishing the use of that existing building platform, and there's some of the ecological benefit, for example. Have you accounted for that in your evaluation?
In terms of ecological benefit, I've already, I think it's clear in my report that overall, I think this proposal has positive ecological benefits. That conclusion's based on the expert evidence that I've read through, which I understand included that analysis of the permitted of the existing platform. I don't know how. my understanding of the ecological evidence is even taking that aside, this would still have an overall long-term positive ecological benefit. So I don't know how determinative that is. In terms of landscape effects, I think there is a risk in some of the applicants' evidence of being too focused on visibility, and they've gone to some length to make comparisons between the relative visibility between that consented platform and the proposed building site. And I think what that risks overlooking is the context of those two potential building areas. And again, not to stray too much into Ms. Wilson's area, she's already addressed some of this under questioning, but even from a non-landscape architect's perspective, it's quite obvious visiting that site that there's a certain, that the existing platform is, albeit very much at the upper end of a band that's visually distinct from the slopes above that. It's visually distinct because it has a whopping great big transmission line through it that delineates it very clearly, and because at that same elevation there's clearly more human influence, vineyards, a greater degree of clearing, a greater degree of track building, and indeed buildings. Above the level of that consented platform in that catchment, there are no buildings to be seen. And I think that context is important, and potentially, risks getting a little bit overlooked if we're simply comparing how visible the lower platform is compared to the proposed building.
So some of those reasons that you've talked about in terms of landscape effect seem to be visual effect. So there are no buildings to be seen, for example. So I just want to be clear from a planning perspective, what is it? What is the key concern from the existing platform and the proposed location?
That the landscape context is fundamentally different between those two locations. You have a far more modified landscape context at the elevation of the consented platform, and a far less modified, more natural landscape context above that.
Okay. Okay. I'll just check if there are any questions for you.
Yeah, I had one, Jake, and it's just given everything that you've heard today, in relation to, and this is in relation to the cancelling of the consent notice. Have you got any change of opinion in relation to the change or amendment of a consent notice, given what the applicant has presented today?
I'm sorry, was that a question for me or for Jake?
Oh, sorry, my apologies. I think I did say Jake, didn't I? My apologies, Ollie.
Okay, sorry.
My
So,
apologies.
can you repeat that again? What was the question?
Yeah. Sorry, it was given everything that you've heard today,
Yes.
and what has been presented by the applicant, have you got any, do you have any changes in relation to your opinion on cancelling that consent notice? Or your position remains the same?
No, my position remains the same in terms of cancellation of that consent notice.
And I have one more. Just a minute. There has been quite a bit of discussion about the reference to the cut and batter and when the earthworks are potential, if we're reminded to accept this, the earthworks, if they find rock, that's going to prevent that. Do you have anything further to say on what would be required, or would you prefer a change of location? What's your thoughts there?
It's somewhat, I think, outside my field of expertise, but I think it is a little bit of an elephant in the room. If, on the one hand, if they encounter rock, then I accept that means cut batters can be significantly reduced in height and depth. The problem then is that you can't plant those, essentially sheer cuts. So how much that then changes the landscape effects and the sort of visual modelling that's been done is something that I don't think has been directly addressed. Yeah. Does that answer your question?
Yes.
Thank you. In relation to section 1041C and the precedent, potential precedent, in your section 42A, you talk about approval of residential development in this upper slope, which we've already talked about. Location may weaken the practical effectiveness of the plan's outstanding natural landscape provisions. Although any future proposal would require its own independent assessment, approving built form and high altitude locations may make it more difficult to resist similar proposals in comparable locations within the same landscape unit. And we had some legal submissions today and also discussion of some witnesses around the precedent effect, or whether there would be a precedent set. Have you heard anything today that might alter your view in relation to that?
Yeah, to be fair, I think having gone through Mr. Page's submissions, I would tone that down. In particular, I accept the position that he's put forward that the site subject to that schedule, not just this site, but all the land that stemmed from Bendigo Station is subject to that schedule. So I think that's a pretty clear distinguishing factor. My caveat there, however, is that Bendigo Station was a very large parcel of land that includes a lot of land that would fit into this kind of landscape character. So I've not done an evaluation as to how many other sites were once Bendigo Station and have comparable characteristics to this site, but it would be my guess that there is quite a bit of land that falls into that, and so there would still be a precedent concern with respect to those sites.
Thank you. Any more questions? Well, thank you, Mr. McIntosh. Appreciate you talking us through your position. And you said that you had some written notes.
Yes.
Are you able to provide those to us?
Yes, yep, they're sort of half typed and half scribbled. So I'm taking off on holiday tomorrow, so I'll finish typing those up this evening, and so I'll send that to the hearing admin so that they can circulate it. I assume you want that to go out to all parties.
Yes, thank you. Yes. Thank you and appreciate your time today, Ollie. I know it must be difficult from another time, slightly different time zone.
Oh, that's right. I'm well and truly used to that by now.
Well, thank you for your time today and thank you as well, Ms Wilson, and I think the other staff member who left, Ms Wright.
Yes.
Thank you very much.
You're welcome. Thank you,
Very
everyone.
helpful. Thank you. Okay, well, it is 5:34 and I think we're probably all feeling a bit tired by this point. But we did get through everything that we had on our agenda. So thank you, everybody, for your participation today. That's much appreciated. In terms of where to from here, we'd like to adjourn the hearing. And we'll consider if we will go back to the site tomorrow. Well, and then we may put out a minute with some. Well, we've got some questions around the proposed conditions of consent that I'd like to document, and there may be other bits and pieces that we want to record as well, or any further comment from your team, and then that process would then lead into your right of reply. Have you got any time frames or any kind of procedural or process matters you'd like us to take into account?
No, not really.
No.
My next hearing is back in front of this panel again on the 28th.
Oh, the filter movement.
Oh, you're welcome.
No, road metals.
Sorry, road metals. Yeah, I knew it was a
The other
quarry.
ones.
A quarry. I knew it was a quarry. Yeah.
So aside from some fast track I need to deal with in the meantime, I can accommodate what your time frames are. So
Well, we'd likely get a minute out. What's today? Tuesday. We'd likely get a minute out by Thursday, Friday. And then that would set up perhaps some dates.
Yep.
That then you could respond to. And that would set up the process for
sure.
voting on the hearing as well.
Yep.
Okay.
Yes, no, that's fine. I've made copious notes, so it won't take me long to prepare a closing, but providing you with some detailed feedback on questions around conditions, I think requires some attention. So I mean, if you gave us a week from the receipt of your minute, how are you placed, Jake? Because some of the condition drafting will fall to you. Yeah. So if you give us 5 working days from the day that you issue your minute, that for filing and closing, that should be sufficient.
So your closing reply will include comment on any questions we have in our minute on conditions.
If that's the way that you would want to receive it, I'm happy to. If you want to receive that separately and prior, then that's fine too. But that seems to be doing it one step with.
Yes. Agreed. Okay, thank you very much. Appreciate everyone's time and input and very helpful assistance to the panel. So thank you.
So can we think about the site visit tomorrow potentially, because there's some logistics required about that. You were driven up last time.
Yes.
I think it's Joe's preference that someone does that from a health and safety risk management point of view.
Yes. Wondering, but would we just be going around once again? Less so on the site.
Yeah.
Yeah. So if we do a site visit tomorrow morning, it will be to kind of look again at the visualizations and the viewpoints.
Okay. I see, right. But I mean, you are welcome to go back to the site, but we just need to do some arranging at our end to facilitate that.
Thank you.
I appreciate that some of you are probably used to driving in the mountains, but
yes. No, look, I think we're comfortable that we saw everything we needed to see yesterday.
Okay.
In relation to the site and the access, and that was all very clear and helpful today. But we would, now that we've had the opportunity to see those visualizations, it would be helpful for us to go back to some of those sites just to double check our understanding from yesterday.
That's understood. Thank you.
Great. Okay, well, thank you, and travel safely for anyone traveling.
Thank you.